Need about a minute and a half. Just give me a second, audience and everybody.
Is this for one of us or?
No, it's, I think the clerk uses it or. Yeah.
Is that turning on?
Do you see it? Okay.
There you go. Yeah, no worries.
Good.
She has hers.
Sorry. Good morning, everyone. Welcome to the zoning adjustment for November 14, 2023. Before we start the official part of the meeting, I'd like to thank all city staff who have been worked tirelessly to present cases for us today. They work really hard to present your cases so that we as a board are informed. Also, I'd like to welcome Miss Maisha Wright, excuse me, Maisha Wright. She's new to our board today. And I'd like to thank our current board members, Tom, Maggie, and Randy, for their tireless service in hearing these cases today. That it's a volunteer position and we do our best to look at the facts and make a decision on those facts. Lastly, Mr. Stiller has resigned from our board. He was here for about 5 years, and I wish Tom all the best. With that in mind, Anna, would you like to explain the rules and procedures for today's meeting?
Yeah, thanks. So I'm going to describe the procedures for this hybrid meeting. For those online, we have two main categories of people participating in the meeting: attendees and panelists. So right now, the only panelists are any commission members or city staff participating virtually. And if you are an applicant or a citizen online who wishes to participate in a case, you can use the raise hand function when the chair calls your case. This will let staff know to promote you as a panelist. There is a ribbon at the bottom of your screen with a little hand icon, and you're going to click this, raise your hand. When that promotion occurs, you will need to accept the promotion, and it'll appear very, very, very temporarily that you've been disconnected. But, please don't freak out. This is just you reconnecting as a panelist. When you're a panelist, then you can turn on your microphone and turn on your video camera so we can swear you in. If you're joining us via the app on a computer or on a phone, please change your name, your screen name, to your legal name. This will help with the promotion process. And if you're calling in via the phone, you're going to hit star by the number 9, and this will work the same way to raise your hand to indicate to city staff that you would like to provide testimony. For those in person, when it is appropriate for you to give testimony, please approach the microphone in the podium in the center of the room. If you are in person, there's no need for you to also be in the Zoom meeting. This can create some negative feedbacks with all of the microphones, and we want to minimize audio disruptions. In regards to all testimony, both in person and virtual, the following rules apply. The BZA secretary or their designated representative will identify you when it is time to speak. Then you're going to be sworn in under oath, and applicants will receive 15 minutes for their presentation. And then 2 minutes will be provided for any member of the general public who represents a single interest like yourself, or 5 minutes for an established organization, think a neighborhood association, HOA, nonprofit, etc. You're going to hear an alarm when your allotted time is over. So please be respectful and wrap up your statement once you hear that alarm. No repetitive or irrelevant testimony. And if you wish to admit any exhibits, for example, a PowerPoint presentation, photos, maps, please have that ready on a jump drive or ready to share on your screen. Once your case has been heard, we also ask that you email the assigned planner those exhibits that were admitted for record keeping purposes. And as a reminder, the chat box online is only used for logistics about the meeting, audio problems, logistics about the agenda. Merits of the case cannot be discussed in the chat box. And the Board of Zoning Adjustment will take periodic breaks. For example, around 10:30, 12:30 for lunch, and 3 o'clock if the meeting lasts till 4. That concludes my overview of the hybrid meeting. Thank you, Mr. Chair.
Thank you, Ms. Anna. Before we start to review cases, I'd like to swear in all city staff members who are presenting or testifying today. If you are online, please turn on your camera and microphone. And are we ready, Anna? Please raise your right hands. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
Anna Nanaski, I do. Joe.
Joe Rexwinkle, I do.
Stephanie.
Stephanie Saldari, I do.
Connor.
Connor Tomlin, I do.
Kim.
James Duddy, I do.
Diane.
Diane
Binkley?
Binkley, I do.
Andy.
Andrew Clark, I do.
Larissa.
Larissa Chambi, I do.
Justin.
Justin Smith, I do.
Everyone. Anna, I'd like to turn this over to you to identify the continuances and or dismissals today.
The continuances and dismissals addressed at this time include docket item number 2. This is case CD BZA 2023-00084 for 4821 Roanoke Parkway. This is a short-term rental related appeal, and the applicant has requested a continuance to December 12th. We also have docket item 6. This is case CD BZA 2023-00112 for 1106 West Road. The applicant has requested a dismissal, and that's because a revised notice has been sent, so there's no longer a reason to appeal that particular notice.
Excuse me, what case was that in? Sorry,
6.
what docket? Number 6? Thank
Docket item number 6. Docket item number 7. This is case CD BZA 2023-00108 for 3441 Main Street. The applicant has requested a dismissal as a revised notice on this matter has been sent out, so there's no longer a reason to appeal the old notice. Docket item number 8. This is case CD BZA 2023-00109 for 340 West 72nd Street. Same situation. This is a case for dismissal as a revised notice has been sent. So there's no longer a need to appeal the old notice. Docket item number 9, case CD BZA 2023-00106 for 1321 Westport Road. Again, a request for dismissal because a revised notice has been mailed. There's no longer a need to appeal the old notice. We have docket item 28. This is case CD SUP 2023-00017 for 9520 Marion Park. This is a special use permit where the rezoning associated with this case was not approved. So the special use permit can no longer be approved as well. So we're requesting dismissal on that. City staff is. We have case 37. We have docket item 37, excuse me, case CD BZA 2023-00137 property at 208 Westport Road. This is a appeal case related to zoning violations. The applicant requests a continuance to February 13th of 2024. And this is so the applicant can pursue a certificate of legal non-conforming use. Followed by docket 40. This is case number CD BZA 2023-00133 for 1321 Westport Road. This is a continuance request to January 9th, 2024, in order for the applicant to pursue a deadline addressed in the notice of violation that was sent. As well as docket item 41, which is case CD BZA 2023-00142 for 131 East 39th Street. This is a request from the applicant to continue to January 9th, 2024. Again, to pursue a deadline addressed in the notice of violation that was sent. And that concludes the continuances and dismissals that will be addressed at this time.
I have one question. So I noticed docket item number 10 also said dismiss. Will we be hearing that one today, actually?
We think we need to discuss that
Okay,
dismissal more in depth, so
Perfect,
we'll
thank you.
talk about it later.
Thank you. Is there any public testimony for the continuances and or dismissals city staff just identified? Anna? Sorry.
I don't have the meeting.
See
open
anything
yet.
in the audience, in the virtual audience?
1 second,
Thank you.
guys.
There isn't anyone.
Okay, thank you. Board members, do you have any discussion on the continuance and or dismissals? And if not, could I have a motion?
Hello, sir.
Oh, sorry.
I was just told I was supposed to let you know I was here for my case.
Can you speak into the microphone, sir?
Yes.
It's the other lady.
Okay, I was supposed to let somebody,
What case are you on here, sir?
it's the place up on White Avenue. about
Okay,
a job
that'll be
trailer.
heard later in the day. I don't see when that one is on it. Sorry, he said Wayne Avenue.
What's the property address?
3105.
5510 Northeast 30.
There it is. 5503 White Avenue.
Are you Harley?
Yes, sir.
Okay, that's docket 10.
So we won't hear your case
Yes.
is it yet. So you gotta have a seat in the audience, sir,
No,
and
not
then we'll
just-
call you. Yeah, that's fine. I just
Thank
don't
you.
know where you are on the docket. So board members, I'm still waiting for a motion on the continuances and or dismissals.
I move that continue case numbers or docket item numbers 2, 37, 40, and 41. And that we dismiss, you want to do them both together, and that we
Do all
dismiss,
as blanket,
and that
please.
we dismiss cases 6, 7, 8, 9, and 28.
Great. Those are the ones identified by Miss Anna a few moments ago. I have a motion. Do I have a second? Second from Mr. Gorens. Anna, please call the roll.
Gorence,
Aye.
Ann, Mixdorf,
Aye.
Wright,
Aye.
Aye, sorry. Okay,
and there's also a request to reorder the agenda for docket item number 29 to be now docket item 14.
I don't have a problem with that. They've been moved around quite a bit, so that's okay.
I actually have a second request there, just a housekeeping matter. Docket number 38.1 and 2 is the exact same legal arguments as docket number 1.1 and 1.2. So if we could include those two cases, which are two condominiums in the same building, that would be more efficient for the BZA's time today.
And did you say those are items number 30 and 31?
38.1 and 38.2. And Alex Glenn.
Docket item 38.1 and 38.2 are late file appeals. So the discussion that should be had at this hearing today involves whether or not the Board of Zoning Adjustment should hear the cases at another date, despite the rules identified in 88-57503B.
Silence the phone, please, or I'll take it out of your hands and throw it outside.
So it sounds like the merits of those are different, which is why we're not hearing them together.
Oh, the 1.1 and 1.2 is still a right to be heard case. Those are two right to be heard cases is what I'm calling them.
We're doing docket number 1, all those cases in just a moment. The 38.1 and 38.2, excuse me, if those are the right ones, we will hear those later. Thank you, Mr.
Yes, Chairman.
Thank you. All right. Anna, please call the first case.
Yep. So item is docket item number 1. This is related to an appeal for several STR related excuse me, let me rephrase. Docket item number 1 is several STR appeals for 7825 North Platte Purchase, 32 East 32nd Street, 1704 Jefferson Street, 4037 Forest Avenue, 2 Jansen's Place, 136 Kensington Avenue, 5026 North Topping Avenue, 5028 North Topping Avenue, 34 East 32nd Street, 4817 North Fremont Avenue, 3938 Forest Avenue, 720 Main Street, Unit 203, and 601 Northeast Woodland Avenue. Before we give like a little overview on these cases, would you like me to address the dismissals involved with docket item number 1?
Yes, I would. And again, we're going to talk about time limits on these, on this docket number.
That is correct. Since this of cases have been heard in a public hearing format a couple of times. The Board of Zoning Adjustment has the liberty to reduce the amount of testimony presented for each case. So it is suggested that there are 3 minutes for the applicant and 2 for all remaining public testimony. First case requested for dismissal is 1.2. This is case CD BZA 2023-00113 for 32 East 32nd Street. This is a request to appeal the absence of an address in the Kansas City, Missouri parcel viewer for a duplex on about 0.2 acres, generally located at 32 East 32nd Street. The reason why city staff have requested dismissal is because the issue at hand being appealed has been resolved. There is an address in parcel viewer for this duplex at this time.
All right, Ms. Duma, we've heard a lot of testimony already. I've had a chance to read your legal brief, around 60 pages, 55 pages, as I recall. And tell us why we should approve this appeal.
So I believe it's couched as why this should not be dismissed. If I'm
Sorry. You're
yes.
right.
So this should not be dismissed because the issue is not whether or not there's an address in parcel viewer. The issue is whether or not Ms. Wright has the documentation submitted in the application in order to have her short-term rental processed under the 2018 short-term rental ordinance. This has they had a duty to get the address into the system, the parcel viewer system. And that's the only thing that stopped her from getting all of her paperwork and getting her permit before the law changed on May 4th. So you should not dismiss it. And just as an overall, I do also object to the 3 minutes timeline. I understand you guys have heard a lot of testimony, but I have a record to protect if I have to appeal. So I do object to that and would request the normal time limit of 15 minutes per applicant.
That request is denied. You have 3 minutes, and of course, you're always welcome to appeal. Again, Ms. Duma, you were here a couple of times, and we've heard testimony on these cases. This is not new testimony to us. Thank you. Ms. Anna, so are we doing 1.1 or 1.2?
Well, since there are merits of the case, like the overview that apply to all of the docket numbers
Right.
that should be heard, I think we should handle whether or not you want the dismissals to happen or not. And then we can proceed forward with the merits of the case is for the remaining
I
addresses.
think we should hear the merits to not dismiss 1.1 I know about 1.2 and 1.9. Those are different cases really than some of these others, Ms. Numa.
Yes.
So let's take one at a time. Let's start with 1.1 and the timer is starting. Thank you.
The reason the city is asking for a dismissal is because the appeal was not timely filed. And the reason the appeal was not timely filed is because the applicant was not aware of his rights to appeal. In front of you.
Ms. Duma, I think we were going to hear this case. We're starting at 1.1, as I thought what you
Yeah,
were trying to.
Which is Tobin
say.
Kennedy.
Which is the one on North Platte Avenue, North Platte Purchase.
Okay, so
Which would have a presentation from, do we have a presentation from city staff for that one, or since we've seen the presentations in the past?
and I'm sorry, I thought we were talking about his right to a,
I think
Yeah,
he
not
said we
yet.
wanted to hear you on that one, so we got you.
okay.
These cases were continued from the September Board of Zoning Adjustment meeting because the Board of Zoning Adjustment requested that the applicant provide some very key points, key facts, and timelines for each of the cases. So unless directed to provide my entire PowerPoint presentation again, I'm just going to go over a little overview based on the discussions that the Board of Zoning Adjustment had in September. So as a reminder that per the Zoning and Development Code, case 80 or code 88-575-09, an appeal must be sustained only if the Board of Zoning Adjustment finds that the city staff have erred. And in our opinion, the item that is being claimed to be erred is that we closed cases that did not apply to the Zoning and Development Code. The Board of Zoning Adjustment does not make legislative decisions, the City Council does. So appeals or issues brought up about council's decisions must be processed through other means. On May 4th of 2023, the City Council approved ordinances 230, 268, and 230, 267, and these were repealed STR rules and regulations from the Zoning and Development Code to the Property Maintenance Code, which is Chapter 88 and Chapter 56 that we use casually. The status of all pending applications that includes STR permits and STR zoning reviews were changed to denied as the portion of the code that would have approved them, that would have dictated their approval, was repealed. And the status was changed to denied. However, we were actually closing the cases because the rules were repealed. Compass KC does not have a status change to accurately reflect what happened with the City Council. So the plan status denied was chosen. And per our direction, 88-505-05E, which is in the Zoning Development Code, states that city staff, we have the power to review applications that are deemed complete. And they will be considered in the processing cycle and reviewed by all the appropriate city staff in accordance with the applicable zoning review and approval procedures identified in the Kansas City, Missouri Zoning and Development Code. So city staff, we don't believe we erred because all pending applications didn't have the review criteria in Chapter 88 at the time to approve them. That concludes my overview. And then when we get through each address, if you want me to go over the timeline for each associated address, I'll be free to do that.
So starting with 1.1, do you want to talk about that timeline quickly? Thank you.
Okay, so 7825 North Platte Purchase Drive. This was a request for type 2 year-round STR. Was applied for on May 2nd. That says 2018 and it shouldn't, it's 2023. My apologies for the typo. So this application does not meet the review criteria when we looked over all of the appellant's applications. And then on May 5th is when the ordinance went into effect. So per the zoning and development code, we do have an allotted amount of time to make sure that an application is complete. We refer to it as QCR, quality control review, and that deadline would have been the 10th. So as you can see, there's overlapping nature between when they applied and when the ordinance went into effect. And as previously mentioned, the cases were changed to denied on the 31st of May. And this is a copy of the messaging that went out to the applicants when their cases were changed to denied. Again, when we closed the cases, informs them why the cases were closed, but it does not include information about the right. Again, the error identified in the application, appealing the denial of that particular STR. We closed all of the cases, changed the status to denied because the provisions in 88 for short-term rentals were repealed. Again, the messaging communicating the denial did include why the change occurred or why the cases were denied, but it did not include the appeal statement from 88575. None of our IOs, intelligent objects from Compass KC include this messaging. So it's easily overlooked by an IT person, and the board may sustain an appeal only if it finds that city staff have erred. That concludes my presentation on 7825 North Platte purchase.
And just a clarification on that first chart you showed us, the application was initiated on May 2nd?
Correct, of 2023. I have a typo on my screen.
Good, thank you. All right, Ms. Duma.
I would request to reserve 30 seconds from each individual applicant to give you just an overview as to why they should have processed these
Of
applications.
course,
May I
of
please
course,
do that?
of
Thank you.
course.
What's that? The video. Sorry, this is my intern, Miss Samaya Allen Hathaway. She's 16 years old. She wants to be a real estate lawyer, and she's part of a People of All Colors Succeed. So she's been working with me and she's helping me with the slideshow
Perfect.
today. So
Thank
just
you.
want to introduce her.
Anna, should I swear her in?
Yeah.
Okay, I'm going to swear both of you guys in.
Of course.
I do solemnly swear or affirm to tell the truth, and nothing but the truth in this hearing today. And please identify yourselves to each person.
I do.
Thank you. Of course.
Samaya Al Hathaway.
Thank you.
Okay, let's just launch this.
And for clarification, we need to reestablish the quorum on this one to include Ms. Wright, and exhibits 1 through 16 apply to this case.
You've reviewed the case.
Yes.
Thank you.
Okay, I've got 2 videos I need to show you guys because what the city council expected is really important. So I've got to, I don't have control to X out of this. There we go. Thank you. And then if we go to.
The thing to your mouse, my apologies.
It's okay.
Only 2 USB,
Yeah, so, oh, no worries.
so I have to unplug mine now. I'm gonna plug mine in at my computer and share my screen from there since her jump drive and her mouse are being
Okay.
controlled with this.
Okay. And Okay. How do we get volume here?
That slide is more detailed version of what I submitted.
It's, the volume's not working for some reason.
Exhibit, no.
Well,
Okay.
We're gonna call that Exhibit 17, Ms. Duma, and that will be admitted.
yes, thank you, Chairman.
No, I don't know what's going on.
Joe, it looks like the volume has just got the X on it from here.
Oh, okay, there we are.
Yeah.
Before you start it. So what we have here is when we were actually discussing, and that's council member Bunch, okay? Because we're really concerned about what did the council people intend when they passed this law? What was their intentions for these people that were in the process, in the hopper? Okay, so if we play that video, here's exactly what the person who sponsored this ordinance says about the people in the hopper, and Mr. Rexwinkle sitting right next to him.
Still can't hear it, kids.
Too low. Can you turn the computer volume up a little bit higher, Joe? The bottom
It's
right.
up all the way.
It's, oh, no, the computer volume, not the other device volume in the bottom right hand corner.
Yeah, this one is.
Oh, yeah.
Okay, so I guess just to move us forward, what he says here is that I would presume out of the 170 applications that are in the hopper, these will be processed under the old law. Nobody corrects him. That's what was presumed. And you'll hear other testimony. That's what other council members presumed of my clients who reached out to council members. That is what it's also in everyone's brief, and everybody's brief will be entered in their individual cases. Secondly, at the very first hearing, if you all recall, Mr. Rexwinkle talked about administrative applications generally, and he said, these are administrative. We continue with the process until they can be approved if they can. And so what the council members intended was to stop getting new applications. But for the ones that were in the hopper, the ones that had already done what's required of them, or at least very easily could, because Joe said that we go back and we make sure if there's something that's easy to fix, we let them fix it. Well, everybody in front of you today either submitted everything appropriately before May 5th, or they very easily fixed any errors. And so they come to you today with a full package. The law with respect to whether or not you could process these applications are that the applicant substantially converted the property to the use, okay? And when they did that, when they substantially converted it to the use, they had a reasonable reliance that the law would remain the same. And so in this case, it's not when they applied for a permit. When you apply for a permit has nothing to do with it. We need to look at those two factors. And as we go through each case, that's the evidence that I will be getting from each individual client. And I do have a timeline for you guys for everybody exactly how you asked. With that, we'll move on to 1.1. Okay.
Perfect.
So Mr. Tobin Kennedy. Mr. Kennedy, can you come on up?
And swearing him in when he comes up. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today? Please identify, step to a microphone. And please identify yourself for the court reporter.
My name is Tobin Kennedy. I want to thank you guys for having me today.
Thank you.
For him and just pull up his timeline.
Start the timer. You have a quick 2 minutes to tell us why we should approve your case.
Right
I
this
think
moment.
is
Hold on.
Ms. Duma
I'm
giving
trying
her
to pull up
presentation?
The summary.
Okay?
I'm sorry, the technology is Hard not having your own computer.
She's gonna do her portion, so we still giving her time, a few minutes, and then he was getting 2 minutes for his.
I just need to remind everyone, we're getting messages from the court reporter. You have to speak into the microphone, please.
Okay. Start me up. This is the summary that, as you guys asked for Mr. Tobin Kennedy. Now, Mr. Kennedy, can you tell us when you purchased your house?
I bought it in 2017.
And did you do any renovations to it?
We did.
How'd those go?
Did a lot.
Yeah,
lot of
how
money
much did
into
you
it.
spend?
Tough to say. 25,000, probably 80.
When you purchased the home, was it intended to be a short-term rental?
No,
Did that change?
it did change.
Can you explain?
It changed in 2022, it changed. As Joe knows, I planned on building my house on 7 acres that we had. City council, some reason I wasn't able to get 2 homes on the lot. We ended up selling it and decided to put our house next to this short-term rental that we were going to make a short-term rental for all of my family are out of state, my wife's family. A lot of her family, most of her family here, but some are out of state. We wanted to make it so we could house our family when they came in town. Wanted to make it convenient, fluid for them. And that was the reason that we started building our house right next door to the short-term rental in 2022.
So how much have you spent on building your house in reliance that you'd be able to use the other properties as short-term rental?
750 grand.
Okay, so Mike, can you go to the next slide, please? We can just show the next.
I guess I'm wondering, is this being shared? I think normally the screen is shared for Zoom. It's on both screens.
Oh.
Is that accurate?
I'm sorry, you guys aren't seeing what I'm seeing.
We're seeing yours.
You
I just
are?
want to make sure everyone online is also.
So it's a really unique piece of property. So it's actually 4 acres altogether. So the short-term rental is on, the new construction is obviously the new one there. And then the older disappeared one is the short-term rental that we
So I want to just talk about your application quickly.
Yep.
I have submitted a legal brief that's very similar for every plaintiff. Can I just move that in as exhibit, I guess, 1.1-1 for Mr. Kennedy with the
Sure.
exhibits?
That is admitted,
And for clarification, it is already a part of the
It's all part of
exhibits.
the presentation.
No, this is a separate legal brief and arguments that it's similar to the legal brief that you read, the 50-page one.
Yes.
So this is a new document you have not emailed to me yet.
No, I have emailed.
Yep, so that I already attached it to the case.
So it's part of the case, Ms. Honor, or not?
It is.
Okay.
So that automatically makes it exhibit and I don't have to do anything else?
No.
Okay. Okay, so tell me about the application process, please.
application process. So like I applied May 2nd, 2023, had all my documents. I actually came in and spoke to Stephanie Saldari, brought in all my documents to make sure I had everything correct. Said it looked good, couldn't guarantee anything because it's got to go through the system. And then, yeah, and then as I'm submitting it onto Compass, there's a banner that tells you information, and on that banner, it's red to allow for additional processing times for short-term rental applications. And to me, that indicated that was good, but it'd take longer. So it was in a long-term lease at that point until 5/2. This ordinance passed 5/4. And so on 5/2, when the tenants moved out, we started putting more money into the property to prepare it to become that short-term rental, while we're also simultaneously been in building our house for the previous year. So
That's fine, Mr. Kennedy. So I've got a quick question. Miss Duma, you're still okay. A quick question for you, sir. You said in 2022, you converted this house to an STR.
Incorrect, no. And in 2022, we were preparing for it. I signed my last long-term lease because I wanted it to coincide with the completion of my new construction. We anticipated the completion of the new construction in May, but you know, everything happened. It's taken much longer than we anticipated it to. So we think it'll be done in December, sometime in December. But we wanted it to time it to where when we moved in, they were both completed.
Okay. And then on May 2nd, it's your testimony that you started the application process.
I started it in April because I knew when I signed that last lease in June that it was up in May 2nd. So I didn't pay any mind until I got closer to the end of that lease because I wanted to respect the tenant's rights in that
Understood.
lease.
All right, thank you.
Mhm.
And as part of an exhibit to his brief is his entire application. And we'd never heard that there were any problems with his application whatsoever until today. And I posit that there's not. If you'd like Mr. Kennedy to lay foundation for it, you can. But it was just a blanket statement that there was issues. There was no evidence of it. So I would object to that and say the only evidence before the BZA is his actual application, which is suffice it for approval under 2018. And the last, because we need to talk about him not. The reason why he should be heard today is because he did not get notified of his rights as was required under the 2018 STR ordinance. He did not know, right? Mr. Kennedy, can you just talk to that really briefly?
Correct. I got denied on the 31st. I came down and talked to Justin Smith. Justin Smith told me that the new ordinance contained verbiage that denied or voided all existing applications, and then referred me to
Right.
neighborhoods.
Okay, city council made their decisions or on or about May 4th to take it out of city planning and push it into another committee. Ms. Dumas' testimony said that Councilman Bunch said, what about these applications in process? They should have addressed that in their proposal that was approved and amended and approved by the city council. That was not done, sir.
Correct.
Mr. Rexwinkle, it's the testimony that Mr. Wright was never sent an email about, do we have a timeline on that would dispute that?
I think he said he was given an email on May 31st.
I was.
Yeah. And just like everyone else, the emails were all the same. It just said that the rules have changed and we can't process your application. And you can, may have referred to a website. We can put it back up on the screen, but everyone.
And Mr. Rexwinkle, on that particular 1.1 that we're hearing right now, when did he file his appeal?
I have it.
Or about when?
The appeal was filed on July 27th of
So
2023.
many days after the initial email that he received. Correct?
Almost 2 months.
Okay.
May I cross-examine Mr. Rexwinkle
Of
for the
course.
record? Mr. Rexwinkle? Of the email that you sent, you're aware that it was required to give notice as to why an applicant would have a right to appeal under the 2018 short-term rental ordinance, correct?
No,
You're not aware that what it reads,
the ordinance that required that was no longer in effect.
but the 2018 ordinance did require it, correct?
Yes, the ordinance that was repealed required it.
So the 2018 ordinance required it, but the email that you sent, it required it so the people would know they had a right to appeal. Isn't that correct?
No,
It just, okay, so the 2018 ordinance did not tell the people that they had in writing that they had the right to appeal to let them know. That's your testimony?
the ordinance that was repealed had the requirement to notify people of their right to appeal. The decision to send the emails on the May 31st was based upon the fact that the ordinance was repealed. There was no longer a requirement to notify people of their right to appeal.
But you have allowed appeals of this 2018 ordinance, isn't that correct?
I have what?
People to appeal the 2018 ordinance, correct?
Board has.
And you unilaterally, or someone in the city planning and development has allowed at least 6 others to appeal out of time, isn't that correct?
I don't allow anyone to appeal. If they apply, we take it to the board. Board decides whether to hear it. There are a couple on the agenda today, including this one, that are about timeliness. So it's up to the board to decide whether to hear it.
You,
I don't make a decision on
Ms.
that.
Duma, I think we're over on time. I know we're gonna have a
Okay,
series of cases here, but
then
we've already,
he'll be impeached later.
let's keep comments applicable to the case. Mr. Tobin, I have one question for you. Is there a reason you can't just apply under the new neighborhoods ordinance for your short-term rental?
I'm building my house and I would like to live in that house. And the new ordinance has that stipulation where you gotta live in it. And I want to live in the house that I just built, spend all that money on, you know? And I want to offer my family a place to stay when they come in town. And it's reasonable. It's 4 acres. It's great. It's perfect. It's not,
And just a reminder, so is the short-term rental, did you say it's on this same property?
it's right next, there are 2 properties.
Right
It's right next, it's on its own 2-acre tract.
And just
Thank you.
family stays there, right?
I would love for it to just be family, but it has a mortgage on there and all the things, so it needs income to also coincide with that. And I didn't want a long-term rental because it doesn't offer the flexibility that a short-term rental would.
But you could pursue a long-term rental under the city requirements if you so chose, the
Absolutely.
property you have, yeah, okay.
Just in closing, he lives right next door to this lot. He made an investment, substantial investment to convert the use. He spent $750,000 to stay in Kansas City, Missouri. And under the law, he reasonably relied that the law was going to remain the same. He had no idea about it all changing because his lease for his tenants weren't up until May 2nd. Therefore, he has the right to have his permit process administratively under the 2018 STR ordinance. And I ask the board to please approve Mr. Tobin's 2018 short-term rental ordinance.
I would have also kept the 7 acres that I sold to build my house on initially if I would have foreseen these issues. Right, it's a larger piece of ground. I'd have had more fun on it. But it's just kind of how it is.
Thank you.
And just for the record, make sure the summary is in as part of the PowerPoint. Is that okay?
Yes, we admitted the PowerPoint is.
Okay,
is-
17,
yeah.
gotcha.
Okay. Board members, any other questions? Comments? Again, Mr. Kennedy, I'm sympathetic with your process, but back in early April, maybe that was the time to start the process for the STR.
That's what I did.
I just heard May 2nd was your testimony.
Absolutely. The process of getting the signatures, getting the, fulfilling the applicant,
Right.
that's when I did start. It just wasn't fast enough. I had no idea I'm not in the short-term rental business, I'm a long-term rental guy. And then come around and I blinked and things changed and
Right.
it's unfortunate.
Okay. Heard testimony? Board members, any other questions of the applicant or Ms. Newman? Comments, motions, anybody?
Chair, I think that since he lives next door, he'll be very picky on who he lets stay there, and also in case any parties or anything, he would be able to control it instead of somebody who lives in California, he's next door.
I guess one comment I have, I'm just concerned of the precedent that we'll be setting of allowing applications to not be filed within the 15 days and how this might move forward as we look at other cases that aren't just short-term rentals. And I'm just a little nervous on if we start allowing this outside of 15-day window, kind of the flood that we'll see as a board related to appeals that aren't within that time frame.
Very true.
Can I say one more thing? The things that I had on my list here, to why I want the STR next door, the family aspect, the flexibility, the income, the oversight, 24 hours a day, 7 days a week, to protect my neighbors who I have extremely high support from, supporting me in this endeavor. I'm looking out for everybody in there, including my family. So I guarantee you it wouldn't be a problem because I'll shut it down.
And Ms. Mixdorf, I don't have any other clients coming after my appeals. The only issue with these particular ones is these guys didn't know they had a right to appeal. They weren't told in the email. And when they came and asked, no one told them. That's why they were late. He didn't find out until he talked to me that there was even an option. So I don't think it'll open that floodgate, and it certainly won't from my end.
All right, board members, what do you want to do?
Sure.
Go ahead.
Yeah, Mr. Chair, I'd like to ask the ordinance for him and motion it to do it.
To overturn
Overturn,
the
yeah.
appeal. Is that what you're saying?
That
Or
is that
the-
to protect
that
his
the right?
$750,000 investment next door.
All right, I have a motion from Mr. Gorens. Do I hear a second from anyone?
I have a question.
Go ahead.
He's requesting to change the appeal. I think what we're asking is, are we allowing to hear the appeal after 15 days? Is that what we're voting on?
I think, excuse me. I think that's correct. The decision is, he was out of time, so he can't have BZA hear the appeal. So at this point, you would decide whether you would hear the appeal in the future.
Okay, got it.
It'd be the same information.
Yeah, so Mr. Gorens proposed a motion that we hear this appeal at some future time. Second, anybody? Not hearing one. What about a different motion?
In case number 1.1, I move that we deny the appeal for docket number 1.1, case number 111.
I have a motion. Do I have a second on that one? All right. I can't second.
I'll second.
Thank you, Ms. Bryan. I have a motion and a second. Anna, please call the roll.
Gorens,
Yeah.
I can't hear you.
Speaking.
No.
Moran.
Aye.
Mixdorf. Wright.
Aye.
Ebbets.
Aye,
Thank you for your time.
sorry. Thank you.
Going back to docket item 1.2. This is case CD BZA 2023-0013 for 32 East 32nd Street. This is a request to appeal the absence of an address in Kansas City, Missouri. Parcel viewer for a duplex on about 0.2 acres generally located at 32 East 32nd Street. City staff recommends dismissal because the issue at hand has been resolved. There is an address in parcel viewer. I'm pulling up the overview for this one. Bear with me. If the board chooses to hear the full case.
I think we should hear this, at least for the dismissal request. Ms. Duma?
Miss Wright, is she on
Yes.
Zoom?
I'm here.
Amber, can you please tell the board what happened
Wait,
with?
Ms. Wright, hold on just for a second. We've got to swear you in.
Yes.
Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
And please identify yourself again for the record, Ms. Wright.
Amber Wright.
Thank you. Duma?
Question quick. Since
Yep.
this one is for dismissal, are you still presenting anything or is it?
I still have something to present for this one.
Thank
Okay,
you.
sorry. Go ahead.
Miss Wright, can you please explain to the board what happened with the?
No,
No.
Anna had a presentation.
Anna's
So
gonna do a
every
quick
case, Anna will do
presentation.
her quick presentation, then we'll go to you. You're good.
Okay, again, the key facts for this case still applies. Okay, it's sharing now. My apologies. The city council is the legislative body that makes laws. City staff applies the laws. In an appeal case, the BZA determines if the city staff made an error in applying the laws. As previously mentioned, the city council repealed STR related laws early May. After May 4, city staff no longer had STR related laws to apply. So the BZA must determine whether, in the absence of the laws to apply, did city staff err in closing the cases. In this case, there is no application. The address 2 was discovered around April 24th of 2023. And city staff, we then did immediately begin working on getting that address to the system, since through some correspondence with other departments, divisions, we determined that it is a valid duplex. So we got that address in the system promptly. It just so happens that the addition of that address in Parcel Viewer did overlap with the ordinance related to STRs being appealed. So the property owner did not have a chance to apply for an STR permit at the address in this duplex, 32 East 32nd Street. Again, the error identified in the application was that there was no address available for the property owner. We did work on resolving that manner as quickly as possible, which just so happened to overlap with the STR ordinance being repealed. The correspondence that we had with the property owner did not include a statement about the 475, and that is because none of our general emails include that statement. We send emails, every single day. And the board may sustain the appeal only if it finds that city staff erred and they are a plaintiff in a larger lawsuit about this topic. That concludes my brief overview.
Thank you. When you ready?
Having her pull up my slide to transition from the.
I have a question for staff. You said there was no application?
No application for an STR for this address, 32 East 32nd Street.
But there was an application where they found there was no address?
Correct. We've also applied for a STR application at 34 East 32nd Street, which is the other side of the duplex. The materials in that document indicated that there were 2 units being sought. So there is no STR application for the other side.
Okay, I get it. All right.
Just to summarize, this is an application where she wrote 32 and 34 on the application, as opposed to doing 2 duplicative documents that say 32 and then 34, and that's the city staff's issue with it. But I think Ms. Wright's going to explain this better than me. Amber, can you please explain what happened with this address issue, why it stopped you in 34, what the city did, what they promised, and then what they took away?
Yes, I applied on April 17th. I put both addresses at the top of my application. They came back and said I would need 2 applications for each. They took a week to respond and say that I needed modification. So I applied on April 17th. They got back to me April 24th. And then from there, I went to apply immediately once they said that I had to have an application for both sides. And the address was not in the system. So I quickly called Anna, or emailed with Anna, emailed and called Justin Smith, finally got to someone that said that they would put it in the system, Mr. John Pajor. And I followed up daily with John, and the address never got in the system. They said that they wouldn't process my current application on 34 until I had the application on 32, which I never understood. And then so then when the address finally I checked and it was in the system on May 16th, I submitted the application, and then they said it was too late. I would need to contact Matthew Keeney. I followed up with him. I called several times. I never heard back. Justin Smith, prior to this, said, don't worry, your application's in, this will be no issue. We just need to get the address in the system. Unfortunately, it is an issue, and I now am being denied the application on 32nd to no fault of my own, other than it was not in the system, and then it was not put in the system prior to the date the laws changed.
Amber, you have an application also for 34 East 32nd Street, and you were allowed to appeal even though your appeal wasn't in 15 days. Is that correct?
Yes.
Did you have to ask the Board of Zoning Adjustment for permission to do that?
I have a seasonal permit on that side.
Yes, but you didn't have to, you were allowed an appeal on that property, correct? And before the BZA later today?
Oh, yes. Right. Yes.
As one board member, I'm kind of in sympathy that the parcel was not in parcel viewer and there was a delays in getting that in there. But I'm just one board member on that issue.
I guess it would be also relevant to know when she bought the property, so you know that she wasn't just trying to get a short-term rental permit last minute.
Right.
Amber, can you speak to when
We
you
see it in the timeline.
Okay, you got it.
Yeah, I mean, and I can elaborate. I mean, I bought it in May 2022. We fixed it up with an elevated design. We probably spent an extra $50,000+ to convert it to a short-term rental. It took us a while to get the signatures. That was part of it. We started this process in October 2022 to get signatures, and we didn't get them until March 2023 because of just getting a hold of neighbors. So it took me 6 months to finally get all the signatures. And that's why I probably would have applied in 2022 had I known this was going to be such an issue.
Thank you, Ms. Wright.
Yes.
If I can, I would just say, I think this testimony highlights what is the question of what is being appealed. If the appeal is for an address, there's nothing in the zoning ordinance about addressing. So there's no right to appeal that there's not an address to this board, at least. If the appeal is about whether it was a duplex or not, that's a different question, but there's no application to have denied in this case. So that's what we've been told the appeal is for. So there's no decision that's been made on an application for a short-term rental at this address.
And I would submit to you an exhibit to Mrs. Wright's legal brief, and I can show it to you. I have it in my hand right here that clearly says 32 and 34 East 32nd Street. This is an application that was submitted. So that's just not true.
And we require that each individual address has a STR permit.
Right.
Which I would have done had it been in the system. I would have done it in time. Had this address been in the system, and I requested it for weeks and weeks. And by the time it was conveniently put in after this all changed.
Right. But you do have the permit to operate the other half, correct?
Yes, but I can't operate it for as many guests as I would have both sides. And I spent significant amount of money on this duplex to remodel it and bring in the income I anticipated it would.
What is the difference between a long-term rental investment and a short-term rental investment, Miss Wright? You're in real estate.
The finishes are higher end. We opened it up to make it more accommodating and comfortable. I mean, like I said, I probably spent about 25% more on the finishes. I furnished it, which was about $60,000 for both sides. We spent over $200,000 between the remodel and the furnishings. We would probably have spent over $100,000 less had this been for a long-term rental.
Thank you, Ms. Wright.
I had a question. Per the staff notes, staff response, it says the address was available on 4/26 to 4/27. Is there any reason why it wasn't available after the 27th?
The address was made available at that time, yes.
Okay, so it was still available as of April 26th. Okay.
Mhm.
But it wasn't there, I don't think, before then. Is that
Before that, there was no address, and you have to have an address to apply.
right?
The address was not available until May 15th or six, I think it was 16th. Was when it was finally put in the system.
Per staff notes, it says it was available on April 26th.
That's incorrect. I have emails to prove it.
All right. Board members, do I hear other comments on this case and or motion?
Mr. Chair, I have the same question. Living in California, who's gonna manage the property here in Kansas City?
My parents live there, and this is another reason similar to the prior case. We bought this as flexibility. My sisters live in Texas. We all have kids. We can't fit in my parents' house anymore. And so we bought this for flexibility to come home and stay or have some of the family stay because we can't all stay with my parents. So my parents manage it. They assist with anything. They live 7 minutes from the property.
Thank you.
Yes.
And to go on the record, Ms. Wright is part of the quorum on this. Review the case.
Yep, a few housekeepings that we're reestablishing the quorum with Ms. Wright. We have exhibits 1 through 6, and then we're also revising exhibit 9, which is city staff's presentation, to add the additional slides that were attached to the packet.
Those are all admitted along with your brief as well.
The legal brief and the slideshow.
Thank you.
Those are included.
And also incorporate 1.1 into this testimony as well, because I feel like these cases kind of build on each other.
Sure. Ms. Wright, it sounds like you were kind of caught between a rock and a hard place on this address.
There was nothing I could do. Unfortunately, I'm at the mercy of you all, and I hope you make the decision to proceed because there was nothing I did wrong. I did everything prior to even the date that this all changed, and out of no fault of my own, the address was not put in the system until after May 5th or 4th or whatever day it changed. And I have emails showing that I checked daily trying to apply, and I would call John Pajor daily to see when he was going to get this into the system, and it was not done until after. And so there was nothing I could do.
Thank you.
Thank you.
I might sound like a broken record here, but I have similar concerns. I know Ms. Duma voiced, these are her cases, but not meeting the 15 days of the decision being appealed. I'm just concerned for the precedent this will set on future projects.
And so it says, so on May 31st, I did send on an email saying that your email does not meet the requirements as set forth. So I'm not sure, is that what you're speaking to on that I didn't appeal it until
this one because the address wasn't in?
Oh,
They
right.
didn't process it,
So that
and
was only
so
for
they didn't
34.
tell you had rights to appeal, and they allowed other people to appeal, but they don't want to allow you to appeal. That's what's happening.
Right. Sorry.
Mr. Chair, can I say one
Please.
thing? There's been some discussion and testimony, discussion amongst the board and some testimony you've heard about the investment people are making. And I need to remind the board that these investments are being made before there's permission being granted for the use. So that's not protected in any way. You can't make an investment and then say that the rules changed before you got permission to do the investment, so apply the old rules to me.
I agree, Mr. Excellent. And the price that they're paying for the property or their improvements does not have any basis on my vote today on any of these cases. It's more the dates.
Yeah, I spent the money a year before. I just couldn't.
Thank you, Mrs. Wright. I think we've heard
Yeah.
your testimony. We appreciate you. I would offer a motion on docket number 1.2.
Okay,
Mr. Chair, in case number 113, I would move that we deny the applicant's request for appeal.
Second.
I have a motion. Do I have a second?
Second.
Please call the roll.
Lawrence,
Aye.
Moran.
Aye.
Mixdorf.
Aye.
Aye.
Ebbets.
Nay. The denial is approved, or so to speak. We upheld.
Okay,
Sorry.
we have docket item 1.3. This is case CD BZA 2023-00068 for 1704 Jefferson Street. This is a short-term related appeal for the subject site. I want to clarify that we are admitting additional exhibits 21 through 24, revising exhibit 9, amending exhibit 19, and reestablishing the quorum with Ms. Wright. Okay.
Anyone coming up?
This one's me, so I don't know what they're starting
Yep,
again.
I'm just sorry. Yep, it's just
Represent, but did you have
taking
any?
me some
you got
time
any-
to.
Is your applicant coming up?
I am the applicant.
Okay, thank you, Ms. Gilman. Sorry.
Okay, same applicable key facts apply to this case, so I won't go over them again, but they are listed on the screen and all of the information is available in your packet. The merits of this case, really quickly, is that the applicant did apply for this STR permit in 2018. Lots of communication with city staff occurred between then and the ordinance being changed. However, the STR permit was never approved. The deficiencies involved in this application in regards to the 2018 ordinance involve that the registration form identifies multiple units within the structure, which affects how the STR permit would have been processed. And the IO for the case being closed was sent out on May 31st of 2023. Key points for this particular site: that the error identified in the application involves the notification not being met in regards to chapter 88. And our response is that applications that were pending when the ordinance was repealed were closed. The status changed to denied. The message in communicating that denial / the case being closed did identify why the change occurred, but the application path is under new regulations. It did not include the application, the statement from 88/75, which is about the right to appeal, again, as none of the IOs from Compass Casey include the statement. The board may sustain an appeal only if it finds that city staff had erred. They are a plaintiff in a larger lawsuit and they were operating without a permit. That concludes my overview.
Thank you, Ms. Allen.
So can we go back to that?
Ms. Duman, to preserve your rights, this will be admitted as part of your exhibits today, along with other materials that you did in case number 1.1.
Yes, we're going to include all the other cases beforehand. Thank you.
Perfect, thank you.
And this is the law in Missouri. If an owner substantially converts a property to a new use, I purchased this property in 2017. This was before the 2018 ordinance. The 2018 ordinance came into effect, meaning they started enforcing it in August of 2018. I opened in April 5th. All of my surrounding neighbors have submitted affidavits saying that they want to support me in being a short-term rental operator. This property is zoned B1. meaning that all I had to do was fill out 2 forms for it to be a duplex. Initially, when I opened, it was a triplex. And y'all see you guys in a couple months on my certificate of legal nonconforming use because I was open as a triplex. And after in 2020, that was the first time that I heard anything from the city with respect to whether I could be a triplex or not be a triplex or what was going on. Now, the reason why this is significant is I submitted my application on August 8th of 2018. I know there was some issue with, well, why didn't I follow up? There was no one enforcing at the city. The city audit that was recently completed found that of the 1,800 short-term rentals that were in Kansas City, Missouri, there was only 7% of them that had permits. There was no compliance. And so I did not follow up to see if I would have gotten my permit, because I presumed at that time that I was okay operating, because I filled out the paperwork. I came down here, I went to City Hall, and I talked to somebody that helped me fill it out here and congratulated me. And so when I got Miss Binkley's email in 2020, I set up meetings. I tried to find a solution to the problem, and I was the last person to reach out to the city to ask them to do their job. Guys, please come out. I'll do whatever it takes. I'll take an oven out like you suggest. I spent over $1.2 million on this property. It was dilapidated. Okay, I'm going to show you guys some before and after photos. Go to the end. There you go. Go up one. Go up another one. One more. Okay, this is 1704 Jefferson when I purchased it in February of 2017. I personally GC'd the project. I'm not very handy, so all I could do is pull nails out of the floor and pick up trash, but that's what I could do. As I organized over 50 trades, spent $1.2 million of my own money that I had to borrow and beg for to get this project done. And I want to show you videos, but I can't because of the time limit that's been constrained on me and because the technology's not working. So let's go to the skip 2 slides. These are videos of me before the grand opening. This is after of what I've done to the property. So I substantially converted this property to the use in April. It was done completely in April. Therefore, I have the right to have my permit processed, not delayed and for 5 years and then ignored.
And you said April 2020?
18.
April
5th, 2018, I had a grand opening party.
Right, so April 2018, the project was completed, correct?
Yes, sir.
And Ms. Newman, you're here today because you're saying the email did not meet the requirements as set forth in the city code.
The reason that that was the boilerplate language is because we had no idea we were going to have a right to appeal. Everyone was telling us we didn't have a right to appeal, go to neighborhood services.
Right.
That's why you have that boilerplate language. City planning and development and neighborhood services, no one mentioned an appeal right. It wasn't until I filed the lawsuit that Brett Casson in his answer to the court, in federal court, said, well, why are they here? They have a right to appeal. And it was like, holy moly, we didn't know that. So we were blessed to be here to have the right to appeal. That's why that language is there.
And of course, on the other 2 cases, you can always take these to the next level up, which is circuit court, as you know.
Yes, and so, you know, I've done, of the 15 properties I had before you today, 13 of them have been completely pro bono. I have not made a dollar from doing them. So if you guys want to punish me monetarily, 2 things. 1, you got me for about $200,000 in legal fees so far, and I'm happy to pay the back 2 permits.
That has no relevance. I'm sorry.
Okay.
It has no relevance on whether you do work pro bono or not. I'm sorry. Thank you. Rex Winkle, I think you've answered this before. So the blanket email that went out on May 31st, does it have to identify their right to appeal? That's my question to you as city staff, not to Ms. Newman. Do you have to have language in there that says that?
When we prepared the language, we did not, since the ordinance had been repealed, our position was that it didn't need to include that language. When we prepared the language for the email that we had to give to the IT staff to put in the system.
Right. And that's because the ordinance had changed and it was no longer under.
That ordinance didn't exist anymore. So the way we kind of see it is when it comes to administrative review and approval of things is that the ordinance has to give staff authority. If we don't, doesn't explicitly give us authority to review or approve something or deny it, then we don't have any authority at all. So once it was repealed, the position that we took was that we had no authority to do anything at all with the pending applications. And that is what I said to the city council at the hearing. And that's the action we took afterwards. And that our email that we configured just reflects that we don't have any right to take any further action on your application.
Okay.
Does this property, can it be applied under the new ordinance since it's zone B1?
I'm not sure.
Because there's 1,000 square foot density rule under the new codes, there's already properties within 1,000 square feet. And pretty much it stops all B zone or B new STRs because in the urban core because of that 1,000 square foot radius. It's a huge zoning density for business use.
And Ms. Duma, I'm not familiar with that part of the code. Can you appeal that?
Can I appeal that part of the code? It's part of the federal lawsuit.
Or get a variance for that? Oh, so.
You cannot get a variance from neighborhood services. They don't have an ability to grant a variance like you guys do.
Okay.
It's just, did they follow the code or not? And in this case, they would have followed the code. So an appeal would be unsuccessful if I apply for neighborhood services.
Right. And you said you've got a pending lawsuit on this matter?
On the 1,000 square foot density, it's part of the federal lawsuit. Yes.
Oh, it's part of a federal lawsuit.
Yes.
Okay. Thank you.
A couple other just policy things I wanted to bring up to you guys. You know, I'm going to appeal these cases that they're denied. And when I do, my clients are currently having damages because they're no longer listed on VRBO and they're a lot of properties are delisted on Airbnb. So ultimately, if I do win based on the law, the city's going to pay those back. The taxpayer is going to pay those back. If you let these 15 properties have their short-term rental permits, they're going to be paying that 7.25% and will be putting money back into Kansas City, Missouri. And the Kansas City, Missouri met its goals. In 2022, there were 1,800 unlicensed Airbnbs. Today, there's only 600 and they're delisted, they're gone. So the goals are met. And whether you want to give the city more money or potentially take it away if I win is something you should consider when making your vote.
Ms. Duma, I'm in sympathy of your case. Again, I'm to talk about the email and the denial of your request.
I guess where I struggle, and maybe it's just me as one board member, but I know you've been operating very well for the last, 5 or 6 years, but the fact that it wasn't processed, I know you thought things were good, but I think you were one of the few cases that actually had the time to get it, through the city process correctly. And that's where I'm struggling a little bit.
But that's in their court. They had everything. They should
But I
have
think
denied
as a project manager for any other things, I think of all the follow-up I have to do. So I think there's some onus on you as well to follow up on that to make sure things are still moving.
I was the last to contact the city begging them to come out for a site visit to get legal. They stopped communicating with me. And in fact, I have an exhibit in the slideshow. I have other projects in Kansas City, Missouri right now that are historic tax credit projects. I'm trying to get a pre-application meeting. Kansas City, Missouri, Joe will not talk to me. He's been told not to speak with me about my project.
That's not applicable to this case, Ms. Duma. Thank you.
It is to the communication with the city.
Board members, any other questions or comments? Motions?
I'm gonna say I'm very sympathetic to all these cases and these are hard for me. But it just seems like these are questions that either the city council or needs to address as part of their ordinance, or, you know, staff needs to address as part of their procedures. I think it's not really for the BZA to address. So I'm gonna move that we deny this request for an appeal.
So in case number 68, you're recommending a denial. Is that right, Ms. Moran?
Yes. I'm moving for denial.
Thank you. And do I have a second on that?
Second.
Second, Ms. Mixdorf. Anna, please call the roll.
Lawrence,
Aye.
Moran.
Aye.
Mixdorf. Wright.
Aye.
Ebbets. Hey, this is docket item 1.4, case CD BZA 2023-00082. Property in question 4037 Forest Avenue. This again is a appeal related to a short-term rental request. Housekeeping matters, we are reestablishing the quorum with Ms. Wright, amending exhibit 15, and then adding exhibits 17 through 20.
Thank you. Ms. Anna, do you want to present? Thank you. When you're ready. Or Joe, looks like.
Just lots of buttons to click to get the screen to share properly. And it is loaded. Again, the key facts for docket item 1.4, the overview has not changed from the previous three. And this information is available in everyone's packet and available on Compass KC. The timeline related to the specific property includes that the application for the STR permit was applied for on April 19th of 2023. Now, they just applied for the permit, a zoning review. The case number reads CDAA 2023, blah, blah, blah. So that would have been the correct case type to apply for, but they applied for the permit application. If the QCR deadline associated with that would have been April 26th of 2023. And then the ordinance changed on the 5th, and the IO explaining that the permit case was closed was sent out May 31st. And in addition to an incorrect application being filed, the application was processed underneath the right case type. Deficiencies in that application would have found that there was no adjacent owner consent, which was required at the time for a short-term rental at this location. This is a copy of the IO that was sent out. Again, explains why the case was closed, but does not include the statement from 88-575. Again, the error identified in the application was that the improper notification was sent out. Our response to that is, again, that all pending applications were closed due to the repeal of the STR related ordinances in chapter 88. The messaging for that appeal was denied, but that's because we don't have a plan status in Compass KC to accurately reflect that. And the board may sustain an appeal only if it finds that city staff have erred and they are in a larger lawsuit. That concludes my presentation on this.
Thank you. Ms. Duma, do we have Mr. in Zoom?
Dirk, you there?
1 second, I am promoting Dirk.
Thank you. We'll swear him in just a second.
Go up.
No worries. They have been connected.
Thank you. Mr. Dirk,
There you go.
can you raise your right hand to be sworn in? And turn on your camera and microphone if it's not already on. I see.
Yeah. Hang on 1 second.
Thank you. I see you there. Sir, who are you with?
This is my wife, Kendall.
Great. I'm going to swear you both in. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
We do.
We do.
Please identify each of you for the court reporter.
My name is Dirk Youngkin.
My name is Kendall Youngkin.
Thank you.
So I guess
Wait,
to
hold
jump
on
in,
just for a second. Ms. Duma is going to start, and then because we've already heard from. Yeah, so Ms. Duma, thank you.
Yeah, so this case essentially boils down to the reason they didn't have that 55% adjacent neighbor consent signed because someone took it out of the Compass KC format in the spring. I've got 2 cases like this. And so Dirk will tell you how he came to appeal and how he came to make his conversion to the use. But when he went to go fill out his paperwork, it was not present. I'd also make sure that Dirk's legal brief is part of the record and that we incorporate all of the 1 cases today into the Mr. Youngkin's record.
Thank you. And that will be admitted as well, Ms. Duma.
Mr. Youngkin, Dirk, can you please tell us how you came to purchase the property and what your intentions were when you did?
yeah, absolutely. So I came to buy this property. We have a good friend that's been living out there and we visited for years, fell in love with the community, the church that we're a part of out there, and we can't afford to live out in California. So we wanted to create a home for ourselves and we planned on staying there long term. And my wife is actually due any moment with twins. And so we're at a little bit of a tug of war right now with making sure that we can have some support during her pregnancy. And so we knew we were buying on the east of Troost, which is, taking a risk as well, but we wanted to start a family and have time to spend out in Kansas City. And so now we have to be back here and there. And so the whole point of us doing a short-term rental is just so that when we aren't able to be out there and be back home with some family, that we have the ability to still make it work. We invested, obviously I know you guys have heard, but we invested everything into the furniture. We take very good care of it because it is our home at the end of the day. But like she mentioned, we did not have the ability to upload the signatures. Once I was aware of this, I did get 100% of my signatures. I'm really close with all my neighbors. I have all of their phone numbers and we're all in texting, but of course, this is where it lies today. We do look forward to getting close with the community and continue growing. But at this point, this is where, we're at.
And so Dirk, when did you actually make your application?
I made my application back in April.
April 19th, 2023. Does that sound right?
Yes.
And when you made it, what knowledge did you have about the law changing, if any?
I was not aware of this at all. So I just was scrambling when we were in the first trimester with her. And so I was just trying to make sure that I could get it in as fast as possible.
And when you went into Compass KC and you did you fill out everything and then that's why you were scrambling to submit it?
Yeah, absolutely. Yeah, I went in and made sure to get everything done and was just spending my day online trying to make sure I did it correctly. And I wish that the online consent for the adjacent properties was there because we wouldn't be running into this today. But the moment that I knew it was necessary, and I don't know why it wasn't showing up when I was online the first time, but once I made sure to get it over, it was 100%.
And we do have as an exhibit to his legal brief, his completed application with everything that's necessary.
Okay, thank you.
I have a question for Joe or Anna. Have you experienced other issues with Compass KC where things are maybe not visible or not showing up for applicants?
So I think there are technically like 2 things to address. They applied with the CDSTR case type, that is a permit, and that material wouldn't have been required for that case type because they filed incorrectly. Materials aren't disappearing from Compass KC. Some cases may not be visible on Parcel Viewer, but that's like a separate conversation.
So if it would have been filed underneath the right kind of type, then that request for the adjacent owner signatures would have likely been on their screen.
Correct.
To submit.
Correct.
Is it a common occurrence that this wrong case type was submitted for applicants in this? Okay.
Yes.
Yeah. Okay.
I echo Ms. Moran's comments earlier that we're very sympathetic with what's going on, Ms. Duma, not with all your cases so far. it's, and we're here only about the permit denial, suspension, revocation. I wish you could work with city council to have some of these that were in process go through the system, allow you to have your SDRs. You've obviously, everyone spent a lot of dollars on that, and I'm sympathetic with that. You know, you always want a return on your investment. My daughter stays in SDRs, so I'm very familiar with them. So,
just to be clear, so your position for these cases, and I don't want to put words in your mouth, I want to understand,
right.
is that you guys as the BZA don't have the ability to overturn what the city planning and development did.
Right.
Okay.
Isn't that right, Mr. Rexwinkle? Right? Did you
think
hear
so.
what her comment
Tell
was?
word maybe.
I think that's a legal question.
Yeah.
Okay, yeah. Where'd he go? Hi.
I think if that's something you want to discuss, we could go into a closed session to discuss it.
No, I don't. Thank you.
Well, I mean, my understanding is that even though comments may have been made at city council meetings saying the existing cases will be handled, that wasn't put in the ordinance. And so when the ordinance was repealed, it took away everybody's power. I mean, they could have put that in the ordinance, but they didn't do it. So at least that's my understanding of what happened here. So
there is a case called Outcome that hits this issue on the head. It says, what happens when you have somebody that's making a lot of investment to a property and all of a sudden the law changes? What happens to their rights? And so that's why I keep talking about substantial conversion to use and reasonable reliance. And that's the two things that we should be looking at.
doesn't that just apply to legal non-conforming uses?
No.
Okay, I'll have to look at that, but my understanding is you would have had to have a legal non-conforming established use for there to be some right to continue it.
Well, the established use is when does it vest? And the right to the permit is very similar. The right to have your permit process is a very similar analysis. It's actually nearly identical to the legal non-conforming use. When does it convert? It converts when there's a substantial conversion. Substantial, not just buying it, not having plans, not having a permit, but doing the renovations, furnishing the home, getting it business ready. That's a substantial conversion. Reasonable reliance is when did these people do it and did they understand the law was going to change or not?
Thank you, Stu. Board members?
I want to mention that I am in agreement that this seems to be more of on a council end when they passed the law and didn't make mention of what's to happen. I don't think it's something that BZA can kind of make decisions on. Also too, very sympathetic considering the amount of investments that were spent and the need for short-term rentals within our community. I agree that, you know, kind of the current ordinance does need some tweaks. Especially with the 1,000 square or the density 1,000 square feet or meters, whatever. But I just had a question in this case. Did I hear correctly that there was an intent for you guys to occupy at some point as well?
Yeah, we plan to spend time out there throughout the year. We were planning on living here if she wasn't pregnant with twins. And so we have a little bit more need of support around our family. But yeah, we plan on doing both. And so that's why we needed the short term so that we can still come out there and have months out there throughout the year and then be able to come back on a whim for a month if we need the support and then be able to have it be listed.
Perfect. Does that qualify under the current ordinance as an owner occupant?
I couldn't answer that. I don't know if they lived there long enough to meet the Chapter 56 requirements or not.
Chapter 56 requires 270 days of occupying the property. And I think with their family needs, probably wouldn't be a good option for them.
We just wouldn't know.
Again, I echo Ms. Wright's comments about city council taking more action on this. It's kind of above what we normally do here, but any motions on this case?
On case number 1.4 or docket number 1.4. Case number 2023-00082. I move that we deny the appeal of the staff denial of the application.
Motion, do I have a second from someone?
Second.
Thank you, Ms. Mixdorf. Please call the roll.
Lawrence,
Aye.
Moran.
Aye.
Mixdorf,
Aye.
Wright,
Aye.
Ebbets.
Aye. We're going to take a break. We'll pass break time for our staff and ourselves. We'll be back in 10 minutes. Can we do 10 minutes, guys? Is that enough for
Sure.
everybody? Thank you. Thank you.
How you doing?
No, I think I'm okay.
You wouldn't need to, all, then it would become more of merits.
Yeah.
Yeah. You're 34. I'm gonna make a note so it comes out. If somehow you get there. It takes a little bit. Yeah. Cool. Have a good day. Thanks for coming. Man, I got boring days. What? We're still there. Yeah. So we just finished 1.4. We have 1. Yeah, for docket number one, there's 13. Well, it's one, yeah, it's a 1.3. What do you hear? 16. And then $30. Your number, number 19. So.
Who wants one?
Everybody kind of ready? Do we need Joe?
We need Elward and Alec, can you remove the prairie slide, please?
We came back earlier than expected.
Okay. So yeah, we just need Elward.
Mhm.
Mr. Joe, can you text Mr. Aylward or our city attorney? See if he can get back. Thanks. I appreciate it. Before we start our our after break session, I want to thank those people in the audience who have cases later in the docket. We appreciate your patience. We normally don't have this many appeals, but we'll get to you as soon as we can. And again, thank you very much for your patience. We're waiting for our city attorney to come back. Once he's back, then we'll get started. We're going to let Mr. Aylward come back in a few seconds. So let's go ahead and get started.
Docket item 1.5, this is case CD BZA 2023-00080 for 2 Jansen's Place. And city staff, we are recommending dismissal of this case. The zoning related decisions made regarding this STR has been approved. So we're unsure about what is actually being appealed. If there is an error or an issue that's still occurring with the STR permits being accessed through chapter 56 or the neighborhood department staff. This is something that the BZA cannot make a determination on. They do have their own appeals board, the property maintenance appeal boards, and those grievances need to be taken up with them.
Is Mr. Mitchell in the house?
He is, and he'll take the stand here and get sworn in.
Come on up, Mr. Mitchell. Let me swear you in. Thank you. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
And your name, please?
Stephen Mitchell.
Perfect. Thank you, sir.
Mr. Mitchell, I understand that you actually will agree with the dismissal. Can you just tell us what happened with
Wait, we're
your?
going to hold off. We're going to get a present.
Oh.
There is no presentation
Okay,
prepared.
I heard you talk on that. Just right.
Can you just briefly tell us what happened with your application and your appeal?
Yes, it only took the city over 5 years to grant our third floor rental, short-term rental rights. We applied on August the 7th down here at City Hall, and the city never got back to us, which is typical of my experience with the city staff. If they don't want to get back to you, they don't. and they just stonewall you. But anyway, we now have a short-term rental approval under Chapter 88, which I thought should be the case. And it was granted by Mr. Matt Kearney on August the 4th, 2023. I stand corrected. It didn't take, it took almost 5 years. We applied in 2018 on August the 7th. So I stand corrected. It was 3 days short of 5 years. And that's about all I have to say. I thank Mr. Rex Winkle over here, and I thank the Plans and Zoning Department for finally granting our right to use short-term rental on our third floor. And they finally also granted a right for our short-term rental on our carry counts, which we primarily do.
Right. Thank you, Mr. Mitchell. So
Yeah, we consent to the dismissal. We just incorporate his testimony into all the other cases.
okay, perfect. Those are admitted.
Yeah, so just incorporate this testimony into all the cases previously and all the cases going forward. So all the ones.
I'm not sure I can do that retroactively.
We haven't approved the dismissal yet,
Okay.
so it's up to the discretion of the board if they want to add exhibits to a case that's being dismissed.
No, she was asking for the other case.
Oh, yeah, the other cases, yes, that did happen.
Yeah. Okay. So moved or so approved. Thank you.
Yeah.
Right. This is pretty straightforward.
I move that the board dismiss this application for docket number 1.5.
In case number 80, correct? At 2 Jansen Place.
Yes.
Thank you. I have a motion? Do I have a second?
Second.
Thank you, Ms. Mixdorf. Anna, please call the roll.
Lawrence.
Aye.
Moran.
Aye.
Mixtor. Aye. Wright. Ebbets.
That case is dismissed. Moving on, Anna.
Okay. We have docket item 1.6. This is case CD BZA 2023-00079 for 136 Kensington Avenue. This is an appeal related to decisions revolving around a short-term rental application. Bear with me as I share my screen. Oh, and as a housekeeping matter, we are reestablishing the quorum with Ms. Wright, adding exhibits 15 through 19, and then cases 1.1 through 1.4 to this as well.
Thank you. Those are admitted.
The key facts associated with this case are the same as 1.1 through 1.4. So I won't go over it again, but as a reminder, this document is attached to the packet and available on Compass KC. The timeline associated with this particular property includes that on March 30th, 2023, the STR permit application was made. The correct filing for this type of request would have been an administrative approval. This would have come through as a different case type for an R-zoned property. We, in light of preparing for these appeals, we did review the materials again, and no adjacent owner consent was provided, which is why it can't be approved underneath the 2018 ordinance. The QCR deadline would have been the 6th if it was filed underneath the correct application time. And then, as previously mentioned, the ordinance changed in early May, and then the IO for the case being closed was on May 31st. A copy of the notification that went out, the IO through Compass KC, does include information about why the case was closed, but it does not include information about the right to appeal from 88-575. Again, the error identified in the appeal application was that an incorrect notification went out in regards to the cases being closed. We note that all applications that were pending on the date that the STR provisions were repealed were closed, AKA the status changed to denied, since Compass KC does not have a status that accurately reflects City Council's decisions. The messaging communicated for the reasoning for that denial / case being closed did identify why and the correct path to file underneath the new regulations. It did not include that statement from 88-575 because none of the IOs contain this messaging. The board may sustain an appeal only if it finds that city staff have erred and they are plaintiffs in the larger lawsuit. That concludes my overview.
Thank you, Anna. And now it's Ms. Duma's turn. Do we have Mr. Shook in the audience?
Miss Jeannie Shook, she's here and she'll testify. We're just pulling up our slideshow.
Zoom or live?
She's here.
Okay. Come on up. Ms. Shook, why don't you sit and talk into the microphone? So I'm going to swear you in. Do you solemnly raise your right hand? Affirm to tell the truth and nothing but the truth in this hearing today.
I do.
Please identify yourself for the court report.
My name is Jean Van Buvenchuk.
Thank you.
Okay, Ms. Jean, we're going to cover for the record the two most important things. When did you get into negotiations? Tell me a little history of negotiations for this property when you purchased it.
My brother-in-law and mother-in-law had been living there since 2008. The last couple of years, she was declining in health. We'd been talking probably maybe a couple years about us purchasing that, what the timeline of that would be. It was all mostly contingent on her health and her ability to get into navigate through the waiting list of subsidized housing that suited her needs. And so it was September last year, 2022, that took over the payments from my brother-in-law. We were seeking out a real estate attorney to do a private sale. They found an undiscovered lien we were all surprised by that was entered in error. Took us some time to get that discharged. And then it was March 30th March 28th that the transaction of the home went through.
So basically, as of September of 2022, that's when you took over, not actual ownership, but you took over the mortgage payments, started moving things out, started cleaning the house, things like that.
Right, because my mother-in-law lived on the first floor. My brother-in-law had moved across the country. He'd essentially abandoned all his things. He was in a position to buy new where he started. And so I was moving things out, starting to do some cleaning, renovation, that kind of thing. I believe she actually moved out officially in November.
Okay, so when you took these actions, what was your intent for the property?
We wanted to make it a short-term rental. Our intent was to have a rental property, build our rental portfolio. We'd been intimately associated with this house since 1996. We saw it the same day we saw our home that we purchased at 130, 2 doors down. We'd had friends. All of the previous residents had been friends of ours, you know, as we met them. It had been a family home then since 2008, thereabout 2008, 2009. But it occurred to us that having a short-term rental, we could do about the same income wise, but then we could also enjoy the house. We had a lot of foster kids, our own children, our house was packed to the gills. Having a short-term rental 2 doors down would allow us to invite family guests for Christmas and close friends. But then also to maintain the integrity of the block. We've been friends and on friendly terms with all of our neighbors for years. Our next door neighbor at 134, we've lived together for 24 years. The projected tenancy of the short-term rental is just a little over 50%, according to management teams. That meant the parking congestion would be alleviated, and I'm forced to keep the property looking really nice, as opposed with a long-term tenant where I'd have little to no control over how they kept the porch and yard.
Thank you, Jean.
We just need to cover her application process for the record. Okay, so can you talk to us about when you applied and what happened with your application?
March 30th, I put in all the paperwork. The form that was in Compass was that I was to notify all neighbors by certified mail. When I saw the neighbors, I said, hey, don't freak out when you get a certified letter from me. It's just about the short-term rental. They saw me with paint buckets, tools. We talked all the time. They knew it was an STR. They were pleased because again, it kept the block looking nice. It kept cars out of our already crowded street because it was only empty most of the time. We weren't going to assemble a fleet of cars. I kept logging in periodically. There was a little infographic in Compass KC that had a little green bar showing the progress. It kept having a little tiny bit of green bar saying in progress, in progress, in progress. I heard nothing more about it. I didn't understand it to be seeking permission. The law stated it was essentially a registration. If I ticked all the boxes, I was registering with the city, not asking permission. And so I heard nothing more until May 25th when a friend called and said, hey, have you heard about this, what they're doing downtown with short-term rentals?
And at that time, you didn't know that your permit was going to be denied. You didn't know anything about the short-term.
I logged in that day and it's still in process. So I didn't know that it would be denied. I actually called downtown to ask, so can you tell me the status of my short-term rental? Who do I talk to? I was transferred multiple times. I was given the number of Matthew Keeney's office. They said, talk to Matt Keeney, 816-513-3226. Dial the number, the gentleman there. I tried to reach Matthew Keeney over several days. Finally, the gentleman that answered said, maybe you should just make a new application because no one could help me discover when the status might change. I just kept logging in and seeing it was still in process.
And there was something to do with you not having 55% neighbor consent. Can you speak to that, please?
That was something I didn't know about. The form that was made available to me on Compass KC was about notifying. I thought that's not hard. I printed out the letters. I went, got the certified thing at the North Kansas City Post Office. I did that. I talked to all the neighbors. I was only told later that was a requirement, but it wasn't. The portal through which we registered did not make that available. Once I was shown I needed to do that, I went out and I talked to the neighbors and I got their consent.
And that's submitted as part of her exhibit to her brief, her entire application.
Okay, thank you, Ms. Duma. That's admitted. Thank you. All right, Ms. Duma.
This is similar to the other cases. Again, we're referencing all those in here as well. And it's from no fault of her own. She made this investment at a house. She lives 2 doors down where she has foster children so they can have extra space at the holiday season to house her foster children and another family guest. Because how many foster kids do you have?
Well, things have changed since, but I mean, we were under the assumption we'd have them the way their situation looked, 5. That was sort of an accident, but we had some previous children come back to us. And so every single room, we were just packed to the gills with kids and stuff. And so if we had any family gatherings at all, it made a lot more sense to just
Thank you, Ms. Shea.
sit in the family home next door.
So
board members, you have any questions?
Yeah. This is very similar to Derek and Kendall Youngkin. There was the application for the 55%.
Right.
She either clicked the wrong button or something happened that was just a clerical error. And she should be processed under the 2018 because she substantially converted her property to the use reasonable that she relied. The law would stay the same when she made that choice in September of 2022.
Okay. Thank you, Ms. Duma. Board members, questions? Motions? Sounds like you did a lot of things that you write that just didn't work out.
I move that we deny docket item 1.6, case number 2023-79.
A motion, do I have a second from someone?
Second.
Anna, please call the roll.
Lawrence.
Nay.
Rand.
Aye.
Mixdorf. Aye. Wright.
Aye.
Ebbets.
Aye.
Okay, now we have docket item 1.7. This is for case CD BZA 2023-00071 for 5026 North Topping Avenue. This is again an appeal related to a short-term rental application. As a housekeeping matter, we are reestablishing the quorum with Ms. Wright. We are amending Exhibit 13, revising Exhibit 9, adding Exhibit 15 through 18, as well as Exhibit 19, which includes cases 1.1 through 1.4 and 1.6.
Those are admitted.
Sorry, I didn't share my screen. Yep, bear with me, just.
Do we have Ms. Brown in the audience today?
She's online. She's feeling well, so she wanted, sorry.
Ms. Brown, can you turn on your camera and microphone, please, so I can swear you in, and then we'll get your case started.
You may have to repeat that. She just joined.
Okay. Hi, Ms. Brown. Would you mind turning on your camera and microphone so we can swear you in?
Yes, I'm here.
Okay, thank you. Please raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
And please state your name for the court reporter.
Harmony Brown.
Ms. Anna, would you tell us about the case?
Yes, so the key facts applicable to all cases still apply to docket item 1.7. I won't go over them again, but as a reminder.
Anna, I want to pause you real quick. We're only seeing that on one screen. It looks like maybe the other presentation is up on the other side.
You can control it, right?
Yeah, you can hit escape on your presentation. Maybe that'll help.
We don't have
Minimize
an escape
it.
option.
Everybody hold for a second till we get technology going here.
There you go. He's got it.
Thank you.
Thank you.
Apologies. So I'll go over the key facts again, but as a reminder, this document is included in the BZA packet as well as available on Compass KC. The timeline associated with this particular property, that it is a duplex. We are talking about one address, one side of the duplex in particular for 5026 North Topping Avenue. It is a request for a type 2 year-round short-term rental permit. It was filed underneath the correct case type, the zoning review. That application was made on April 25th here. And then it passed QCR, which is city staff, us making sure that it is a complete application. So were all of the correct materials filed? And then we proceed forward with a full detailed review of said materials. After QCR is made, then we schedule the full review. That full review, and for that full review would have been May 24th, which of course is after the repealing of the STR related ordinances from Chapter 88. In preparation for these appeal cases, we did re-review all of the materials and the deficiencies in this application, which is why it is not in compliance with the 2018 ordinance, if that was still in effect today, is that the registration form identifies both units of the duplex. As previously mentioned, each separate unit needs its own STR permit if that is the intent of the property owner. There is insufficient adjacent owner consent. We did have correspondence about the LLCs and and associated with some of those property owners, but they still don't give us enough information to provide accurate adjacent property owner consent. And then mailed notice document, the addresses were updated, but the notarized form wasn't updated, the date of that the notary would have needed to make for said mailed notice. And then The IO for this is the same. And this particular property owner was issued a refund for this particular case. And, oh, excuse me, the same IO did not go out for this particular applicant. I resolved this review in a manner that was not in accordance with the rest of the IOs. However, the same information was presented to the property owner that the review was not completed because of the ordinance change. So again, the error identified in the appeal application was that the correct notification was not sent out. And our response is that applications that were pending at the time that the STR related ordinance was repealed were closed, aka the status was changed to denied. And the messaging communicating the reason for that deny did identify the ordinance change, but it did not include information from 88-575, which is the appeal section of the code. And that is because none of the DMD reviews contain this messaging. The board may sustain an appeal only if it finds that city staff erred. They are a plaintiff in the larger lawsuit, and they have been operating illegally without an STR permit. It was first listed in 2021. That concludes my presentation. Thank you.
Okay, can we bring it back up to Harmony's? And while she's doing that, so the city that there were 3 problems. The first 2 with respect to doing the 2 addresses on one application, that is just a clerical writing thing that could have been remedied in a matter of 30 seconds. The second, updating the notary after she sent it, again, that would have taken 5 minutes. These are not legitimate reasons to deny her appeal. The ones that were communicated to us before we came before the BZA was that she did not correctly identify who her neighboring, who the LLCs that owned the properties around, who owned them. She got their signatures, but they just didn't sign as a member of the LLC. So we submitted, go to the next slide, please. Affidavits from Pat Grace and Brandon Fenwick. Oh, sorry, this is a slide of the properties, so you can get an idea of who she had checked. And Pat Grace owned 2 of these LLCs, so she identifies that in her affidavit, which is submitted in evidence, saying that back before the law changed, that these people signed and that they were the people that owned the LLCs. Therefore, she had all of her documents completed. The matter of a clerical error of just writing a number on a different piece of paper should not stop her from getting her 2018 STR permit. Her and the Matt Rich, another one you're going to hear today, has a similar issue. Everything was done. They were confused. We cleared it up. They still don't want to process it. And it was not about going backwards and, fixing anything. That being said, Ms. Harmony, I'd like to talk with you now about your substantial investment to convert your property to a use. And because we're talking about the first side.
Next slide, Ms.
Yeah. Oh, sorry. These are the affidavits clearing up the matter with respect to who owns the LLCs. Now, Samaya, if you could go 2 more back up. So we're just going to the summary. There you go.
Thank you.
Let's talk about Ms. Brown, the 5026 North Topping. Can you tell us when you purchased the property?
I purchased it in 2019, April.
And when did you decide to make it a short-term rental?
At the end of 2021. So I lived on 5026. I lived there for 3 years. Was laid off, started a business. It's hard. So I was struggling. So I decided to take my side with all of my personal belongings. Of course, I did a little bit of remodeling and excuse me, changed some things out and put my side on Airbnb just to help pay the bills. And I moved in with my mother.
And so that was 2021 that you turned it into an Airbnb, is that right?
2022.
2022. At that time, did you heard of any changes in the laws coming, or did you understand the laws were going to be the same as they were under the 2018 short-term rental ordinance?
No.
So let's talk about your application. When did you make your application to be a short-term rental for 5026?
In April of 2023. I would like to state, though, that I started the process in the beginning of 2022. I attempted to do everything I could to get the signatures, but I am / was, I mean, mostly surrounded by LLCs that have changed hands several times, most of which were also out of state owners. So throughout the whole year of 2022, before I went live on Airbnb, I was doing everything I could to get those signatures.
And
And it wasn't until a new ownership at the end of 2022 that I was finally, it was a new local LLC. So I was able to get in touch with them and get those signatures.
before the city dismissed your application in the mass denial flush, did they communicate that you would be processed or give you any assurances?
At the city council hearing, I was disappointed in the new ordinances because the new ordinances will not allow me to operate. And yet I left that day at the city council hearing feeling okay because I understand why ordinances are needed. But I felt okay because, well, at least as they said, Eric Bunch and other people within the city council, we were going to have our applications processed.
And that didn't happen, did it?
No.
When were you denied?
I
Is it,
believe it was the end of May is when, I believe it was the end of May.
Harmony, does May 24th sound correct?
Yeah.
When you initially applied to appeal to the BZA, were you allowed to apply, or did you receive an email saying you could not appeal to the BZA?
Well, at first, I did apply for the appeal and they were voided. And then I received an email that they had changed, that the city had changed their minds and they were going to allow me to appeal.
Who'd that email come from? Compass KC?
That was, hold on, I had that open. Jared Clements, I believe, is that his name? Yeah, Jared Clements. And that was on July 7th.
So that's why you're here to appeal today. You didn't have to ask the BZA to appeal out of time, correct?
Right. I mean, I, you know, again, I was denied and then they came back saying, hey, we've changed our minds and we're going to allow you to.
I think that's all I need to get in for her.
Thank you, Ms. Duma. Thank you. Board members, do you have questions of either Ms. Duma or Ms. Brown?
May I say something?
Yes, ma'am.
So the part of the address changing on the neighbor consent, I don't know exactly which one they're referencing, but I know at one point they'd asked that I notify our neighborhood, our neighborhood committee. And I had reached out asking, you know, I'm not aware of one. Who is that? I eventually found it through the parcel viewer. I was waiting for a response from the city, so I went ahead and mailed the notice, even though I saw on the city website that that neighborhood department was no longer in effect. It was inactive. But I went ahead and did it, and I know I added them onto that form. But then, you know, Anna did come back later saying, you're right, it is inactive, disregard that request. And I also just want to add that with that, I truly feel like I did every single thing they did, plus more. You know, they kind of added rules in the middle of the game, you know, get these signatures. I got those signatures. Now prove who those signatures are. Well, that was never a part of the process. I got the signature. You have the city parcel viewer that shows who owns these properties.
Thank you. Thank you, Ms. Brown.
They're also registered businesses in Kansas City. So I don't know why I had to then go prove that they own those properties neighboring me.
When you got your notice of denial May 24th, did you appeal that at that time or within 15 days?
No, because I was not aware that we had the rights to do that.
Right. Okay. Thank you. Board members have any other questions of the applicant or Ms. Duma?
On docket number 1.7, case number 2023-71, I move that the board deny the appeal.
I have a motion. Do I have a second?
Second.
Call the roll.
Lawrence.
Aye.
Moran.
Aye.
Mixed-Art.
Aye.
Wright.
Aye.
Ebbets.
Aye. Ms. Brown, since you're on the next case, kind of stay where you are.
Okay.
We knew that you're still under oath.
This is docket item 1.8, case CD BZA 2023-00103 for 5028 North Topping Avenue. As a housekeeping matter, we're reestablishing the quorum with Ms. Wright, amending Exhibit 13, revising Exhibit 9, and adding Exhibits 15 through 18, as well as Exhibit 19, which includes cases 1.1 through 1.4 and 1.6 and 1.7.
Those are all admitted. Ms. Duman, do you want me to admit the testimony from the previous case for this case?
Yes, we'll incorporate.
That's so admitted. Thank you. Ms. Anna.
Not sharing my screen. As previously mentioned, the key facts for all of these cases apply also to docket item 1.8. It's a part of the BZA packet and available on Compass KC. The timeline in question for this particular property involves a zoning review application for a type 2 year-round STR that occurred on April 25th of 2023. The application passed QCR on May 2nd of 2023. And this application was filed a little bit later than the other one, because again, it's the other side of a duplex. We notified the property owner that if the intent is to rent out both as a short-term rental, then both addresses need an STR permit approval. After QCR is when full detailed review of the materials is done. That deadline would have occurred on the 24th of May. In preparation for these appeal cases, we reviewed the application again, and deficiencies, the following deficiencies were found: that the registration form still identifies both units, that the adjacent owner consent, similar to the previous case, we needed more information about the LLCs, as well as the mailed notice form that the application used did not have the updated date. Again, a refund was issued for this case. And similarly, the notification about why this case was closed was messaged through the review portal versus the IO, like the other happened with the other cases. It did include information about why the case was closed, but did not provide a statement 88575. Again, the error identified in this appeal application is that the notification was improper. It did not meet 8832104C. Our response to that is that all applications, STR applications that were pending on the date that the STR related ordinance was repealed were closed, aka the status was changed to denied. The message communicating that reason for denial of the case being closed did identify why. However, that statement from 88575 was not included. None of the reviews issued by our staff contain that statement. The board may sustain an appeal only if it finds that city staff have erred. They are plaintiffs in the larger lawsuit, and they were operating illegally without a permit, first listed in April of 2023. That concludes my overview for this address.
Thank you. Ms. Duma.
Just a correction, Ms. Brown's not a plaintiff anymore. We only have 3 plaintiffs in the new lawsuit. So Ms. Brown, the dates on this property are a little different, so let's talk about that. When did you convert the other side to a short-term rental?
I started in, I believe, August of 2022.
And when was it furnished and ready to go?
I had most of the items purchased within the first 3 months. So probably by October, November of 22, while I continued painting and fixing it post long-term tenant. I had a lot of repairs I had to do there. So I purchased a lot of the things pretty quickly, and then the rest of the time was spent repairing the property.
Between August and January, did you have any indication that the law was going to change, the short-term rental laws?
No,
Well, you submitted for reconsideration on these 2 properties to Mr. Rexwinkle, correct?
yes,
And just so you know what the terms for reconsideration was, they had to they unilaterally set the date of April 28th to reconsider. And then they had all of their documents notarized before May 5th, then they would reconsider the application. This is Harmony's case. She had her documents. She should have been approved for reconsideration. She submitted her initial application was April 17th of 2023. She had all of her documents notarized. There was confusion about the notary, and that's it. It should have been reconsidered with all the other cases that were reconsidered. At this point, I'm aware of 10 individuals that have this CPD has overturned in their reconsideration process. And Ms. Brown should have, her properties in both of these cases, 1.7, 1.8, both should have been reconsidered with the affidavits as new evidence.
well, and I did also receive QCR approval on both of them, which I was told that pretty much defines that all of my documents were correct and that they were ready to go on to the next the next stage of review. And then these deficiencies that are being mentioned are news to me. Those did not get mentioned until the last hearing in September. And they're minor administrative deficiencies that in the big scope of things, I don't think matter.
So again, just the reconsideration process, that is where you guys actually have power here, different than the other cases, okay? Because remember, they started doing reconsiderations. They talked to you about reconsiderations, and you've heard them say that they can reconsider under certain criteria. She meets the criteria. So this is not just we can't do it because city council, but there was this little caveat of reconsiderations. And I have 2 cases that I believe, actually 3 cases I believe really fall under this reconsideration caveat.
Can we get a definition from Anna of like what qualifies you for QCR approval?
We do a QCR to make sure that the minimum requirements are in terms of forms are provided. So I think the issue here is the form was provided, but it did not tell us the names of the people signing for the LLC were the authorized person to sign for that LLC. At least that was one of the issues on this one. I don't know if there was additional things. So we wouldn't know that until we get into a formal review.
Board members, further questions of the applicant or Ms. Duma?
Does staff have any more response to Ms. Duma's argument that this is the same as the other cases that were reconsidered?
Can you explain a little bit more your question?
She's arguing that there were 14 cases.
10 that I'm aware of that they have reconsidered and given permits to on their own accord without you guys getting involved.
And that this case met the same criteria.
Yeah, I mean, it was a complete application. All the forms were filed, at least for one of the 2 duplexes. And this has added confusion because there's 2 different applications in the unit or in the building. But the issue was that who's signing for which a lot of the properties are owned by corporations or they're not owned individually. So the individual signing, did they have authority to do that was really the question. And we've encountered that before, and they end up having to provide a supplementary document which we didn't, I don't think I think, well, we didn't get that before the May 4th. I'm looking to Anna because was reviewing this case.
The affidavits that were presented in this presentation were not attached to the original submission.
Right, and so the criteria that we used to reconsider was the application filed complete on or before May 4th? And then would we have been able to approve it? So one, was it complete? Yes, it was. We would not have been able to approve it at that time because we would have asked for the supplemental information.
And it's my understanding that she did give you guys Secretary of State documents that you did not accept. And so after she became my client, I said, great, they're reconsidering things. Go talk to these guys because the evidence is there. They had it and it was complete because the people that signed for the LLCs were the people. Proof of that is the affidavits. You didn't need the proof if it's already the truth when they signed it, which was before May 4th. She fits the reconsideration timeline.
Similar situation to the previous case in which denial was on the 24th and appeal was filed June 14th.
No one challenged her right to appeal. The city planning and development just went ahead and scheduled her for a full appeal on their own without bringing it to you guys first. So that's not an issue before you.
And Ms. Duma, in the previous case number 71, same situation. She had the application complete, except the signatures weren't part of the LLC, yes?
Yes.
The people that signed them, were they members of the LLC?
Single managing members. They just didn't put as the managing member of the LLC. And the affidavits that are in the slideshow represent that. And
To the extent it's helpful, part of the reason staff was not accepting signatures like that was because we have had, and I can't remember if there's been any appeals come before this board, but we have had, I think there has been, where people have claimed that their signatures were forged. And I think you actually did overturn a decision at one point on that basis. So that is, we were being very conservative and wanting to make sure that the person who signed their consent was the actual person that was authorized to do it.
Right.
These affidavits, were they part of the original application? Okay.
No.
It was not a known needed item. It was just it was added in at some point to my surprise.
It was something I told her to do to clear it up for them.
Right.
Because I thought we have the signatures, the evidence is preserved, it's done, game closed.
Right.
Show them so they can 100% know that who's signing is who's signing to alleviate any concerns about forgery. And so she did it because I told her to.
Mm-hmm.
I think kind of as Ms. Moran had stated previously, there's a lot of things with this process that maybe needs to be addressed, but I don't know that that is within our court to do so. So I would offer a motion.
Go ahead.
In case number 103, I move that we deny the applicant's request.
Second.
I have a motion by Ms. Mixdorf, a second by Ms. Moran. Anna, please call the roll.
Lawrence.
Aye.
Moran.
Aye.
Mixdorf.
Aye.
Wright.
Aye.
Ebbets.
Nay. Let's move on to the next case. Sorry.
Just as an FYI for the board, we recommend taking this case and then proceeding to lunch break. But again, it's up to the BZA's discretion for
Say
that.
one more time, Anna. I heard dismiss.
Address 1.9
Yep.
and then proceeding with lunch break.
Okay. All right.
Again, up to the board's discretion though.
All
That's just city staff's decision.
Okay.
Okay, so we have case case CD BZA 2023-00102. This is for 34 East 32nd Street. This is the other side to the duplex addressed in 1.2. City staff, we are recommending dismissal of this case as this address, the side to the duplex, has been approved for a type 2 seasonal permit. And underneath the new regulations for 56, this generates a non-resident permit in correspondence with staff who have the authority of chapter 56. They did confirm that this does transfer to a non-resident permit. So the appeal for the denied / closed type 2 year-round permit isn't necessary because they have approval to operate this as a non-resident STR permit.
And we're establishing the quorum again on Ebbets, Gorens, Mixdorf, Moran, and Wright.
If you choose to hear the full case.
Yes.
I will concede to a dismissal. Just to be clear, you're saying that anybody that had seasonal permits under the 2018 short-term rental ordinance are grandfathered in for long-term non-resident permits under the neighborhood services.
If you have an approved seasonal permit underneath chapter 88, when you go to renew your permit under chapter 56, chapter 56 doesn't make a distinction as chapter 88 does, and it will translate to a non-resident permit. I confirmed that with Matthew Keeney.
Just a reminder of all those people that got the seasonal permits that knew this. They didn't have to get neighborhood consent or do any of the things that my clients did, and now they're grandfathered in. They didn't have to jump through these hoops or stand before you, and they're grandfathered in. But we'll accept the dismissal from Ms. Wright on the side.
Yeah. And again, Ms. Duma, we don't write the code. So I hear, Ms. Newman, do you have a problem with us moving to dismiss this case?
No, I consent to dismissal.
Okay, thank you. Board members?
The docket item number 1.9, case number 2023-102, be dismissed.
A motion? Second, someone? Second, Mr. Gorens. Anna, please call the roll on this.
Aye. Moran?
Aye.
Hicksdorf? Aye. Wright? Aye. Ebbets?
Aye. So, Sandra, is it your intention that we take a half-hour break at this point? Somebody just got that. All right, let's do it. Be back at 12. 40.
20?
12:20, excuse me. 12:20. Thank you. What?
I see any of the extra.
Yeah.
12:25.
This is the right clock. You gotta look at the right clock. You need the thumbs up.
Yeah, you'll be fine. It's.
Good afternoon, everyone. We're going to start our afternoon session. We've got a few housekeeping issues before we start with case 1.10. One of those is after we hear a couple things. One of our board members is going to be leaving at 2:30. That means we'll be down to 4, so that makes a little bit of complication for those cases heard after 2:30. That means you've got to get all unanimous approvals. We're verifying with Mr. Gorens whether he will be leaving at 2:30.
Yeah.
I would like to move up one of the cases. This is docket number 11, docket or case number 38. After we hear the 1.1 series, let's go to that one again for a client issue. Not a client, but a customer issue out there. We're waiting for Mr. Gorens, and then we'll get started. Thanks.
So you're gonna go to 38 after the ones?
No, ma'am.
Oh, I'm sorry. I thought that's what you said.
No, it's case number 38. So we're gonna do all the ones, all yours, and then we're gonna jump for a quick to docket number 11 with a case number of 38 at 1108 Grand.
So to get my client back here, if
Yeah,
you were gonna
yeah.
go to 38.
Yes, yes, yes.
That I have. Ours. Yeah, he was supposed to go over the weekend, so we've been fighting on this. And that can be just. You know, out of perspective, I cover it. Yeah.
I didn't. Yeah, that's. I mean, they made it like 3 every on Tuesday. Yeah. Yes. I mean, I don't know what they do.
You are the main.
Anna, let's start with 1.10.
Okay. Case 1.10, this is, excuse me, docket item 1.10, case CD BZA 2023-00078. This is for 4817 North Fremont. An appeal related to a short-term rental application. As a housekeeping matter, as a reminder, we are reestablishing the quorum with Ms. Wright, amending Exhibit 13, adding Exhibits 15 through 19, revising Exhibit 9, and then also adding Exhibit 20, which is cases 1.1 through 1.4, 1.6 through 1.9.
Thank you. And we've established the quorum, right?
Yep.
We do that. Thank you very much.
If you want to swear in any additional testimony
Okay.
for that case before I proceed forward with my presentation.
I mean, I have an argument, but I think you go first, right?
Yeah, is the property owner going to speak on this one?
He's not, he's active duty military overseas serving our country.
Okay. Anna, tell us about the case today.
The key facts applicable to all of these companion cases still apply. So I won't go into every single item, but as a reminder, this document is within your BZA packets and available on Compass Casey. One second. Now my screen is frozen. Sorry for the technical difficulties, as always. Okay. The timeline associated with 4817 North Fremont Avenue. This is a request for a type 2 year-round short-term rental permit. The application for that zoning review came in on March 5th of 2023. A QCR was performed and the review was not initiated. However, the ordinance was related to short-term rentals that was repealed in May 5th, 2023. As a matter of preparing for these appeals, we reviewed all of the applications. The deficiency within this particular application is that there was inadequate adjacent owner consent. So specifically, only one of 5 signatures that are required were obtained. Some key points for this item. The error identified in the appeal application is that the correct notification for this matter was not appropriate according to 88-321-04C. Our response is that STR applications that were pending on the date that the STR ordinance was repealed were closed, aka the status changed to denied. The messaging communicated for that reason for the denial, the closing, did identify the ordinance change. It did not include a statement from 88-575, and this notification of why the case was closed was through the review mechanism, not the same kind of IO that was sent with the other applications, and the review did not include the statement from 88-575. As none of the reviews that our city staff process from DMD's perspective contains this message. The board may sustain an appeal only if it finds that city staff erred and the STR was operating illegally without a permit. It was first listed in December of 2022, where it identifies that it is renting out the entire home, and there is written opposition from neighboring property owners attached to this case file. That concludes my presentation.
Thank you.
Calling out mine.
Mr.
I'm just pulling up my,
Estima?
so I lost her. I'm going to start with objecting to the introduction of any neighborhood opposition. It's hearsay and it's not an affidavit form in violation of the BZA rules. You should please disregard it. It's my objection. I also am going to submit because Mr. Justin Sanchez is active duty military, and he purchased this home in August of 2022. I have long ago submitted his affidavit, but I can resend it to you so you have it for the as an exhibit in addition to what's on the slide. Because he can't be here, I have his sworn affidavit iterating the facts that I'm summarizing here.
Okay, that will be admitted.
And so he purchased the home in August of 2022. Very quickly thereafter, he does very high level intelligence work for our country, and he was deployed to Somalia. And when he realized that he was going to be deployed, they realized they couldn't keep this home in Kansas City. As opposed to selling it, he was going to rent it out to support his family, pay the mortgage as a short-term rental. So in August, he started to convert it. He opened it as a short-term rental in December of 2022. As a reminder, none of the audit or city information with respect to the laws changing happened until after December, and the first public hearing wasn't until April of 2023. So he had made a substantial investment. In his affidavit, it lays out all the expenses that he went to in reasonable reliance that he could operate a short-term rental. With respect to his application, he was not even denied. They just deleted him out of the system, as they just told you. And so he applied on March 5th. He definitely could have remedied these errors. Because he is active duty military, I personally went to his home, talked to his neighbors, and got the required signatures once he became my client. It's the only client I did it for, but I thought he deserved that. So I submitted that as an exhibit to his legal brief, which is part of the record. You'll see he does have a complete application. No, it wasn't done before all the signatures weren't achieved and notarized before May 4th. But the only reason that is because city staff did not get back to him and deleted his application from the system with zero communication thus far, all in his affidavit. That's pretty much all I need to say about him.
All right. And Ms. Newman, once he got his denial, did he try to appeal it at that point, or do you know?
I don't think he ever received a formal denial because they voided him from the system. And so he did appeal. They initially said it was out of time, but somebody at CPD, not bringing it to you guys, reversed it, unlike the testimony we heard earlier, and allowed this appeal. And so we're here.
All right. Board members, questions, comments?
Can staff address Ms. Dumas saying that his application was deleted from the system?
Yeah, so when the ordinance changed, before, as city staff, we had an understanding or an agreement of how to close out the cases. I, in error, voided the case instead of leaving it as the denied status. Cases that are denied or are voided with the plan status of voided, they are removed from Parcel Viewer, which is the mapping software, as a mechanism to declutter the cases viewable from the mapping perspective. The case is still available on the public record side on Compass KC. And the review that was failed did inform the property owner of the ordinance change, which is why the case was closed. And this case changed to voided instead of denied like the rest of them.
She just said she erred. As the BZA, it's your guys' job to correct errors. She used the language, please, for Mr. Sanchez, for our United States military active duty client, please approve his short-term rental permit.
Does that error distinguish this case from the other cases? I'm asking staff.
What's the question?
Does the error that you made in closing this or deleting this, does that distinguish this case from the other cases we're hearing?
She did that She changed it to voided instead of denied. And what we did later, a few days after she did this, was we did through our IT department a mass change to everyone else. So it didn't capture this person because she had already changed it to voided. So it doesn't, she just used a different status. And that's what she means by the error. She is a day or two later, we decided the status ought to be denied because we had to pick a status. And that's what we switched it. And part of the reason we picked denied is because it removes, if you change it to void, it removes it from parcel viewer. So it appears as though the record to anyone who's not a contact, and Ms. Duma is not a contact on his application, it appears the record's gone, but it's not. It's there for Mr. Sanchez to see. If he were to log into Compass, he would be able to see it.
There is the technology issue, but the materials submitted with that original application still do not meet the 2018 STR ordinance.
So this wouldn't have, the error wouldn't have prevented him from following through and completing his application, and is that what you're saying?
It's the same as the other cases in that it didn't meet the 2018 ordinance, and we couldn't go back and reconsider it either. The error that she was referencing was just that she used a different status when she was closing the case. She chose voided instead of denied.
And it was voided after May 5th.
Yes.
Mr. Rexwinkle, there were cases that were in the hopper, so to speak, after May 18th that were approved, as I understand.
No, after the first board hearing on these appeals, we went back and I don't know if you recall this when Ms. Binkley was there. We went back after that hearing and decided to reconsider all those who had a complete application on or before the date the ordinance was repealed.
I see.
So that's what we did. And we have approved all the ones that met the ordinance.
Right.
At that time.
That's not exactly correct. The first case we heard, Mr. Kennedy, he had everything in place, just he submitted it on May 2nd, not their non-codified arbitrary date of April 28th. Just so you know.
Your response to that one?
Yeah, there is a code provision that sets forth the amount of time that we have to get back to a customer on a quality control review. It doesn't use the word quality control review, but it does say within 5 business days, I believe, we must identify deficiencies that prevent us from moving forward in formal review.
Right.
So that's where we're backing up 5 business days prior to May 4th. That's where we get April 28th.
Do you have a site for that code for the record?
I can find it.
Mr. Chair, I have a question for.
Sure.
Mrs. Duarn. My normal question is, who's gonna manage his property?
Actually, another one of our clients who you'll hear next from, he has one of the largest short-term rental management companies, and he personally handles everything. There was an issue, as I talked to the neighbors, with the trash not getting picked up a couple of days. And so we fired the trash company. I did it unilaterally, just telling Justin what I did later, because I was there in the trenches. And that was the one issue that the neighbors had. And so I fired the people that were doing the trash and hired Tyler Shirks people who has Airbnb short-term rentals. He's got a team of about 6 people that are based out of Raytown, but are all over the place, and he's managed.
So there's somebody there to listen to the neighborhood complaints.
Yeah, I think those will be a non-issue now after my visits with the neighbors.
And Board Member Corns, you have to speak into the microphone.
Sorry. Okay, I'm done.
I have that code section. It's 88, should put my glasses on. 88-505-05-B states the official responsible for accepting the application must make a determination of completeness within 5 working days of application filing.
It's your testimony that he, Mr. Sanchez, or his representative, turned in things for May 2nd. Is that what I hear you say?
Not Mr. Kennedy, the 1.1, he had everything submitted as of May 2nd.
Right.
And
Of course, the ordinance changed.
May 4th.
Yeah.
That's why the record's just kind of entangled with these different cases. They all touch other facts. That's why we need the record to reflect all the cases.
Board members, further questions or comments and or motion?
Well, if staff doesn't believe there's a way to distinguish this case, then I move that docket item number 1.10, case number 2023-78, be denied.
I have a motion. Do I have a second?
Second.
Anna?
Corrance,
Hey.
Moran,
Aye.
Mixdorf,
Aye.
Wright,
Aye.
Ebbets.
Nay. That means 3-2.
You too.
And I think we only need 3 votes to deny, right?
The appeal.
You need 4 to reverse, so,
Right, but 3 to
yeah, if you don't have
uphold
that.
it. So,
yeah.
yeah, I think the 3 votes are there to uphold it.
All right. All right. Didn't make it.
Docket item 1.11, this is case CD BZA 2023-00083 for 3938 Forest Avenue. This is an appeal related to a short-term rental application. Housekeeping matters include reestablishing the quorum with Ms. Wright, amending Exhibit 13, revising Exhibit 9, adding Exhibits 15 through 18, as well as Exhibit 19, which includes cases 1.1 through 1.4 and 1.6 through 1.10.
Those are admitted for this case. Anna, tell us a little bit about it
We're doing a
when you're ready.
swear in the property owner.
Oh, yeah, I'm sorry. Sir, raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Please identify yourself with the court reporter.
Matthew Rich.
Thank you, Mr. Rich. Anna, when you're ready.
The key facts applicable to all items in docket item number 1 still apply to
Oh, no,
docket
I'm gonna
item.
pause you for a second. We're not seeing that on both screens. I think the other presentation is still above it.
Sorry.
I see what I have to do now.
There we go.
Apply to docket item 1.11. As a reminder, this information is within the packets and on Compass Casey. The timeline associated with this property is that the property owner filed for the type 2 year-round STR zoning review on April 28th. And a QCR was initiated, and the deadline to complete that QCR was May 5th. That is the exact same date that the ordinance related to the STR STR cases applications was repealed. And then the notification that the case had been closed was sent out on May 31st. As a matter of preparing for these appeals, we reviewed all cases. And the deficiencies found in this application was that there was no adjacent owner consent provided in that original application. So it does not comply. It does not comply with the 2018 STR ordinances. Here are some screenshots of the correspondence sent out, the IOs for Compass KC. It does talk about the reason for the denial, but it does not include information from 88575. The key points associated with this property includes that the error identified in the appeal application was that the notification did not meet 88.32104C. Our response to that is that all STR applications that were pending at the time that the STR provisions were repealed were closed, aka changed to denied. The messaging included in that denial did identify why the change occurred, but did not include the statement from 88.575. And you see a slightly different date for this one, and that is because the IT department sent out a few, and then the next day not the next day, but then what's the right word? When cases sometimes sync, when I apologize. There's a correct technology term for when something is updated within 24 hours in a technology system, but then the additional notices were sent on the 31st, which is why you see the two different dates for this case. The board may sustain an appeal only if it finds that staff have and the STR at this property was operating illegally without a permit. It was first listed in April of 2023. That concludes my overview. I apologize for not knowing the correct word.
If I could just add one thing. This was one of the cases we reconsidered. And the distinction here is there are sufficient number of signatures. You have to have signatures from the owners of 55% of adjacent properties. The reason I did not approve it was because I could not verify to my own level of comfort one of the signatures. So that's really what this is about. If the board thinks Mr. Rich did have a signatures collected prior to May 4th. When he provided those, he did not upload those for some reason, whatever reason. But when he provided them to me upon reconsideration, they were notarized prior to that May 4th date. So we accepted them. It's just one of the signatures, the key one, the one you need to push you over 55% is signed by two individuals, and I wasn't comfortable approving it. So really, this could be an interpretation thing on the board's part.
Understood. Thank you, Mr. Rex Winkle, for that clarification. Ms. Duma?
May I approach to show you guys what these signatures look like that caused the confusion?
Sure. And we will admit this as part of your.
It's already Exhibit C to his legal brief. Yes.
Okay, thank you.
Signature there by the mother and the signature there by the father. Okay? Or the son. Mother and then signature son. This is signature son. And you can read the picture.
Of course, they're notarized. Yep.
No, yeah, well, it's notarized that he got his signatures.
Yes. Okay.
What was the question about the signatures?
Mr. Rex Winkle?
That one of the two that signed was the owner, but not both of them, I believe. One was off memory, and I'm trying to remember my conversation with him about that. Let me pull it up.
There were two owners, but only one of them signed, or one of the people who signed wasn't?
Right.
But he lives there as a tenant. So this, again, I put him first initially when I was ordering the cases because this was a slam dunk. Like, there's no confusion. Just because they signed right next to each other, that gives them the right to rob him of $300,000 of investment of his time and money.
So you had an extra signature on it?
An additional signature of a tenant. More evidence. But I want to talk with Mr. Rich about when he made his investment, his substantial conversion. So Matt, when did you buy the property?
I bought it in October of
The microphone, please.
October of 22,
October of what?
2022,
And why did you purchase the property?
for the sole purpose of short-term rental.
What kind of work did you put into it?
Well, the previous investor that owned it had long-term tenants in there and they tore it up. It was cosmetically nearly unlivable, and I put approximately $100,000 into it after furnishings.
When was it business ready to be a short-term rental?
Approximately the middle of April,
And when did you apply for your permit?
very shortly after I received my signatures from my neighbors.
Does April 28th sound right?
Yeah.
So he meets the reconsideration timeline under even their standards. And did the city staff, anybody from CPD tell you there was anything wrong with your application at that time?
No, not at that time.
So what happened?
It was denied and then later reviewed, and then Mr. Rexman and I talked about it after that.
Mr. Reg, you didn't, I couldn't hear that, sir. Say that again.
My original denial didn't have a reasoning on it, and then it was reviewed again, and then that's when the conversation between Mr. Rexman and I happened.
And about when was that conversation about? Yuma?
Oh, I have, it's part of the exhibit. So they spoke in August. They spoke in August about the
I-
reconsideration.
Thank you.
And that's an exhibit to his legal brief.
All right.
And so again, I just showed you what the confusion was. That shouldn't have been confusion at all. Now what we also have as exhibits to submit that they're on the slideshow, but I can bring them to you as well, are the affidavits from the from the mother and the son attesting that those actually are their signatures. Not required. Their dates don't matter. It was just to try to convince Joe to do the right thing.
Right.
He erred in making that judgment call. I have evidence that he did. Please, for Mr. Rich, reverse the decision and grant him his 2018 STR permit.
Board members, questions?
Question, when you first purchased this property, was it for a short time or was it for,
My goal was to turn it into a short-term rental.
it was?
Yes, that was my goal. That was the
How
reason.
many
why.
units?
What's that?
How many units was it gonna be?
This property is just a single-family home.
Single family, okay.
Yes.
And the issue is just when you can't, as you probably know, we've been in the weeds on all of these. When someone signs something, if you don't know who they are and what their signature looks like, and there's just one person signing it, you can accept that that's the one person that is the owner of record. When there's just one person who's the owner of record and two people have signed it, it creates that's where the confusion comes in for us. And again, given all the allegations of forged signatures, I thought it was best for the board to decide whether, when everyone's under oath.
All right, thank you.
I had submitted exhibits previously in the golden ticket holders cases where there were tenants that signed with just a first name like Lucy.
Don't bring that up.
I'm saying when they're reviewing these signatures, those are clear. It's even written son of the owner.
Right.
Please.
I remember reading the golden ticket and hearing about it. Thank you.
Mr. Chairman, it does seem like we've found one that we can distinguish.
I believe
Um,
you're right.
So I move in docket number 1.11, case number 2023-83, that we uphold the appeal and reverse the decision of the staff.
I have a motion from Ms. Moran and a second from Mr. Gorens. Anna, please call the roll.
Gorens,
Yes.
Moran.
Aye.
Mixdorf.
Aye.
Right.
Aye.
And Ebbets.
Aye. Lexer.
Thank you. Thank you very much.
Congratulations. We got one. Have a great day.
Okay, we've got docket item 1.12. This is case CD BZA 2023-00073 for 720 Main Street, Unit 203. And this is a appeal related to a short-term rental application. More housekeeping matters. We are reestablishing the quorum with Ms. Wright, amending Exhibit 13, adding Exhibits 15 through 17, revising Exhibit 9, and adding Exhibit 18, which is cases 1.1 through 1.4 and 1.6 through 1.11 as in this docket.
Those are admitted. We have someone. Do we have Tyler in the audience?
I'm not sure. I don't necessarily need him, but Tyler, are you online?
Tyler Shirk?
Let's see. Anyone by that name?
Nope.
Sorry, I don't see anyone by that name.
Okay,
I can proceed without him.
okay. All right, Anna, please tell us about this case.
Just waiting for the PowerPoint to load. There we go. The key facts associated with docket item 1.12 are the same with the rest of docket item number 1. As a reminder, this document is attached to the BZA packets and available on Compass KC. The timeline associated with this property includes an STR permit application submitted on 4/20, which would have resulted in a QCR deadline of 4/27. The ordinance changed in May, on May 5th, 2023. And then the case was closed on May 31st. Deficiencies in the application include no registration form and no property owner consent. So the materials submitted at the time of application are not compatible with the 2018 STR ordinance. The language submitted in the IO to notify the property owner, the permit applicant, because it's an apartment complex, the STR permit applicant does include information about why the case was closed, but does not include information from 88-575. More key points. The error identified in the application is that the notification did not meet 88-321-04C. Our response to that is that applications that were pending on the date that the STR related ordinances were repealed were closed, aka the plan status was changed to denied. The messaging did communicate why that denial / case close happened. It did not include the statement from 88-575, as none of our IOs do this. The board may sustain an appeal only if it finds that city staff have erred and the applicant has multiple listings in this apartment building. So we assume that this particular appeal is attached to unit 203 and prior all of the STRs were operating illegally without a permit. That concludes my brief presentation on this matter.
All right, thank you. Ms. Duma?
On my slide, just pulling up my slideshow here. Okay, the two problems with this.
And can you share your screen? Thank you.
Share.
You need to go through Zoom to do so.
Okay.
Perfect.
Okay, Mr. Shirk leased this property in the fall of 2022 to convert it to a short-term rental. Now, what's interesting about this property is there was no requirement that you have to have owner consent because of the way it was zoned. Here's why. Let's look at how it's zoned. And this is from KC Parcel Viewer. Look, the zoning for 720 Main Street. You can barely see it, but zoned UR. Okay. And to the right here is the 2018 short-term rental code with respect to properties that are zoned UR. You'll see that listed in the middle of the ARBD UR. There are no approval requirements, but registration of the short-term rental unit with the City Planning and Development Director and issuance of a short-term rental permit with annual renewal is required. He submitted the form application on Compass KC, and that should have been it. He should have just been, and he did it before the deadline. So this is another one where they're requiring something that the law doesn't require, which is an error.
Thank you. Comments by staff?
The owner verification that she's referencing is for the owner of the property where the short-term rental is. This is a rental community. And so in order to apply, anytime someone who's not the property owner, when they apply for anything with our department, we require consent from the property owner that acknowledges someone's applying for something on the property. That's what, this is not the adjacent owner consent. That is true. That is not required in this location because of the zoning.
So the property owner being Flash Cube or whoever owns 720 Main Street, or the unit that's in question?
The person who owns the building, it's a rental building. It's the Flash Cube building. So I don't know the exact name of the owner, but
I'm familiar with that.
And Mr. Rexwinkle, is that in code or is that an internal requirement?
I can look. I know we, as a matter of practice, we always require it.
I believe it's required for registration. Yeah, I believe it's in code for residential properties, but not for this particular group.
Not, it might be a legal question whether we even have the right to take action without the owner's consent on anything, but let me see if there's anything in the code that says that. It'll take a while.
Did I hear correctly that this applicant has other units, short-term rental units in the same building that are permitted?
They are not permitted.
They're not permitted. Okay.
He did. They are all winding down after this. Like they're in the process of winding down. Part of all of the legal briefs, the exhibit A is the relevant portions of the 2018 SDR ordinance. In a quick read, I couldn't find what we're referring to, but if you guys wanted to take this one under submission to see if it's there. If it's there, I would concede. But if there is a requirement, subject to my other arguments, that he's substantially invested in reasonable reliance, but I don't want to waste more of your time than is necessary, but I don't believe that requirement to have the owner sign applies to UR as the way it's written. Might be written bad, but I'm having to deal with a lot of that today.
Well, I think staff is probably saying, the city has always required owner consent for anything the BZA is gonna do that's gonna impact the property. Like if we're gonna grant a variance and that's permanent, we've got to get owner consent. I don't know how but this is just a registration.
And he signed a
Sorry.
lease, and the lease specifically says it's for a short-term rental. Like, so he manages it and takes care of it, and she's guaranteed her rent every month. And then he tries to make a little extra on short-term rental. That's how it works. So she knew and knows she's lost a lot of revenue lately.
Yeah, I guess what I'm saying is I understand why staff would have required that, but if it's just a registration, it can be canceled because it's a permit.
And I have clarification on the registration requirements. According to 88-321-04D, which is other requirements for all short-term rental hosts. And this is permit phase, zoning review phase. The first item in that section of code says that a notarized affidavit from the owner of record of the property or unit consenting to the short-term rental, shall be with that application.
Concede that was a requirement then. Thank you. And I apologize for not being more prepared. The consent was sent to them for reconsideration, but it wasn't notarized until June 20th of 2023.
Any other questions? Motion?
Docket item number 1.12, case number 2023-73. I move that we deny the applicant's appeal.
I have a motion. Do I have a second?
Second.
Thank you, Ms. Mixdorf. Anna, please call the roll.
Gorance,
Aye.
Moran,
Aye.
Mixdorf,
Aye.
Wright,
Aye.
Ebbets.
Aye.
Okay, and to conclude docket item number 1, we have docket number 1.13. This is case CD BZA 2023-00075 for 601 Northeast Woodland Avenue. This is an appeal related to a short-term rental application. More reminders for housekeeping matters. We are reestablishing the quorum with Ms. Wright, admitting exhibits 1 through 16, revising exhibit 9, and then adding exhibit 17 for cases 1.1 through 1.4 and 1.6 through 1.12.
Those are admitted. Thank you. And when you're ready, Anna.
Swear in the property owner.
Oh, yeah. I'm sorry. I didn't see him up there. Sorry. I apologize. Sir, raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Please state your name for the court reporter.
Starin.
Say it again.
Cole Starin.
Thank you very much, Mr. Stan. There. All right. Anna?
The key facts applicable to this docket number, similar to the rest of docket item number 1, apply. As a reminder, this item is attached to the BZA packet and available on Compass Casey. The timeline associated with this particular property includes the application for the STR for the zoning review portion to be submitted on April 19th of 2023. The QCR was, the deadline was April 26th. And which would have put that next for them to address these identified and reapply. That would have occurred after the ordinance changed for the short-term rentals, which was on the 5th. The applicant did re-upload documents to address those deficiencies identified in the QCR, but again, like I said, that occurred after the ordinance changed. The deficiencies include insufficient adjacent owner consent, with note that there was false claims made on behalf of the housing authority by the property owner. And then the case was closed on the 31st. And to cite the code again, that it specifically states that the property owner of record is who needs to sign when it comes to that 55% rule for adjacent owner consent for short-term rental. Here's a visual representation of what those required signatures would have been. And the application material submitted originally only include 2, again, with false claims that the housing authority provided their consent. The notification, the IO that went out when the case was closed, again, identified the change, did not include a statement about 88,575. Key points again that the error identified in the appeal application is that the notification was inaccurate in regards to 88.321.04C. Our response to that is that all STR applications that were pending at the time that the STR provisions were repealed were closed, aka the plan status changed to denied. The messaging communicating that reason for the case to be closed was identified, and a potential path forward underneath the new regulations. However, it did not include that statement about the right to appeal listed in 88.575. Again, none of the IOs from Compass Casey do this. And the board may sustain an appeal only if it finds that city staff have erred and the STR was operating illegally without a permit first listed in 2022. That concludes my overview.
Thank you, Anna.
I would start just with a brief cross-examination of Ms. Nanowski. You mentioned there were some false claims that my client had authority from the housing. Can you provide documentation evidence of that, please?
Yeah, I can pull that up for the board. So this document was uploaded May 9th of 2023. Oh, I'm not sharing my screen. So sorry. As we can see, I clicked on this file right here at the top, uploaded May 9th of 2023. It opened up this document, which is a blank unnotarized document submitted by the property owner, which says that the property owners are the housing authority and that this piece of document should act as the housing authority's consent.
Can the board just take a minute and read that, please? Can you explain why you wrote that?
So I also have long-term rentals and I work quite frequently with the housing authority because I do give back as a small business owner in Kansas City. My business is predominantly the revitalization of property in Kansas City. I give a lot of time, a lot of sacrifices, a lot of my money to fixing up properties in Kansas City. So I have housing authority people from, tenants from the housing authority that I home currently. Now dealing with them, even that process is very complicated. Going into their location off the Paseo, their offices, it's not ordinary for people to be very confused on how to process, whether it be their applicants for housing or what it may be, which I don't blame them. It's a tough job. For something like this application, in my opinion, should serve as a request for a permit, just like I get a lot of other permits for when, renovations, whatever it may be. I'm not saying or claiming that this is to serve as their permission. I'm making a statement that my application as a whole, from my understanding from what's out there, because there's nothing dealing with my unique situation of the housing authority owning 3 adjacent properties to my home and other adjacent neighbors. There's nothing out there with the short-term rental process for applying that says anything about dealing with the housing authority. There's no information out there. So my application in particular is unique in that the housing authority owns basically a whole street next to my home.
And let me just share our short presentation quickly. I'm going to get through substantial investment and conversion and reasonable reliance really quickly. When did you buy the home?
I purchased the home off a foreclosure sale in January of 2022.
And why did you buy it?
So I had, again, back to kind of telling you a little bit about my business. This was actually to rehab and resell initially. And then again, I do have long-term rentals. So that was thought process was taken. But again, in my industry, we can, consider various exit strategies. For this particular property, it ended up going down the road of the short-term rental to, at the time, get my fiance other opportunities outside of her nursing career to help me with day-to-day, because again, I do take on a lot in my role, which again, small business owner, I'm pretty much doing everything. So this became an opportunity for her to reduce, days where she had to go in the office when she's now pregnant. We're expecting. That's besides the point. So that was
So
kind of the
when
point.
was this property ready to be a short-term rental?
So this property would have been ready for sale initially was the thought in April of 2022.
When was it a short-term rental?
So then it became a short-term rental, I want to say May of 2022.
And why is it reasonable with given that timeline that why did you reasonably rely that the law was not going to change?
So the voters were given, issued the
Option to vote on.
the little deal, there basically it was put out, a survey was put out to the actual taxpayers on their thoughts of short-term rentals in Kansas City. And I believe that was in December of 2022. And I mean, if you read that, that's out there, public knowledge. The overwhelming results of that is it's pretty indifferent. I mean, people admitted that, hey, when I travel, you know, I stay at Airbnbs. Then taxpayers then voted for an increase in the lodging tax applied and the taxes and fees. Great thing. Again, I'm a business owner. Taxes are good for our city. They're good for our communities. It was then shortly right after that, that this, you know, was essentially a ban. And this is kind of where we're at. So
Just to cover briefly the legal topic. So can you see my screen? Yes. Okay, good. This is his property. And this right here is a vacant lot. There are emails from Justin Smith that are exhibits to his legal brief that state that a lot itself is not residential in nature as required by the 2018 ordinance, so those don't count. The issue with the other two of the KCMO Housing Authority is that it's owned essentially by the government. And so how do you get a government agency to give you permission to short-term rent? It's impossible. So therefore, under like using common sense, you'd think that they at least would just abstain from those votes even counting. So that's why Mr. Starin had these adjacent owners. So if we don't count these 3 properties here, he had 2 out of 3.
I have 3.
And now he has 3. But when he applied before the arbitrary cutoff date, and then the actual law changing, he had what was required. There's also emails from Justin Smith stating that properties owned by the city, like schools or churches, schools or things like that, they didn't count those towards adjacent neighbor signatures. And so there's no case law actually on this particular issue, as you can imagine. It's very nuanced. But from a common sense standpoint, he couldn't even have gone to these people and gotten the tenant signatures. That wouldn't have sufficed for the law. And he can't get the Kansas City, Missouri housing because he tried to reach out to them and there was no one to get a hold of. That's what his letter was saying. It was grossly misrepresented, saying that he lied. He's like a solid guy as they come. And so what he submitted before was 2 of 3 neighbors that should have counted. And that is the error. And we're asking the BZA to correct that error and issue him his 2018 short-term rental permit.
I can't remember. I want to say the executive director of the Housing Authority, I think his last name's Loundis or Londis.
Yeah.
Londis. Yeah. Did you try to reach out to him? Mr. Starin?
I don't know who that is.
He's the executive director of the Housing Authority of Kansas City, Missouri.
Okay.
And he's also got a board of directors that works under him. Ms. Wright is familiar with with those people. I'm just one board member. I don't think you pursued it hard enough.
I just had a question as far as the Housing Authority being a government agency. It's separate from the City of Kansas City, Missouri, correct?
Okay. That is correct.
So it still would be a required signature.
That is correct.
Could we have staff explain, do you exclude any government-owned property from calculations, and why is that? Is that in the code or?
No, we've, to my knowledge, I know of an example where there was city-owned property and we said they had to get consent from someone. I couldn't give it, of course. So yeah, there's nothing in the ordinance that says, it just says consent from 55% of adjacent property owners. exclude certain kinds of property owners or anything like that.
It does say residential property owners. So
Residentially zoned property.
but again, what is the point to tell your neighbors, hey, I'm a short-term rental. Do you approve me or not? Not to tell grass.
Board members, any other for comments or questions? So, Ms. Duma, excuse me, I'm sorry, the subject property, Mr. 601, did he give Starley's and Robertson's and the one across the street, Edmondson?
Yes, and I have it here as an exhibit to his legal brief if you'd like to see those signatures.
No, but it was on the application. I didn't.
Not the initial application. The initial application, who'd you have? Two of three.
So I had the Stanleys, and then I had the Edmondsons.
Okay.
The neighboring property actually changed hands. The gentleman that had lived there had been in hospice, I believe, since like when I first bought the property that was vacant property. So as soon as that, and you guys could find it on Compass, the deed changed hands, I believe in June or July. And I immediately talked to them at that time.
This year.
Yes, correct.
Or 2023. So.
But yes, I do have consent of the actual adjacent property owners.
The initial application, you only had two in the initial application. Yes,
that's correct.
Because the guy was in hospice and he wasn't at his house, he couldn't find him.
It was
Then he died.
Yeah, it was in a trust, I believe. I won't speak to that, nor my attorney or anything. I don't want to get it. That's none of my business. I just know that he was in the hospital for an extended period. It was in some legal agreement.
that's fine.
Yeah, so yeah.
Ladies and gentlemen.
I guess the question is, should the housing authority count? It would be very difficult. I know you know a lot of people, but it'd be very difficult for somebody who's not as well connected to go to a board, figure out who those people are, and then try to get someone to agree to sign. And they're not going to want to do that. You know, they're going to say no. So I don't think that these public entity properties should count. And I think that that's kind of the way that we treated other things like schools and big multi-use properties. That's the way city planning and development treated those adjacent neighbors. So in this case, he's on a corner, he does have his neighbor's consent. And at the time that we're looking back, that we're allowed to look back at per your other decisions, he would have had 2 of 3 if we cancel out, the lot's canceled out, if we just cancel out the 2 that have homes on them.
I leave it to my fellow board members for a motion.
Yeah, it doesn't sound like there's the authority to cancel those out, though, is what we're hearing from staff.
And I don't want to be difficult. So I respect your guys' decision. Again, I also deal with, the housing authority, happy to do so, give back. But this is kind of contradictory. And I'll say that because they can put anyone in those houses without mine or any of these adjacent property owners' permission. So the fact that I have to call and nail to figure out even who to go to, which I have, which I appreciate your opinion, but yet I have tried. They don't know. It's like they never heard of short-term rentals or even know things happen so fast, right? But this is kind of contradicting because for me to basically still need this, but then, people coming in and out of there, I have no idea who they are. There's no permission or anything like that. Matter of fact, Kansas City Housing Authority buys properties all over the city without any knowledge of it. I know it's for the greater good and I respect that. But, again, I think all of this, and you can tell me if you disagree, but this whole new ordinance was to protect the communities. It was to do away with what I believe was the 1% of issues. Now there were issues. I can, not with my stuff, but I know it was out there. But again, this is kind of the same thing, what if my fiance, my new baby were living in this house? No idea what the background checks, who was moving there. I don't know. And I didn't have to give permission or consent. So why am I being put in that scenario?
And
Thank you, Mr. Stern.
Joe did testify that even sometimes the city of Kansas City, Missouri, would require signatures. And he did just testify that even he didn't know who would sign for Kansas City, Missouri, and that he couldn't. So, and he's the leader of this whole deal. That's why they're wrong. That's why these shouldn't count. Please, let's just go 2 out of 3 and end on a high note, and then I'm out of here.
I appreciate your argument, but I'm gonna move to deny the appeal and docket number 1.13, case number 2023 F75.
I have a motion. Do I have a second from someone?
Second.
Second from Ms. Mixdorf. Anna?
Corrance. Moran. Mixdorf. Wright. And Ebbets.
Aye.
Thank you for your time.
Thank you. The end of our STRs at this moment. I'd like to push up docket number 1138 with an address of 1108 Grand for extenuating circumstances. Thank you, Ms. Duma, for all your testimony.
You're welcome.
Yeah, we're jumping to number 11, Tom. Just this one. The address is 1108 Grand.
Okay. You're welcome. Thank you.
Yeah.
Where's Anna? Oh, there she is.
There I am. Doing all the things. Okay, now we're focusing on docket item number 11. This is case CD SCP 2023-00038. The property in question, 1108 Grand Boulevard. This is a request to approve a special use permit for a hotel along the boulevard on about 0.125 acres, generally located at 1108 Grand Boulevard. The applicant and the development team are with up front today. The standard exhibits 1 through 9 apply to this case.
Thank you. I'm going to swear both of you or everyone in. Raise your right hand, please. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today? Please state your name. Either I do or I don't.
My name is Jay Simon and I
do?
I do.
Good. Thank you, Mr. Simon.
Doug Stone with Lewis Rice. I do.
Thank you, Mr. Stone. All right. As part of your case today, there are exhibits labeled 1 to 9. Do you have a problem with those, us admitting those to hear your case today?
No.
One of those is a presentation by Anna on your case. Anna, please take it over.
Thank you. As previously mentioned, we're focusing on CD SCP 2023-00038, property in question, 1108 Grand Boulevard. The site is currently zoned DC-15. This is a downtown zoning district, and the applicant is seeking approval of a special use permit to redevelop an existing structure into a hotel along Boulevard. The site in question is located within the Central Business District of Kansas City, Missouri. In fact, it is actually only a couple blocks away from City Hall. Here is a close-up of the subject site. We see City Hall where my cursor is, and then the property in question highlighted in yellow along Grand Boulevard, and then a closer look up on the left. Then an existing structure. This is a site plan provided by the applicant. Again, very straightforward because they are renovating a historic building into a hotel. There's going to be around 35 hotel rooms. This is a image of the existing facade and then a rendering of what when they remodel, what the facade could look like. The approval criteria for a special use permit is listed on the screen. I'm not going to go into every single item, but two factors that I believe support city staff and the City Planning Commission's recommendation of approval subject to conditions. The first review criteria being C, which is this compatible with the character of the surrounding area in terms of site planning, building scale, project design, and from a planning perspective, redevelopment of an existing structure, especially one that has historical context that's registered on the National Register of Historic Places, is a good thing. As well as review criteria D, which talks about is the compatible character of the surrounding area for this particular use, operational characteristics. So consider hours of operation, lighting, noise, traffic generation. Is that compatible with the proposal? And hotels are very appropriate for a high traffic area, high activity areas. We see lots of hotels downtown. This is near, the Sprint Stadium, excuse me. It's T-Mobile now, and other, event venues and entertainment districts like Power and Light. So a hotel here is appropriate. There is a variance request associated with the special use permit. It's involving the spillover light along the front property line, as described in the outdoor plan in the staff report. So the code's 88-430-05. It dictates that spillover light may not exceed 1 foot candle onto public rights of way measured at the grade along the property line. And their proposed conditions exceed that. There's a maximum number that I saw on the plan that includes 103.1 foot candles spill over onto the public right of way. Now, as described, this is a renovation of an existing building. As per lots of structures in the downtown district, the building is already built to the property line. So additional lighting features added to the front structure quite easily causes that spillover light to exceed on the property line. The orange line described on the screen shows the property line. Everything to the left is the existing structure, and everything to the right is the proposal for the hotel for their little patio outdoor space. The things highlighted in yellow indicate the portions of the lighting features that exceed our requirements for 1 foot candles, and I'll let the applicant go into their choices for adding those lights to the structure. So as previously mentioned, this is a request to this variance request associated with the special use permit is a variance to the maximum spillover light for a hotel along the front property line of the subject site as described in the outdoor lighting plan. The variation, this ranges from 102.1 to a minimum of 1.1 across that yellow highlighted area that I described. Will a substantial change to the character of the neighborhood be affected by this variance? So excessive lighting pollution is always a concern. That's why the code requirement exists. So that may occur. However, in downtown areas, you do see more sites prone to that excessive light due to its location at the property line and the number of buildings located within this area. And can the difficulty be obviated in some feasible means other than requesting a variance? A change in design can obviate the need for a variance. To conclude, the City Planning Commission did recommend approval subject to conditions, and they also voted to revise condition 12 to state that in obtaining the approval of a valet parking permit that would allow that space in front of the building to be used for their hotel valet area, it needs to be renewed annually, and that valet parking permit needs to be obtained prior to the certificate of occupancy. And that concludes my presentation, my staff report on this matter. I'll be happy to answer any questions.
Thank you. Anna, I meant to ask, is there anyone in either in the live audience or in the Zoom audience that wants to testify on this matter? Have you seen anybody?
As a reminder, if you are a member of the public who wishes to provide public testimony on case CD SCP 2023-00038, raise your hand on Zoom now so city staff can promote you, or approach the microphone in the city council chambers. Once public testimony has started and concluded, no other members will be admitted. Seeing none.
Okay, thank you. Who's speaking today, Mr. Simon?
I'm just gonna be Ed Sullivan and then turn it over to.
Okay, thank you,
Simon.
Mr. Stone.
Thank you. So I am. That's right.
Oh, before we do that, any questions of Anna from board members? Nope, seeing none or hearing none. Go ahead, Mr. Simon.
Thank you, Mr. Chairman, members of the board. Appreciate the opportunity to present in front of you today. First and foremost, we want to make sure that we can have this special use permit passed today. We've gone through all the commissions and processes. I think we've had unanimous approval everywhere we've gone. The picture that you see on your screen right now is the current condition of the building, which is actually much worse right now because we had vandalism when the building is now boarded up. If you drive by, it looks pretty awful. The original building was 4 stories in 1903. In 1906 or 1921, 2 stories were added to the building. And the remarkable event of this is you can't really determine what changed in terms of the actual work on the outside of the building because it's all copper structure that's on the outside. A Kansas City firm, Zahner Corporation, who is now internationally famous for their metalsmith work, had done this work in terms of the metal smithing on the building. And one of the unique elements of this building in Kansas City is this copper facade that you see, as well as the terracotta structure that surrounds it. Our plan is to refurbish totally according to historic requirements and recommendations for restoration of the copper facade and the building as a whole. We do intend for it to be a real gem to the city of Kansas City, as well as the street along Grand Boulevard. The interiors, just to give you a quick glance, piano bar, can't go too fast here. Nice little bar as well. Bedroom spaces will have ceilings 12 to 17 foot tall. 30 of the 35 units in here are suites. Our market study showed that Kansas City was short of suites, and this is the target market that we're trying to achieve. Another beautification of the elevators and the elevator doors. So you can see it's going to be a first-class hotel we're going to present to you. As Anna had mentioned to you, the building does have an issue where the building is actually right along the property line. Because it's right along the property line, it doesn't give us much opportunity for illuminating the main entrance to the building. The code is one where it requires us to have 1 foot candle at the sidewalk level along the property line. Well, imagine turning all the lights off in this building right now and putting a candle by your feet. And that's how much light we have to cross the threshold into this building. People who also are usually out of towners are coming to visit. So our desire is to, this is the facade of the building, is to get the variance approved today to allow us to have more illumination than what the code it does require. The lighting that's on the building is primarily uplighting on this building, but there are lights underneath this canopy. As you see, the little copper canopy that's underneath, that's where all the excess illumination is. And it's a 6 foot diameter canopy around the front door. So it illuminates downward from the underside of that canopy. Does not go into the street, doesn't affect anybody riding the bicycle along the pathway. In the study in which we had done, there's bowered lighting on the outside, and that bowered lighting has no impact on the code. So the only real lighting entry issues that we have are right there underneath the canopy. And obviously there is some spillage, as Anna had pointed out, that does emanate towards the city sidewalk and in the right of way. But you also notice some other characteristics here that you're right next door to your left is where the Wall Street garage is. We have cars coming in and out. We have bicycle path going right in front of the building. We have cars parking in front to unload our guests and bring them into the building. So when we met in front of the Downtown Neighborhood Association, their recommendation, one of their top recommendations was that we have increased light here at this point. This is a very important area to have illumination because of the car traffic going to the garage, the parking and the bicycle traffic. And of course, we have pedestrian traffic that goes along the way as well. There's a lot of things going on in through here, which I think justify the additional lighting. Because it is a historic building, my alternative to recess the lighting into the lobby, for example, doesn't exist because I can't get that past National Forest State Historic. So what I ask for you today is to consider the two hardships really. One hardship is that the building structure is right along the property line. And the second hardship is the overall congestion and the need for more light that's here. And think also, you know, I don't like to bring these things up, but this is the crime statistics in this area. And it's very important for more light to be present in these areas to provide the element of safety for our guests and safety for the community as well. Therefore, I request the variance be granted along with the approval of the SUP.
Thank you. There was a number of conditions, part of CDC. Do you have any problem with those conditions? No. And Ms. Anna, there were some that needed to be corrected before today's hearing. Were those corrected?
That is correct.
That they're done?
Yes.
Okay, great.
And we also need to admit their PowerPoint presentation. As
Oh,
exhibit
yes.
10.
Thank you. That will be admitted as exhibit number 10. Thank you. Board members, further questions, comments?
I'd offer a motion.
Oh, perfect.
In case number 38, I move the applicant's request to be granted in accordance with site plan, staff report, and conditions therein.
And there was one condition about the ballet, number 12, as I recall.
12, condition 12.
Yeah, and that will also be part of your motion, correct? Thank you.
Including condition 12.
Okay, thank you. I have a motion. Do I have a second?
Second.
Thank you, Mr. Garnes. Anna?
Gorns.
Aye.
Moran.
Aye.
Mixdorf. Wright.
Aye.
Aye. Good luck with your project, sir. It looks great.
Thank you very much.
Work here is done. For pushing us up. Jay had to be back in St. Louis.
Okay,
Thank you.
Going back. Where are we, Anna?
Yep.
All these other ones got canceled.
Number 3, I think.
Number 3. 2. No, 2 got canceled.
2 is continued, right?
Continued.
Mr. Chair, did you want to take an opportunity to announce if there's like a
Oh,
specific,
yeah.
the 4 p.m.
Yes,
cutoff
thank you.
time and what docket item you think you might end on? Because I know we have people here for like the very end of the docket and
right.
I've told them
Probably
it's
not.
extremely unlikely, but I think they'd like to hear from you.
Mr. Garnes, what's your timing today? Do you recall? About when? Say it again.
2:30, 2:45.
Okay. So, ladies and gentlemen, in the Zoom audience and the live audience, we're approaching docket number 3. Joe, in your experience, and Anna, how far do you think we're going to get?
I think that in my
And remember,
perspective from city staff, that we're probably only gonna make it through docket item number, what is the new 14, which was case 29, docket item 29.
okay. All right, so you think we'll get through 29?
Through the
14.
new 14 by 4 p.m. For the cases that are heard after 2:30, which is only in 30 minutes. You will only have 4
board members,
votes.
correct.
Yeah, board members.
So Mr. Gorans has to leave at 2:30, and that means we only have 4. For your case to be approved, we have to have all 4 affirmative votes. Any one negative vote will cause your case not to be approved. Because of that, we will roll you to the next month with no problem at all, no fees, no nothing. But especially if your case numbers are in the 20s, upper 20s or 30s, I don't think we're gonna get you today. And Joe and Anna, were we gonna have a special one? No, we're rolling to December. What?
There wasn't a quorum available the rest of this month on the other
Yikes.
dates
Okay,
we offered.
so we have to roll you through to December. And hopefully we'll have a new board member then too. So, all right, that's where, and then, is that right? Did I cover everything, Anna?
I just want to clarify for those in attendance that the new 14 that Anna was referencing is if you have the agenda, it's docket item 29.
Right.
So that's what.
Okay.
Okay, I am calling docket item number 3. This is case CD BZA 2023-00057. Property in question is 805 East 39th Street. This is a request to approve variances to the parking and loading standards, as well as residential infill lot building standards, plus any other necessary variances in the zoning district R5 on about 0.6 acres, generally located at 805 East 39th Street. The case was originally heard in August and then continued to allow the property owner to redesign plans. The staff planner associated with this case is Connor Tomlin. As a housekeeping reminder, we need to reestablish the quorum with Ms. Wright. The standard exhibits 1 through 9 apply. And then if the redesign is presented here, we'll add those additional exhibits then.
Thank you. Ms. Pollock, can I have you raise your right hand to be sworn in? Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Thank you. And state your name for the court reporter.
Rita Pollock.
Thank you very much. Rita, as part of your exhibits today, there's exhibits 1 to 9 that we need to admit to hear your case. Those are administrative exhibits, pretty common. Are we okay to admit those? They're part of your staff report. Connor?
Yes, he's asking if you're okay with admitting all the exhibits in order to hear your case.
Yes.
Perfect. Those are admitted. Part of that is a presentation by Mr. Tomlin. Thank you.
Okay, can you all see my screen okay?
Yes.
Okay, today we have docket item 3, CD BZA 2023-00057, located at 805 East 39th Street, zoning district R5. Applicant is seeking approval of 4 variances to permit a large driveway on the front yard of an infill lot. This is the general location of the site. This is a closer look at the site itself, outlined in yellow. A reminder that this is an infill context area. That green line that you see marked is the block face within the context area. All properties along that green line are considered to infill standards. This is the new proposed driveway. Previously that was proposed was 2 separate driveways with the staircase remaining down the middle. You guys recommended to come back with a new design, and this was the new design proposed. It is a large single concrete pad. It spans about 21 feet wide. These stairs are relocated onto if you're looking from the street towards the home, 18 feet wide. Rita, do those stairs go all the way down to the sidewalk? Or is that?
Okay. I do have a picture of an example of how it's going to be. I do have it with me.
If you give me just a moment, I'll finish up my presentation and we'll have a look at those. So there will be numerous variances needed for this to meet infill standards. The first variance is to permit a driveway on the subject site in general. The infill context area does not permit a driveway. This will be a complete deviation. Substantial change to the character of the neighborhood is anticipated. The proposal of a driveway, not 2 driveways, does not align with the infill residential context area. The difficulty could be obviated through a change of design. Variance request B, a variance to the maximum percentage of pavement allowed in the front yard to permit 55% of pavement in the front yard of the subject site. Code permits a maximum of 40%. This is a 37.5% increase. Substantial change to the character of the neighborhood is anticipated. Other properties in the neighborhood that have driveways are below that pavement percentage requirement. Difficulty could be obviated through a change of design. Variance C, a variance of 9 feet to permit the proposed western driveway at 21 feet. That could be altered if it is 18 feet wide. How I was understanding the plan was 21 feet. However, we can come back to that in just a moment. Substantial change to the character of the neighborhood is anticipated. The maximum code requirement is 12 feet. Difficulty could be obviated through a change of design. And then finally, variance request D, a variance to the features allowed to encroach and required setbacks to permit 2 parking spaces in the front yard. Complete deviation, substantial change of the character of the neighborhood is anticipated. The proposed driveway width is not consistent with the infill residential context area. With that, that concludes my presentation. I will take us back to the submitted plans.
Thank you, Mr. Tomlin. Before I go further, Anna, do we have anyone in the Zoom audience on this case? And anyone in the live audience on this case? Seeing none in live.
There is 1 second. Someone with the last name Doyle, they've raised their hand and they're being permitted. Can you stop sharing your screen, Connor, real quick?
Yes, give me just a second.
They are connected and no one else appears in the chambers.
And that was Doyle is the last name?
Correct.
Mr. Doyle or Mrs. Doyle, can you turn on your camera and microphone, please?
I'm on microphone only today.
Okay, just a microphone today, Mr. Doyle, right?
I'm the engineer of record.
He's the engineer of record.
Oh, engineer of record, okay. I'm going to swear you in and we may need some technical advice, but for right now, I think we're good. Please raise your right hand to be sworn in. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
And your name again for the court reporter.
Patrick Doyle.
He said it, Patrick Doyle.
Oh, Patrick Doyle. Okay, thank you, Mr. Doyle. Does anyone have any questions of Mr. Tomlin on his presentation? All right. Excuse me. Ms. Pollock, why should we, now remember, we've always heard testimony already from you at the last hearing, and Ms. Wright's already caught up to speed. Please bring us new information on your case today.
Okay, I have complied with the request of the board to adjust the pad configuration and the step configuration. The new design is 2 9-foot pads together and removing the existing steps. And I do have, as a matter of fact, examples of actual properties that have.
If we'll admit those, that'll be exhibit number 10. Mr. Tomlin, can you bring those up to us? Thank you.
There are examples how it will be, the approach to the steps will be the pathway first and then the steps up to the front of the house.
Great.
So instead of the steps first and then the walkway, it'll be a path and then the steps up to the porch.
Okay.
So those are examples to give you an idea, and different materials. It'll be, wood steps is my intention. And I would like to, and also I believe that the area that I'm consuming with this design has been reduced quite a bit. And I think now it's maybe just over 6 feet.
Okay. That's good.
Okay, and so, we really made a special effort to comply with all that. And so I'm to reintroduce myself to everybody and what my personal plan is. I'm doing age in place in my home.
Yes.
And
I've got a couple quick questions for you. You had some neighbor concerns last time you were here. You remember them? I think they were to your west, as I recall.
that's right. And okay, so what did you want to review?
Well, my question is, are they okay with this new proposal?
Well, I would like to explain from the beginning. I haven't had a chance to give input. Originally, those new investors in that property, the second day that they came to the property after they closed, had come up to my house and told me it was the wife, as it turns out, only the wife. And so I explained immediately about, because this property has changed 3 owners now in 3 years. And the 2 previous owners gave me permission to take down their east wall to the driveway. And then I explained to her the plan for my driveway. She agreed, although in her Zoom presentation, she presented what happened. It was a complete distortion and misrepresentation. I asked her, would she agree to it? I showed her exactly how 2 driveways were going to connect and the benefit for both driveways. She agreed to that plan. Then later, she said that, her husband, who was never mentioned, and I didn't ask her marital status or anything, but now her husband wanted a statement, something that if there was any damage to their property, that it's on me, it's my responsibility. We had already discussed all of that.
Good.
Ahead of time. Everything was understood. Well, then all I heard from Miss, what was her last name? Okay, so the wife. And she only repeated over and over, I'm not spending any more money. I'm not spending any more money. My contractor already told me that he could just take down that wall, no asking for money.
Right.
Okay. And so, so it seemed like everything was good to go. And so, because I had already started the process with the zoning board. So then, I have pictures of what was,
Appreciate you giving us the history,
okay, so then.
but I want to know what they said about this new project. We've got 20 cases behind you. Thank you.
I have not talked to them. They're out of town. They never from the beginning ever got back to me at all.
Right.
Never talked to me, never, except when she needed water because the water had been shut off, and I gladly accommodated that. And also, I was in the very beginning generous and offered all of my yard tools, my garden tools, and anything else that I had, and then including the water then that they needed
Sounds
Thank
like
you,
you're,
Ms.
it
Pollard.
sounds like you're very neighborly,
Mhm.
but let's get to the meat
Okay,
of the
but
matter.
What was the reduction in your previous submission versus now? Is there like a reduce the pavement by 10% or what number are we looking at if that's available?
If my memory serves me correctly, I believe the two previous driveway pads were, one was just shy of 13 feet in width, the other was right at 12 feet or just below 12 feet, so roughly 25 feet in width in total. This comes out to either 21 feet in width or 18 feet in width, but I would like some clarification from the engineer on what that width is, just to make sure that the proper request is being
Right.
made.
Mr. Doyle, that's a comment to you. Our city representative wanted to know about the width of the driveway, sir.
Thank you, Patrick Doyle. The width is either 21 or as an option, we provided 18. And the Behringers next door represented they had an engineer on contract, and I tried to contact and it turns out they do not. So I did try to make contact with their engineer, but they do not have one. They represented they did at the last meeting.
All right, Mr. Tomlin, do we need a clarification from him whether it's 18 or 21?
Yes, just as I was looking at the plans, I see where the 18-foot mark is, but then directly to the right, there's also a 3-foot mark of continued pavement. I just want to make sure that I have my numbers correct
Right.
on whether the width is going to be proposed at 18 feet or 21 feet.
Well, excuse me.
Mr. Doyle, your comments?
There's two options, 18-foot option and a 21-foot option. So
Okay,
the
which
width
one
of
are
the
you
driveways-
proposing, sir?
Well, if the board were to be accommodable to the wider driveway, naturally, we would request that. But if in the event that they would not, we would like to, we will be satisfied with the 18-foot option.
Connor?
And sorry, should interrupt Connor. Board member Mixdorf, to provide clarification, they present two options in the cover sheet for the revised plan. You were talking about percentage of total pavement in the front yard, I believe was your original request. Option 1 says 70% and option 2 says 64%. Thank you.
But that's still a reduction from where it was before, as I recall.
That's correct. It would be a reduction from the original submission.
Yes, yes. Thank you, Mr. Tom.
Okay, I have more comments then. Excuse me, but could I please ask for a few more minutes to finish?
I think we heard
I
your testimony.
think we
Yeah.
fully understand, Ms. Pollock. I think we fully understand. We know 39th Street's a very busy street. You need to get there safely. And with your recent accommodation with your engineer, I think we're at a plan. We've got a plan. So thank you.
I know I'm just one board member. I still feel like it's a little wide in relation to the context of the rest of the street since no other homes have driveways. But that is just my personal opinion.
Could we hear from the engineer on, will the 18-foot function properly? Or do they need 21?
The 18-foot is acceptable. That would be the lesser option too.
Mr. Doyle, I think it's hard for the board to hear you. If you could increase your volume on your microphone.
Can you hear me better now?
Yes.
Yeah.
Okay, the
18
18-foot
foot
is acceptable. The 18-foot is acceptable.
This is probably the side of my room.
Can't do anything about that right
Yeah, okay, so we're.
Mhm. Yes.
And as a reminder to the board that if changes are made to the variance request, those would be reflected in the official disposition letter that is released after this hearing. However, the plan submitted would not be able to be stamped approved. We would still need to see plans to make sure it ensures compliance with city code or approved variances.
Did you hear that, Mr. Doyle?
I did, yes.
So if we approve either the 18 or 21, you've got to give the city staff new drawings that reflect those issues.
Updated drawings will be provided, yes.
Perfect. All right, board members.
I think 21 would be something that would be
Mr. Gorns, you have to speak into the microphone if
can't
you're
hear
having
you.
discussion about the merits of the case.
I like the idea of the 21. That you can turn in there without scraping one side or the other.
Right.
It just seems.
Sure.
Good.
Sounds like you have a motion.
I think I have a motion. So my motion is to approve the 21 feet on
Case number
case
87.
number- Yeah.
57.
Case number 57.
57. God, I lies.
On 805 East 39th Street with all the improvements.
Second,
A motion and a second. Anna, please call the roll.
Fritz,
Aye.
Moran, Extorf, Wright,
Aye.
and Ebbets.
Aye, your driveway is approved. Good luck.
oh, thank you.
Sure.
Oops.
Let's go to the next case. Connor, you're still up.
We have docket item 4. This is case CD BZA 2023-00087 for 4840 St. John Avenue. This is a request to approve a special exception for a fence in an R 2.5 zoning district. This is a residential zoning district, plus any other additional variances on about 0.11 acres, generally located at 4840 St. John Avenue. Connor Tomlin is the staff planner associated with this case. The case was continued from September in order for the property owner to revise the design of the proposed fence. And docket or exhibits 1 through 9 still apply to this case. Revised materials addressed will be additional exhibits.
Thank you. Those will be admitted. A rep, Angela Morse.
If you are the property owner in question or any members of the public who wish to provide public testimony for 4840 St. John Avenue, please raise your hand now or approach the microphone as additional individuals. Once the public hearing has started, no additional people will be promoted. And a Joanna Morse has raised their hand. Waiting. Oh, you have to accept the promotion, Joanna. They are connected.
Miss Morse, can you hear me? Can you turn on your microphone, please? Anna, maybe an affidavit, maybe, depending on who she is.
Does the affidavit include Joanna?
Yeah, are you there with us?
He's the same person.
Oh, same person, same individual as the property owner.
Okay, thank you. Miss Morse?
Yes, I'm here.
Oh, thank you. We're going to swear you in today. Please raise your right hand to be sworn in. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
Yes, sir.
And please identify yourself for the court reporter.
Joanna Renee Morse.
Thank you. And you're the property owner?
I am purchasing the property.
And we did discuss this matter at the last hearing, that they're in process of purchasing the property. We do have correspondence from the seller that she can present, and they're the same people, the Angela and the Joanna.
Thank you. Ms. Morris, we have a list of administrative exhibits labeled 1 to 9 that I need to admit for your case today. Is that okay?
Yes, sir.
Thank you very much. Those are admitted. Part of that is a presentation by Mr. Tomlin on your case. Connor, tell us all about it.
Sure, give me just a second to get this presentation going. Okay, can you all see my presentation?
Yes.
Fantastic. Okay, we have docket item number 4, CDBZA 2023-00087, located at 4840 St. John Avenue. This is an R25 zoning district. The applicant is seeking approval of a special exception for a fence at a height of 6 feet. This is the general location of the site. This is a closer view of the site itself, outlined in yellow. As you recall, the plan proposes to go across the front of the home to the front door, and then back towards the house at that point, and there will be a gate across the driveway. Previously proposed was standard pickets standing upright. It was recommended to come back with a redesign. What is now proposed are these horizontal pickets with spacing in between in each individual picket. A variance of 2 feet to the height of a fence on a residential lot to permit a fence at 6 feet in height on the subject site is the request. No fences over 4 feet in height are permitted along the front of the property. The variation will be 2 feet. A substantial change to the character of the neighborhood is anticipated. The majority of homes in this neighborhood do not have a fence heights of 6 feet tall. The difficulty could be obviated with a change of design. That concludes my presentation.
Thank you. Board members, questions of Mr. Tomlin? Hearing none. Ms. Morse, why should we approve your case today?
Yes, sir. I would hope to get approval for my case today because I have lived here 7.5 years and there is lots of people that go by and we as a family function on the back porch. It's on the side where the driveway is. And that's where, we function outside as a family. And the people approach my home. They're at less than 10 feet from my property. From the sidewalk to my property is less than 10 feet. So it's very uncomfortable. Sorry, cars going by. So it's very uncomfortable when people, strangers per se, approach my property asking for cigarettes or drugs or anything. Is very uncomfortable for us as a family to endure this for all these years. And so I feel like I'm in dire need of a privacy fence to have some type of privacy to where they don't just they're just not able to just approach my porch and my family, my grandchildren, and just make us uncomfortable. It's very uncomfortable when strangers approach my home. I'm less than 10 feet from the sidewalk. So
I know St. John Avenue is a pretty busy street.
yes, very busy. I apologize for the background noise.
And one second. Mr. Tomlin, again, she's just asking for the fence as highlighted in red. The yellow is not the fence.
Right, so the yellow outlining the entire property
Yes.
is just highlighting the property itself.
The one in red is what we're approving or not.
That's correct.
Okay. All right. Board members, questions of Ms. Morris?
Could we see that again? Fence?
Yeah.
Could we see where the fence is gonna go again?
This is going across the front of the property.
Could he see that picture?
Yeah, let
Thanks,
me
Tom.
share my screen, I'm sorry.
Not that picture, a different picture. There,
So the yellow would be the fence.
No,
No.
the yellow is
No.
the property line. The red is the fence.
red is the only fence she's asking for. Looks odd, but that's neither here nor there.
So it's gonna go up to the house and over to the
Driveway.
property line.
Yeah.
That's on the St. John side.
Yep.
And I appreciate the efforts to add some transparency to the fence. I guess my sole concern is we don't often approve 6-foot tall fences in the front yard. And when we do, it is typically for a security reason and you're doing kind of enclosing the whole property to make that secure. In this instance, it is more aesthetics and it's not enclosing the property. So I don't know that a 6-foot tall fence is necessary at this location. But I'm just one board member.
Is the house next door, is that a fence next to it that will connect to the driveway fence?
Looks like it's chain link to
Chain
me.
link fence.
Looks like 4-foot chain link. And that's on the left as you're facing the house, okay? I kind of am okay with the 6 foot because of the transparency of the pickets. That's what is okay for me. And it doesn't go around the whole property. But that's just me, so.
With St. John being a busy street, I'll be concerned with in and out of the driveway, who can see who.
Yeah.
Even with the transparency.
Right.
Think of
So
4
you'd
feet,
be okay with the 5, 6 foot or 5 foot?
the 4.
Oh,
4
you
foot.
want a 4 foot?
Well, the 4 foot's not gonna help her much. I mean, I would think it would at least need to be 5 to. 4 foot's here, if she's. I would think it would at least need to be 5.
I think that's why we asked her to come back with other designs this time. I understand we've got a different design in terms of materiality, but there's been no conversation and change of height. Nope.
Ms. Morris, there's discussion about your acceptance of a 5-foot fence. What's your comment on that, ma'am?
I would be fine with the 5-foot fence.
You're fine.
You said yes.
Okay, all right. With that comment, Ms. Morris, I entertain a motion from my fellow board members.
Okay.
On docket item number 4, case number 87, I would move that we approve the request as changed by the proposed new transparent fence and only allowing a 5-foot height.
I have a motion. Do I have a second?
Second.
Thank you. It looks like it's just the 4 of us on this quorum. I didn't see our name.
That is correct.
Is that correct?
That is correct.
So, please call the roll.
Gorntz,
Aye.
Aye.
Mixdorf,
Opposed?
and Ebbets.
Approve. What happens?
A special exception just requires a majority, so the 5-foot,
So it approves.
yes.
Okay, so you're approved for that 5-foot fence with the transparency, the way you described it, Ms. Morris. Good luck with your project.
Thank you so much. I appreciate it.
Sure.
Okay. So it's close to 2:30, so to not,
Let's do another one if you can before we lose Mr. Gorens.
but he won't be here for the voting of this, because it's.
Oh,
it's-
for which one? So
Yeah,
for
so
the,
we can either take like a little break and then, read the case with the quorum that's gonna be able to make a decision on it.
can we, so you're talking about electing a vice chair?
You're gonna say to the end of, okay, even if it goes past 2:30?
Yeah,
Okay.
he was good to about 2:40 till.
45.
So we'll listen to case.
Okay, we'll leave it up to the applicant, for KC International Academy. Are they online, Andy?
Yep, Brian.
Great.
Online.
Great, so apologize for the delay. Docket item number 5, this is case CD SCP 2023-00035 for 414 Wallace Avenue. This is a request to approve a special use permit in District R 2.5 and District B1. That's respectively a residential zoning district and a commercial zoning district, to allow for a parking lot and other school amenities on about 8 acres, generally located at Wallace Avenue and Wilson Avenue. Andrew Clark, he is the staff planner associated with this case. The applicant is online and already connected. The standard exhibits 1 through 9 apply to this case.
Thank you. Those exhibits will be admitted. In just a second, they will be. Who we got? Brian Hochstein?
That is correct. I'm sorry. Yes, Brian is the applicant.
That's okay. And is that the only one?
Yes.
Is anyone else interested in this case? 4 414 Wallace Avenue.
This is a reminder for any members of the public who wish to provide public testimony for the case at 414 Wallace Avenue to either raise your hand on Zoom or approach the microphone, as once the public testimony has started, additional people will not be admitted. Seeing none, Mr. Chair.
Thank you. Mr. Hochstein, can you turn on your camera and microphone? Oh, I see you there. Can you please raise your right hand to be sworn in? Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Identify yourself again for the court reporter.
I'm Brian Hochstein with MKEC Engineering.
Thank you, sir. There's a list of administrative exhibits labeled 1 to 9 that we need to admit for your case today. Can we admit those?
Yes.
Thank you. One of those is a presentation by Mr. Clark on your case. Go ahead.
Good afternoon, Chairman Ebbets and fellow board members. Andrew Clark with City Planning and Development. Before you today is docket number 5. This is CD SUP 2023-35. This is for a special use permit at the Kansas City International Academy campus located at 414 Wallace Avenue. The site is located in the 4th Council District. It's directly east of Interstate 435 and just south of the Missouri River. As you can see here, the existing campus is expanding to the north side of Wilson Avenue with some land they have acquired, private land and land they've acquired from the land bank. The site, the topography, there is severe slopes in this area. And then also this is very close to the Hawthorne power plant. So there are transmission lines that run where the arrow is directing you on the west side of this proposed parking lot. The applicant is seeking deviations or variances to the parking landscape, our landscape standards and residential parking standards. As you can see here is the existing school, and the photos on the bottom do a really good job of showing the existing congestion when it comes to pickup and drop off at the school, which is why they need the parking lot. The landscape was handled through an administrative adjustment, which is at staff level, but there is a variance the applicant is seeking. It's a 100% variance to the amount of pavement allowed in the front yard. These are residentially zoned lots and they're paving all of it. So they need a 100% variance. The City Plan Commission did recommend approval with conditions for this case. And that concludes my presentation.
Thank you. Does anyone have questions of Mr. Clark? All right, Mr. Hochstein, you're up. Why should we approve your case today, sir?
Mr. Clark, could you please share the landscape plan? Again, I think that best illustrates kind of the overall objectives. Kansas City International Academy, as Mr. Clark has described, is expanding. This lot is quite a challenge. What they have done is they've purchased a property that frankly needed to be demolished, and that home has been demolished, and then acquired some land bank property. You can see under the overhead electric lines, it's very heavily overgrown. And what this does is it allows for about 48 cars to be parked on the north side of the school. The intention is that this will be staff, which will then remove that need for parking out of the primary parking lot, hopefully leaving even more congestion. We've also done a few things with this. It is very heavily landscaped. It is also quite the grade change. So we have a retaining wall around it that is screened heavily by spruce and other evergreen trees. And with the goal being that again, to alleviate traffic. Now, the school is also going to use it for a couple other things. It'll be an activity area where you can see a walking track on the inside of it. And at the recommendation of the city, we have incorporated a 450 square foot little native area. It treats some stormwater, but it's more of a learning opportunity for the students. So those are the kind of extras that we've thrown in here. This is a pretty rough neighborhood. And the character of this, I think, will actually fit very well in there, especially with all the other adjacent concerns, including, you know, the power lines. So I'll take any questions you guys have.
All right, thank you. There was a list of administrative exhibits, a list of city plan commission recommendations. Do you have any problem with those?
No, we accept all the conditions.
All right, thank you for that. Board members, questions of Mr. Hochstein? Looks like we approved a school project back in 2006, originally for the school.
That's correct. And then the SUP, I mean, this is the process that we go through every time. They're currently buying more property, so we will probably see you guys again next year as they continue to grow the property.
And then from the public engagement document, it looks like there was no objections from neighbors for this project.
No, we talked to a few neighbors. I think their primary concern was during construction. And so we were able to kind of alleviate those concerns about how they could access their properties. And that has definitely been shared with the Kansas City International Academy.
Thank you. Mr. Chair, I'd offer a motion.
Yeah, we don't have anyone in the audience here.
Oh, yep.
Okay, there's good. Go ahead, Ms. Mixdorf.
In case number 35, I move the applicant's request be granted in accordance with site plan, staff report, and the conditions therein.
I have a motion. Do I have a second?
Second.
Let's see. Sorry, Anna, please call the roll. Thank you.
Lawrence,
Aye.
Moran,
Aye.
Dorf,
Aye.
Wright. Aye. Ebbets.
Aye. Your project is approved, sir. Thank you very much.
Thank you. Have a great day.
All right, and we move.
Needs to pay out, right?
I think he's out. You gone or you want any more? Want some more damage? Uno mas or no?
No, they told him I'd be there after 3, so.
Okay, so you good? Okay, thank you. I know it's almost time for break, but Anna, I really would like to get through these a couple more before Mr. Gorns has to leave.
Yeah,
is that
good.
okay with your staff? Thank you
Yeah.
so much. All right.
Okay, we have docket item number 12. This is case CD SUP 2023-00039.
What about 10? Hold on, we missed 10.
Oh my gosh. My apologies. You're right. Sorry, Andy. Docket item number 10, this is case CD BZA 2023-00027. Good catch, Mr. Ebbets. This is for 5510 Northeast 33rd Street. This is a request to appeal zoning violations related to outdoor storage in R6, which is a residential zoning district on about 7.7 acres, generally located at 5510 Northeast 33rd Street. The Board of Zoning Adjustment heard this case originally in April of this year, and they continued it to allow the property owner to submit a building permit. This task has not happened. So city staff requests that this case be dismissed since the failed request.
Happened. Yeah, I get it. Mr. Harvey, I need to swear you in. Have a seat in front of the microphone, please, sir. Thank you. Raise your right hand. You solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today.
Yes, sir.
Please identify please say your name for the.
My name's Harley Harvey.
Thank you, Mr. Harvey. Is it 1 to 9 on the administrative exhibits? Actually, no, we're actually to dismiss it. So, sir, there have been some conditions that have not been met. And that you've requested an appeal to the zoning violations. And there's been no corrective action taken on your part, sir.
I tried. See, the permits department gave me the permit. They won't give me a building permit yet until they sign off on the fill site. I tried. So what I've always had, what I offered last time, I think, I know exactly where the building's gonna go, home. And I also know that I got the site plan that I want to give to the city as far as permits go, but they're not ready for it. I was ready for what you guys are asking for when I applied for my permits. They will not permit me a building permit until they sign off on the fill site. And
I think that was the request.
That was the request.
To get the completion of the fill site so you could get the building permit.
Okay, so there I am once again. I am filling it. I need the storage container very badly. The one and only person I believe that had an issue with it in the neighborhood, I heard, is moving. Has sold her home. Okay, so she is gone out of the equation. All my other neighbors I get along with just fine. Just as ironic though, that the one neighbor that had the issue has the exact same trailer in her backyard, only half the length. There's been a lot of falsehoods brought to this job from this lady. And nothing against her, but a lot of falsehoods. She did say or mentioned that the trailer, it's not a trailer, it's a storage container that goes on a trailer. She mentioned how it was hideous. I took the time and
Thank you,
money.
Mr. Harvey.
Yeah.
I think we heard some of this last time.
Yeah,
as
we
well.
heard it before.
Yep.
And you have,
Painted the
you,
trailer since then is what I'm saying. It's not.
the deal
hideous
is you
looking.
had 5 months to correct it.
On
From
ahead
April?
as well.
Oh, I'm sorry.
Yeah, and I'm sorry for jumping in for clarification. The building department, the building division, excuse me, would accept an application for a permit. Maybe that a permit cannot proceed forward with formal review or approval because of outstanding conditions like grading. However, the application for the building permit as requested by the Board of Zoning Adjustment has not been submitted.
Thank you for that clarification.
I just know their answer. I've done talk to them again up there. They've done reassured me that they will not give it. So why should I
don't
guess to appease everyone? Council, I understand that, I guess, but it's a flat, blunt no until my land is. And it's an ongoing thing. I have machinery up there. There's not a construction site in town, residential or commercial, that don't have some kind of storage unit on it. It's clean. There's no trash up there. I keep it leased very nicely. It's just a box that holds oil, grease, welders, cutting torches, everything to maintain heavy equipment. I painted it. There's no
It's
trash on the
still not
lot.
allowed by the city code.
I can move it where no one sees it on the property. I just don't know what.
Mr. Harvey, I
Go ahead.
appreciate your concern. And we're sympathetic to some of this. But it's been since April, we're now in November, and the request is to dismiss this case. That's what's out there.
So what you're telling me is I need to move the container.
I'm not telling you to move the container. I'm just telling you that there are zoning violations on your property, and
so
we're not going to give you, I'm not saying we, I don't.
Look, I have one question that might help us all out. So if I apply for the permit, like she said.
Right.
And they give me a reason why they won't give it to me, and then I come back and forth of you guys, would you look differently then? Put that effort in.
The effort should have been put into this point in time.
Hey, but I didn't, I have a very small mind, I guess, on things. I did not see. It cost me a lot of money to apply for that because I'm not computer savvy for one. So I have to hire that done when I already know that's going to be a waste of time, money, energy. So I just did not do it. But for me to keep this trailer there is very a necessity, a big time necessity. I will go ahead and spend that money on your request to ask the permits department.
In the meantime, we need to dismiss this case.
So I have to
Take it off
pay
the books.
more money to come back in front of you.
Well,
guys. I'm paid $500. The one and only neighbor that has issue has the same trailer in her backyard, and she sold her property. She's gone.
that's not my issue.
I know that's
our-
not your
Our
issue.
issue is there's a zoning violation on your property. It has not been corrected, and we're here to dismiss this case. And I'm sorry, you don't like my words, but
No,
that's
I'm
the
not
key.
having any problem with your words, sir. I've asked you, now that I know more clearly what I need to do by this lady over here, can I apply for a permit?
That's not my fellow board members will put forth a motion. And
And-
then we all vote on it.
And another thing, sir, I'm in the midst right now of getting it rezoned. And so by your next meeting date, it might be rezoned and that might give us resolution.
And for clarification, in April, when the Board of Zoning Adjustment made the determination to grant a 6-month continuance to October with clear instruction that building permits for the detached dwelling unit that he's referencing must be submitted by October 10th. That language is stated in the disposition letter referencing that continuance. We also don't have an application for a rezoning.
Mr. Chair, I would move to dismiss case number 27.
I've got a motion to dismiss BZA case 2023-00027 with an address at 5510 Northeast 33rd Street. Do I have a second to that?
Second.
Okay, we have a second by Ms. Wright. Anna, please call the roll.
And I'm sorry, Ms. Wright, but we're not on the quorum for this one, so we need a second, a different second.
We need to be on the quorum on the second. That'd be Ms. Moran.
She's listed on it.
She's listed.
I'm here.
She's part of the quorum. She listened to the tape.
You listen to the tape? My apologies. My notes don't reflect that.
transitions, yep.
I am so sorry.
All that work.
Lawrence.
Aye.
Moran. Mixdorf.
Aye.
Right.
Aye.
Aye. Sir, your request to appeal has been denied. Good luck. Sorry.
Yeah, I need more than luck, guys. Thank you.
Okay, now, Andrew, if you want to proceed
Yeah,
forward
keep on
with,
going. We
okay,
already did 11.
we have docket item 12, because we heard 11. Is CD SUP 2023-00039. This is a request to approve a special use permit for motor vehicle repair at the general category on about 3 acres generally located at Northeast Berries Road and North Brighton Avenue. Andrew Clark is the staff planner associated with this project. I do believe that the applicant is in attendance today. And this is a reminder for anyone who is also a part of the applicant team or wants to provide public testimony for this particular project, please let themselves know now. Raise your hand on Zoom or approach the microphone stand within the city council chambers. Once public testimony has begun, no other applicants will be sworn in.
You see,
Seeing
right?
none.
And exhibits 1 to 9 on this one typical?
The standard
Thank you.
1 through 9 exhibits apply, yes.
Ms. Grant, hi. And I never can remember, do I swear in attorneys?
Yes.
Okay, sorry.
I'm not an attorney though, so.
Yeah.
Teresa did it sometimes she didn't, I just can't remember, but thank you. Now I'll remember this. So Ms. Grant, please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Thank you. State your name for the court reporter, please,
Amy Grant,
with,
Olson LEPC.
thank you. There's a list of administrative exhibits labeled 1 to 9. We need to admit to hear your case today. Is that acceptable?
Yes.
Thank you. Those are admitted. It's a presentation by Mr. Clark.
All right, good afternoon again, Chairman Evans and fellow board members. Okay, and then now before you is docket number 12. This is CDSUP 2023-39. This request is for a special use permit at 5001 Northeast Berry Road. This is located in the northeast quadrant of the city in the first council district. It's just north of 152 in between Berry Road on the east side of Brighton Avenue. As you can see, the site has since been rezoned from when this screenshot was taken to allow for this use with a special use permit. The site has never been developed. It's just over 3 acres. This applicant is proposing to only use the southern half of this site and only rezoned the southern half to allow this more intensive use than what the original zoning allowed for. This is special use permit is a request to approve a general auto repair. The company is B Street Collision Center. Here are a few renderings. And as you can see here, it shows the lot, existing undeveloped lot being split into two. The applicant is only looking to develop lot one, which is what the special use permit is for. They did do public engagement with and neighbors from the east were satisfied with the screening that's being proposed for this use, as all activities will take place inside of the facility. The City Plan Commission did recommend approval with conditions for this project. And that concludes my presentation.
Thank you. Do we have any in the audience, Sana?
No one else has
Okay,
appeared.
thank you. Ms. Graham, you're on. Why should we approve your project today, ma'am?
We very much would like to bring this amazing new business to Kansas City, Missouri. We have enjoyed working with staff and going through the typical zoning process. I really want to be very respectful of your time. It's been a long afternoon, so I'm happy to answer any detailed questions that you have, but I believe that Andy has covered it adequately along with your staff report.
Thank you. What about approval with conditions? Any issues with the conditions as stipulated by the CDC?
No, sir, we find them all acceptable.
Okay, great. Thank you. Board members, questions? Mr. Gordon, this is up in your area. Do you have any questions?
Yeah, I live off Brighton. I just, we're not gonna have any junk cars hanging around there, right? It's gonna be just, the beautification part of the building. It looks nice. But are they going to, store stuff and?
So there will be a few vehicles, maybe 1 to 2, that might be determined to be totaled once they come to the facility. But we immediately turn around and work to have those removed from the property with the insurance company. So very short term and very few.
Yeah, thank you.
Does B Street Auto have other repair facilities in the Northland or in the Kansas City Metro?
They do not. That would be their first one here. They do have a facility in Lenexa that is right off of I-35. And then they also have one out by the Legends in Kansas City, Kansas. They're mainly out of Omaha though. So those are their 2 current ones in the metro area.
Yes, thank you.
Mhm.
Okay. Ladies, gentlemen, any other questions?
I'd offer a motion.
Great.
In case number 39, I move the applicant's request be granted in accordance with site plan, staff report, and the conditions therein.
I have a motion. Do I have a second? Thank you, Ms. Wright. Anna, please call the roll.
Gorns.
Aye.
Moran.
Aye.
Mixler.
Aye.
Wright.
Aye.
Ebbets.
Aye, your projects have been approved. Good luck, Ms. Grant. Thank you.
Very much.
Sure. Getting nervous, Tom? One more? Thank you. You raised the flag this time. Go ahead on. Oh, where'd you go? City staff, we will take a break soon. Just give us a few more. Thank you.
We're still good with Gorns? We're still good?
Yeah, he said he's still good. For
Okay.
a few more minutes.
Okay, this is docket item number 13, case CD SUP 2023-00045 for 3901 Main Street. This is a request to approve a special use permit for a bar. In the code, it's listed as a tavern/nightclub and entertainment venue within the Main Street overlay district on about 1 acre generally located at 3901 Main Street. The applicant is Lauren, and I apologize, I have their wrong last name on here, with Exact Partners. They are online and I am promoting them now. This is a reminder for any other members of the applicant team or any members of the public who wish to provide public testimony on this particular case that you raise your hand now in Zoom or approach the microphone, as once the public testimony portion has begun, no other members will be sworn in. Lauren is connected.
Great. Miss Lauren, can you raise your right hand to be sworn in? Hickman, right? Is that correct?
It's Jensen. I haven't had my married name changed in Compass Casey just yet.
Okay. So is it Lauren Hickman? What's your last name?
It's Jensen. Yeah, Lauren Jensen.
Jensen, right? Did I hear
Yes.
that correctly?
Yeah,
Thank
that
you.
was my typo.
That's okay. Lauren, please raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Thank you. Please state your name again for the court reporter.
Lauren Jensen.
Great. Ms. Jensen, there are a number of administrative exhibits we need to hear for your case today. They're labeled 1 to 9 as part of your staff report. Do we have your approval to admit those?
You do.
Part of that is a presentation by Miss Anna on your case. Anna, tell us all about it.
Okay, as previously mentioned, this is case CD SUP 2023-00045. The location in question is 3901 Main Street. The property is zoned B4-5. This is a commercial zoning district, and the applicant is seeking approval of a special use permit to site a bar/entertainment venue on the subject site. Within the Main Street Overlay District, which this project is included, any taverns or nightclubs, commonly referred to as bars, with a gross floor area equal to or greater than 3,000 square feet require approval of the special use permit, which is why you're seeing this case before you today. The site is located within the Main Street Overlay District in the Midtown portion of Kansas City, Missouri. And here's the subject site in question. As you can see, it is located at the intersection of 39th Street in Maine. Then a close-up shows that this bar is being located within an existing structure with the parking lot to the rear. This is materials from their application. I reoriented it so it fit better on the screen. Basically, you can see that the last tenant space closest to the intersection of Main and 39th Street is being renovated to the bar in question with some outdoor patio space. This is a look from the property on Google Street View. Again, it's that corner section of the tenant space that is being used as for the proposed bar. The review criteria for a special use permit is listed on the screen. I'm not going to go into every single item, but the two factors that I believe support why city staff and the City Planning Commission recommended approval subject to conditions. First being approval criteria B, which talks about the interest of public convenience, ensuring that the proposed use does not have a significant adverse impact on the community or the general neighborhood. So this is along the streetcar line, and the streetcar expansion has spurred a wide variety of development, regardless of uses, commercial and residential alike. So a bar innately in this type of space along this major corridor, especially in close proximity to another nightlife district, which is Westport. It's kind of down the road southwest from this site. We do not believe have an adverse impact on the community. With review criteria D, this talks about the compatibility with the proposed use in terms of operational characteristics. Again, think of hours of operation, lighting, noise, traffic generation, etc. Again, this is directly adjacent to a future KC streetcar stop. So we anticipate that, these high activity uses is appropriate for Main Street, especially considering the mass transit investment in the area. There are already several restaurants, bars, other entertainment venues along Main Street. So thus, the City Planning Commission recommended approval subject to conditions, and that concludes my staff presentation on this matter.
Thank you. And do we have anyone in the audience other than Ms. Jensen?
None have made themselves known.
And no one in the live audience, it looks like. Ms. Jensen, why should we approve your project today?
Well, thank you so much. So we purchased this building a few years back. At the time, it was a very underutilized space. It was the specific premises that this bar is going into was previously a bank, which included a drive-through. And as I know the board members are aware, drive-throughs are being removed from the Main Street overlay. So with that being said, we wanted to find a use that we could convert that existing drive-through space into something that's more beneficial for the neighborhood, that creates more of a walkable environment. And as you know, was previously stated, kind of incorporates into the entertainment district that's surrounding. We have a fantastic kind of theater district right there at the intersection of 39th and Main. And we thought this would be an excellent use and something that would lend itself to our neighbors well. We met with Southmoreland, which is the relevant neighborhood, had an excellent presentation and generally received support from them. They asked kind of the questions that one would expect when you're attempting to put a new bar into a location about safety. And I believe that the bar owners who presented at the time did a great job of addressing not just the hours that they'll be open, but how they'll be managing the crowds and the space, the interior space and the exterior space. But I think that this will be an excellent addition to our intersection.
Ms. Anna, we don't have to approve any parking variances, do we, on this?
No, they addressed their parking need with an alternative compliance parking plan. And it's being approved with the special use permit.
Thank you. Ms. Jensen, a quick question. There's a Pizza Hut that's kind of up the street, south on that location. Are you taking over that space as well?
So the Pizza Hut is so the entire property that you saw in the overview runs from 3901 Main to 3911 Main. The Pizza Hut is within the building.
Okay. But again, we're just approving 3901.
So if you're familiar with this, it's actually where Great American Bank used to be located. It's just their kind of in cap space.
Right.
So the bar will only be in what is designated as 3901, which is its own suite.
Thank you. Board members, any other questions?
I'd offer a motion.
Thank you.
In case number 45, the applicant's request be granted in accordance with site plan, staff report, and conditions therein.
I have a motion. Do I have a second?
Second.
Thank you, Ms. Wright. Anna?
Lawrence.
Aye.
Moran.
Aye.
Mixdorf.
Aye.
Wright.
Aye.
Ebbets.
Aye. Your project is approved, Ms. Jensen. Good luck with it.
Thank you so much.
So we're going to lose a board member, I think. Right? Yeah. So for cases 14 and later, only have 4 board members. And Anna helped me out on the vote. So for any case that we want to approve, they've got to get unanimous approval, or does an SUP allow 1 negative?
With the special use permit that's up next, majority vote applies.
Right.
With the variance requests that come afterwards, you would need all 4 to
All
vote in
4
the
affirmative votes for it
affirmative.
to happen. So, for those cases 14 and beyond, you have a choice of, if it's a special use permit, you only need 3 of us to approve it. If you want to have a variance, you need all 4, or you wait till next month. And we're not going to have a meeting in late November, so it'd be December, and you'd be up for that deal. So not sure if there's anyone in the live audience or the Zoom audience who wants to continue onwards. We're going to take a break. But if you want to think about it and then get with Anna, we will hear your case today. Sure, quickly. We're gonna take a break. What's your question, sir? What do you say?
I keep, it's too far back.
He's asking for scenarios of when it gets voted down. I can speak with him if.
Yeah,
we
that's
take a
great.
break.
Mr. Rexwinkle will address your concerns. Anyone else? Please talk to
Okay.
Joe.
And
We're gonna take a 10-minute.
I made a mistake. The special use permit would need 4 votes.
So it needs 4 affirmative.
Yes.
Yeah, it's typically only the fence height requirement that require a majority. Everything else usually requires
Or
4.
to deny.
Or to deny. Yeah, okay, so I spoke in error. So if you have a fence, you need 3 votes. Anything else, you need 4. And there's only gonna be 4 of us here, so. All right,
The next meeting is the 12th.
yes, 12th of December, our Christmas meeting.
Yes.
We all wear Santa hats.
No, we do not.
Okay, recording stopped. We good? Where my recording stop button is?
Can you?
We're gonna take a 10-minute break. We'll be back. Thank you.
Change this document.
We'll do our vice chair election at the next month.
That's what they determined today.
Yes. I meant general.
I'm traveling.
He has.
Hey, hey, I had a question. Hello, I had a question. So I don't have. So I can't. Hello, can I talk to Anna? We would like to see if you guys can go through our variants today. I can't hear anybody. Not working.
Where did?
No, right now it was muted.
Okay. Can you hear us? Ms. Velasquez?
Yes, I can. I was just questioning. We're on I think we're on number 19 today. We're hoping if you guys can go through the variants today versus next month.
Where did he cut off? Where did he say earlier?
Because I guess you guys were wanting us to talk to Anna, but I don't know how to talk to Anna or who she is, and the chat is disabled.
Ma'am, are you with docket item number 14 as presented on the posted agenda?
We were on 19, but I was just clarifying because you guys were on break and I was trying to reach somebody. And because the chat is like disabled right now. So that's why I had to do something to say something because I don't know who Anna is to let someone know that we would like to be looked at today.
Gotcha. So the board is on break right now, but before they went for break, they explained that they've got a hard stop at 4 p.m. Additionally, we only are going to have 4 board members to vote on cases that are heard, which means that you would need all 4 to recommend approval for your request. If we get to docket item number 19, that is up for your determination to decide if you want to proceed forward with hearing today, or if you want to be continued to the December docket.
Okay.
And we can't anticipate at this time exactly how many cases they'll review between now and 4 p.m.
Okay. I guess we can decide in a little bit then. See what you guys get through. Yeah.
What number they are right now? 13?
Yeah, I think we'll look at it later. Thank you.
Okay, so anyone else on Zoom who is here for anything before docket item 29 or earlier is published on the agenda. What the board chair announced before they went into break was that from here on out, the rest of the day until 4 o'clock, which is when they're gonna end, they will only have 4 members available to vote on each case, which means that if you have a special use permit that you're requesting or a variance, which I think is all that's left on the docket anyway, that all 4 of them have to vote in your favor for it to be approved. So it's just a little bit of a higher bar. And what the board likes to offer is that if you'd rather, if you want to take that risk and be heard today and they get to you, they'll hear your case. If they get to you before 4. Otherwise, they will accept a continuance request to their December meeting. So if you would like a continuance request and you're associated with docket item 29 or lower than 29, raise your hand in Zoom and I will ask you to identify which docket number you're here for and we'll let the chair know. John, you should be able to speak. Which docket item are you here for?
I am 17.
Okay, 17 is 7704 Main Street. And on that one, since it's a variance, all 4 members that would be present would have to vote for it.
Right. Can I request a continuance or for next time?
Yes, the next meeting is December 12th and we can ask the board to continue.
That would be great. Do I need to do anything or will that just automatically happen?
They'll have to vote on it, but we will pass it along and I'm sure they'll accept it.
Okay. Thank you.
17 continuous. Yep. Is there anyone else on Zoom that has any questions about any docket item prior to docket 29? Or that would like to continue a case? Go ahead, Ms.
Velasquez, we would do a continuance too. We can do for the December 10th.
Okay. And your docket item again, I'm sorry, was
19.
19. Thank you.
Cool. Thank you.
Thank you. Okay, Jason, go ahead and identify the docket number you're associated to.
I believe it is docket 27, 1603 Westport Road.
1603 Westport Road?
Yes, sir.
Okay, so that is an appeal, so that one would take 4 votes. Are you wanting to continue that or have it heard today?
Let's continue it, please. Well, let me ask you, if it is continued, when will it be continued till? Because I'm about to go out of town.
So the option is to either leave it on the docket for today and hope that they get to it before 4 p.m. and hear the case, in which case you'd only have 4 members present and all 4 of them would have to grant the appeal.
Sure.
Or you can request that they continue it to December 12th. In the likely event that they would have 5 members, which would theoretically make it easier to get your appeal granted.
Sure, December 12th would be preferable.
Okay, we will request that they continue it to December 12th.
All right, thank you very much.
Anyone else? Erie Lopez, go ahead. Are you here for docket item 22, Erie? Says you're unmuted, so there must be something on your end not working if you're trying to speak. You can message us and using the chat feature. I'll promote you to a panelist so that you can do that. And tell us whether you'd like the case continued or heard today. In the meantime, is there anyone else who would like to discuss their docket item? Okay. Cheryl Williams.
I would like to have my case heard.
You would like to have it heard or have it continued to December?
I would like to have it heard. I won't be available for the December 12th date.
Okay. What's the docket item you're here for?
My number is CDBZA 2023-00066.
Okay, got it. That's docket item 14, which is the next case, right?
It is after.
Oh, it's the case after next, so they probably will get to it.
Okay, thank you.
Erie, can you try speaking now? Okay, I think something's wrong with the audio on your end, so just go ahead and send us a message in the chat feature, which should be on the toolbar at the bottom of Zoom. And if you just send it to all the panelists, then every staff person will receive it and be able to respond. And which docket number are you here for? 22. Okay. They want to be heard. Docket item 22 would like to be heard if they get to it. Thank you.
Yeah.
Joe, you ready for us?
Hey,
Want to hit
Yeah.
the recording button? Or are we?
yes,
We're good?
okay.
All right, we're back to our after break. Anna, please tell us what we're doing.
Yep, we are presenting case docket item 29. This is case CD SUP 2023-00037 for 3122 Gillum Plaza. This is a request to approve a special use permit to allow for a self-storage warehouse in the district M1-5, which is an industrial district, and B4-5, which is a commercial district, in an existing building. The applicants are in attendance with us in the city council chambers. They have consented to the 4-person quorum. And Larissa Chomby is the staff planner associated with this case. The standard 9 exhibits, so are applicable.
All right, good. Excuse me, 1 minute. I'm going to have you raise your right hands to be sworn in. Do you solemnly swear or affirm to tell the truth and nothing but the truth today?
Do.
And state your name for the court reporter.
Eli Johnson.
Say it again.
Eli, E-L-I,
Okay.
Johnson.
Oh, Eli Johnson. Okay, go ahead.
Michael Kelly.
Okay, Michael. And what's your last name? Teller?
Kelly, K-E-L-Y.
Kelly, sorry. All right. Sir, there's a list of administrative exhibits labeled 1 to 9 as part of your staff report. Do you have any problem with those admitting?
No.
Okay, great. Those are admitted. Part of that is a presentation by Miss Larissa. Please tell us about the case today.
All right, good afternoon. Larissa Chomby, City Planning. As Anna mentioned, this is a special use permit for 3122 Gillum Plaza. Here is the general location of the site. It's located in the Midtown Plaza area. Here is the property with its surrounding zoning districts. The property is located within 150 feet and adjacent to a boulevard, which is Gillum Plaza. That's why you're seeing the special use permit. A self-storage warehouse, it requires a special use permit approval. Here is a site plan of the project. This is an existing building and there are multiple points of access on Gillum Plaza, and I'll go through them so we can point them out. The first access on Gillum Plaza is right here. It provides a circular drive. This is the proposed ADA access for the property. There's a second access right further south, which you can see here highlighted with the 2 arrows. That goes to a 24 stall parking lot. This area immediately north of that parking lot used to be an access point. However, the applicant is proposing to landscape that. So this parking lot provides direct access to the office, which is located in this small corner right here. Then moving on to Oak Street, there are 4 access points on Oak Street. The first is the one further south of the property, and that goes up to this second parking area with 14 stalls. There are 2 options for this parking lot. You can exit here in this second access egress point, or go through the building, and I'll explain that here in a little bit. There's one more exit that comes straight out of the building onto Oak Street. And then there's one final access point here on the northernmost part of the property. The applicant is also proposing approximately 3,000 square feet of co-working space, and you can see that highlighted in the yellow. This is to enhance the pedestrian experience. It was requested by the City Plan Commission that they add a second use to the project. And so as you can see here, just north or just a little bit up where you can see my arrow, that is the entrance for regular sized vehicles to come in, unload all of their, I guess, property that they have here, and then leave through that third access point that I mentioned on Oak Street. This is only for regular sized vehicles. Oversized vehicles will unload outside. And this access point is a blind corner for the sidewalk over here on Oak Street. Like I said previously, this is an existing building, and so the facade is not changing. There will be some minor updates to it. However, most of it is to remain. And so here's the south elevation. You can see the loading areas. Here's the north elevation for the project. And here is the revised east elevation that was provided to the City Plan Commission, showing the co-working space with additional glazing. And just a zoomed in view of that. And then this west elevation for the building. The applicant is proposing Carl Forester grass to help kind of break up the stucco that's along Oak Street. That was also a request from the City Plan Commission. As you know, there's criteria for a special use permit to be approved. I've covered the ones that are highlighted in red. There is in the interest of public convenience and will not have a significant adverse impact on the general welfare of the neighborhood. The project is proposing multiple access points on each side. The pedestrian access and the pedestrian traffic will be significantly impacted by this proposal. C is compatible with the character of the surrounding area in terms of site planning and building scale. This is one of the larger buildings on the block. So while it is, it's existing, so it's the size that it is. However, the project design, there is a proposed pedestrian alert system for the blind corner that I mentioned that will create, I believe, flashing lights and an alert to signal that there is a car exiting the building. That will add to the noise in the area. And then finally, will not have a significant adverse impact on pedestrian safety or comfort. Again, there's just multiple access points on each side of the property. And here's some views of the property. This shows that 24 stall parking lot. And you can see where my mouse is. That is the second or third access on that side that will be removed and landscaped. And here is that circular drive I was talking about to help with the ADA accessibility. Here is the view from Oak Street and the outdoor loading and the entrance for the smaller vehicles. I do want to bring up that this property to the west of the project was recently approved for single family housing. And then at the City Plan Commission, they recommended approval with conditions after the modifications to the building were completed, and staff recommended deny. And I can answer any questions if you have them.
Board members, do you have any questions of Ms. Larissa?
Yeah, what was the basis of the staff recommendation for denial? Was it the all the access points causing
The pedestrian impact, yep.
Who's speaking, Mr. Johnson or Mr. Kelly?
Both.
Yes, one
Sorry,
question.
sorry.
Since it's a manufacturing lot, right? What else could go here besides storage or the use that was there previously? Or did it require rezoning to basically have anything else there?
It is M1 and B4, so it's pretty permissive of what's allowed there. I don't know off the top of my head all the uses that are allowed.
Thank you.
Yeah.
Go ahead. Who wants to start?
I can start. Okay, so again, this is an adaptive reuse of a building that's now vacant in Kansas City. It's a very unique building. It was built in 1951 in phases. There's uneven floor plates, and it's an industrial building split over 2 stories, making it generally undesirable for many uses. Storage is probably one of the only uses that I can think of, and I think we've got someone who's going to speak to that shortly. But overall, it's a functionally obsolete building, yet it's big, heavy, built of concrete, not easy to take down, as we've seen from this being listed for multiple years up to this point. As requested by Plan Commission, we added a mixed use component. There was an interest from Plan Commission to activate the boulevard and have more neighborhood services. So we've worked in this co-working space, something that we think will work well with with storage as well. So Etsy businesses, eBay businesses, people who have a benefit for having some type of storage use, but they could use a small office, maybe for shipping labels and packaging and things like that to run their neighborhood business. The storage planned is a Class A, climate controlled, managed facility, well lit and professionally managed, as I mentioned. We've enhanced the landscape, windows, repaving the asphalt, added trees. So it's generally going to be more attractive on both sides of the building, both the Gillen Plaza side, as well as taking into account improvements for the neighbors that at this point, I don't think any permits have been pulled, but should they come, it'll be a more attractive view from those homes. At this point, I believe we've met the standards as well as every staff request and every Plan Commission request that's been made of us. We're not seeking any other zoning relief or any other deviations from the zoning code at this time. Nor are we seeking any city incentives to do this work and bring this to the community. So with that, we respectfully request that the special use permit be granted. And then we had issue with one of the conditions. So have Michael talk about. Talk about now, yeah.
Mr. Kelly.
Sure. So at the Plan Commission hearing, there was a condition that was added for a 10-year renewal on the special use permit. There's a lengthy discussion at Plan Commission about that. Ended up being a 3-2 vote. 3 members requested the 10-year and 2 members were willing to move forward without the 10-year renewal condition. So as part of our package, it's in your package, we are seeking to remove that condition for 4 reasons. First, renewal conditions for special use permits based on our research are uncommon. We were able to find
That's 73% of all special use permits since 2021 did not have a renewal condition. And then of the 20 special use permits that did have a renewal condition, all but one fell into a number of different categories that are not really applicable to our application, whether the zoning code required it, like a halfway house, entertainment or travel uses, ancillary or minimal investments in the property, such as a landfill, a parking lot, outdoor storage, things that really don't take a lot of money to get that type of business off the ground. Or sometimes a special use permit was tied to the lease of the building, which is not the case in our circumstance. At the last plan commission hearing, there was a discussion about another project in front of us, and the staff or the commissioners asked why a renewal wasn't required on that special use permit. And the staff member said that it was not being sought because the project is, quote, putting a substantial amount of investment on the site, which seems to be, based on our research, one of the standards for why these renewal conditions are on there. Well, I'm here to tell you kind of the third reason. We are going to be putting a substantial investment on this property. As Eli mentioned, it's going to be a multi-million-dollar investment, including but not limited to site demo, asphalt, new landscape, masonry restoration, circular upgrades, new signs, mechanical and electrical upgrades, new glazing. So we're putting a lot of money into this project. And finally, kind of comparable projects really have not had renewal conditions. We were able, since 2021, found 6 special use permits related to storehouse or warehousing usage, and only 2 had a renewal requirement. One was a 3-year special use permit for outdoor storage, again, of landscaping materials. And the second was for the construction of a 3,000 square foot office and a 5-year special use permit for covered outdoor storage. Again, in our opinion, not a very large investment in that project compared to ours. So, that's really our kind of contention with the condition, and our, requesting that your board remove that as part of the conditions on the plan. So,
thank you.
Yeah.
I'm trying to picture the project, but as I recall, maybe 5 or 6 years ago, it had been a plumbing supply warehouse or something like that forever. I remember seeing gigantic tractor trailers, 50
Yes.
footers.
Yes.
Back when you showed that loading dock.
Yes.
I remember those being back there in the olden days.
We have a seller here as well,
Oh,
and his agent, if they want to, they can speak to the tenant who just moved out. But yeah,
No,
this
that's
is extremely busy.
right. But you won't have that kind of activity
Exactly.
on this one.
Exactly.
So in a way, the neighborhood's going to benefit from your lighter use of this facility.
100%. Yes.
Loading primarily will be done indoors. For
Right.
majority of people come in their consumer car. So neighbors won't even see that somebody's coming in. The average stay is sometimes like 11 months. So they kind of come, put stuff in.
Right.
Don't always come back for a while. So in terms of traffic and things like that, the impact is way, way, way lighter than what you would have for the existing zoning and the prior use of this building.
Right. And the alert for pedestrians, I mean, I'm sure you're not going to have a 200 megawatt speaker sitting out there.
No,
So
and
be
we
something-
did some research. We looked at other properties in downtown, and we found one that has this system in place. I think it probably was a requirement as part of the permitting.
Right.
And we're planning to do, it's this property, it's at 417 Grand Avenue.
Okay.
And we're planning to use the same system that they have on their property.
Sure.
And their property is across the street from a multi-story, multifamily building.
Right. Right.
So we feel pretty confident this is the right solution.
And obviously it's not like an outdoor facility you see up in the Northland.
No,
Where,
no.
no, it's just trashy.
So
This looks pretty good with all the landscaping and the
Thank you.
windows and things like that.
Thank you.
Questions, emotions?
I'm kind of going back and forth on the 10-year piece with that condition. I think there's a lot of development in that area. I live in an adjacent neighborhood. I walk past this building all the time, so I'm very excited to see improvements and the things that you're doing, but also understanding with all the development to, does 10 years make sense to give us the opportunity to reevaluate as we kind of develop downtown and, streetcar will be running through the adjacent neighborhood and all of that, just to give us that opportunity if the use still makes sense at that point in time.
And can I add that condition was also added because this, the applicant and new property owner might be great and keep the project clean and operating efficiently. Since this special use permit would run with the land, this does give us the opportunity if someone else moves in to add conditions or remove them as we see fit.
In the word SUP expiration sounds harsh, but it's really a renewal. So in 10 years, the SUP would need to be renewed, as Larissa explained, making sure the conditions are working. Do we need new conditions, et cetera?
Yeah, and I feel like we get a lot of those renewals coming before us, and usually as long as you're still in good standing and having good conversations, it's usually a non-issue.
Yeah, it's usually pretty much a rubber stamp after that 10 years.
So.
Yeah.
I understand it. That's probably but like maybe the norm, but the sport changes, staff changes, there may be new opinions 10 years from now, 10 years. So, from our perspective, seems like it's a requirement that's not being asked of other applicants. And because of that, we don't think it's appropriate. So that's really our main argument. For example, again, we did a lot of research on this. At your August hearing, there was a special use permit for another warehouse project. It was for construction of 2 storage buildings. It was within 150 feet of a boulevard, so it's the same specific requirement that we're here because of our special use permit being within 150 feet, and renewal requirement wasn't required for that project. So that's really our kind of issue with the renewal requirement.
The one other challenge is there's a practical issue that comes up in terms of financing the facility. If you're a lender and there's a chance that the rug is going to get pulled out from you in year 10, you don't necessarily want to provide favorable terms or longer term debt on the facility. So maybe immediately it won't be an issue, but at some point, it creates a potential hardship for ownership.
Can we do a 20-year?
Under the special use provisions, I think we could always repeal it. The special use permit if there's problems.
That's true.
There's a process to go back in and,
right.
Which I think a lender would be even more nervous about, but if that would be, I'm not sure the 10-year serves a purpose because it's so long out. If there's problems, you want to repeal it sooner than that.
Right. There's code enforcement.
I think that's what you're saying, where there would be what we heard earlier today, there was non-conforming use or the issues and he had to come back and so.
The finance issue, I kind of understand that because.
Yeah.
Go ahead.
Can I get perspective from city staff on that timeframe? Because I feel like this is way longer than I've ever seen. So I would think that's already very generous in terms of a renewal.
Condition called for a 3-year expiration.
Yeah.
And at City Plan Commission, they discussed it and extended it to 10 years.
Okay.
We had a very long discussion about this at Plan Commission.
But I can't remember what the provision is, but there is a provision in there that allows the city staff to request and the BZA to revoke a special use permit if there's problems.
Yeah, there's revocation proceedings, but they would have to be in violation of something in the code or a condition of approval that you guys place on the project. And at CPC, I think the main concern was wanting to reevaluate this use in a place that the commission and staff, for that matter, sees as evolving to become more pedestrian oriented over time with a use. They saw the appropriateness of this use for the time being, but we're concerned about a long-term impact of a use like this in an area they see evolving to become more pedestrian oriented. I think it is useful to compare the pattern of expiration dates, but you would need to look at this use in these types of areas, and that sample size is much smaller.
Yeah.
I'm not sure that all those locations were also in pedestrian oriented areas.
Some of them are more car centric in the Northland and have different requirements in this more
Right,
urban
right.
context. I know I'm only one board member, but I think the 10 years is really gracious compared to what we usually get. And I know that's not what you're looking for, but I do like the ability of knowing that what we're kind of granting is still meeting the needs of the neighborhood and meeting the needs of your business and kind of has some level of accountability for the project.
Well, that makes sense. I mean, as long as it's not gonna sink the project because of the financing.
Yeah, that's the thing I was
When they're talking
concerned
about
about.
putting millions into a project,
Right.
I see the issue.
Of course, the
there.
bank would want to have assurances that it's not going to go away in 10 years. So I
Right.
understand these guys' concerns and the bankers' concerns. So it's not like they're just keeping the old plumbing building and not doing anything with it. That in one district. So
When do you guys anticipate getting to construction close?
Say it one more time, sorry.
When do you anticipate getting to construction close?
Starting construction? If this is proved today, we're hoping to close on the building by the end of the year and start construction right away in
And how
next year.
long will construction take?
We believe it'll probably be around 7 to 8 months. So we hope to be open by the end of next summer. Yeah.
as a finance person, I understand the longer term, but then I understand your considerations too, Randy. So I'm kind of mixed, as they say.
You have an open public testimony, so if the individual in the chambers wants to provide testimony, you need to swear them in.
Oh, yeah. Is anyone providing?
I heard a comment.
You need to come up, be sworn in.
No, yeah.
Do you solemnly swear to tell the truth and nothing but the truth? So, did I do that right? Yes. And state your name for the record.
I do. Billy Hodis.
Thank you. And who's going to be testifying with you? Do you solemnly swear or affirm to say the truth and nothing but the truth in this meeting today?
I do. Carrie Weems.
Thank you, Carrie. Mr. Hodis?
So I'm Billy Hodis. I'm the current owner of the property. And I just wanted to give my input on how we've been operating out of this property for the past 12 years. It's not really that neighborhood friendly. We have had, significant truck traffic through there, 53-foot containers, 5 or 6 of them a day, UPS trucks, customer trucks with pickup. In this neighborhood, it's just not really a good use in this type of neighborhood. Self-storage is significantly more neighborhood friendly than industrial distribution. Parking, we had about 70 parking spots for 125 employees. So we used a lot of street parking, and that's really not good for that neighborhood. There's a lot going on. There's a lot of people using those streets. These guys are proposing to have 1 to 3 employees on site and a few folks coming in there. So parking on the street and tearing up the streets with our big trucks is not going to be an issue anymore. And so that, along with, I would like to ask Carrie to speak to the marketability of the building to other uses and what we've experienced.
Otis?
Thank you. So I've been working with this building for about 2 years. I've had 285 people inquire on the building. I've had 9 people become serious. Of those 9, more than half were people who wanted to scrape the site and redevelop it, as you were talking about. The construction of the building is such that it is very heavily constructed, steel beams and very heavy concrete. There's actually a concrete roof on this building. To tear down the building becomes cost prohibitive for redevelopment. So therefore, the developers all backed away. We were left with 2 parties who were serious inquiries. The other party was also a self-storage operator. They decided that they would not go through this special use permit with the city of Kansas City, Missouri. And so they backed away. And that leaves us with Blue Ribbon, who are absolutely dedicated to this project. I have grave concerns about the finances going forward of being able to sell this to anyone else. I'm afraid this building is going to sit vacant. With the current interest rate environment, this has become a real impediment to these buildings that are industrial buildings that are essentially functionally obsolete. They don't have the right ceiling heights and they don't have the right tax abatements on them. And they have all sorts of issues that compete with brand new buildings that are computerized distribution points. That is what people who are conducting distribution want in our city. And we have those in other places. So we have to find out something to do with this current building. And these guys have been in it to win it. And I really think they'll be great for the neighborhood because there's going to be over 1,000 multifamily units built within 3 miles of this building in the next 2 to 3 years. Thank you.
And Ms. Carey, the design of the building looks great, at least to me. I hear around my fellow colleagues more an idea about the term of the special use permit. I'm not hearing too much negativity on your development itself. So,
And that's part of the concern is, part of my concern, frankly, as the owner of the building is
right.
If the buyers cannot get their financing due to the term of 10 years.
Right.
Then it could kill the project and it could sit as an empty, blighted property.
I guess I would just be curious, since we see so many cases that have renewal periods. I mean, are they, I can't imagine all of them are also having issues with financing and they're much shorter. They're 2 years or 3 years. So the fact that this is 10, like that would be a positive in the project because it is so long compared to anything else that I've ever seen this board approve.
Well, the terms of borrowing have changed significantly here over the past 6 months. And so that's only getting tighter and tighter and tighter. And so, a business model that takes 20 years to get a good return on getting into that with a 10-year term on that permit may deter the lender.
Just to give Mr. Kelly and Mr. Johnson some confidence, I can't remember, I've been on the board for almost 12 years, maybe 13. I can't remember us ever overturning an SUP, taking it away. I mean, we've seen it in bad neighborhoods where things were, these calls, things like that, projects such as yours. So. Any other comments, questions, or motions?
I would offer a motion.
Yes, Ms. Mixdorf.
In case number 37, I move the applicant's request be granted in accordance with site plan and staff report and the conditions therein, maintaining the 10-year renewal.
Okay. I have a motion. Do I have a second?
A second.
Thank you. That's right.
Moran. Mixdorf.
Aye.
Wright.
Aye.
Ebbets.
Aye. Good luck with your project and I hope your financing works out.
Very much.
Thank you. Appreciate it. Thanks to Kelly and Mr. Hodis for coming down and waiting all day long. Thank you.
Okay.
We're
Then
on next.
to conclude, since the board has identified sorry guys, can you take conversations out into the lobby? The echo is so bad in here. So to conclude, the docket today, as you guys have identified a hard stop at 4, we've got docket item number 14 with case CD BZA 2023-00066. This is for 1621 Belmont Avenue. This is a request to approve a variance to the rear yard setback requirement in an R2.5 district, so residentially zoned district, plus any other additional variances on about 0.08 acres, generally located at 1621 Belmont Avenue. The staff planner associated with this project is Connor Tomlin, and the property owner is online. I am going to promote them as a panelist, Cheryl Williams. They have consented to the 4-member quorum, and the standard exhibits 1 through 9 apply to this case.
Perfect.
They have been connected.
Thank you. Ms. Williams, can you turn on your camera and microphone, please, in order to be sworn in? I don't see you quite yet. See her? See her?
Yes, you're on the big screen.
Can you see and hear me?
Oh, there you are. Thank you for turning on everything. Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
Thank you. And please state your name for the court reporter.
Cheryl Williams.
Thank you, Ms. Williams. There's a list of administrative exhibits labeled 1 to 9 that we need to admit for your case today. Do we have your approval to admit them?
Yes.
Thank you. Those are admitted. Part of that is a presentation by city staff, Mr. Connor Tomlin. And Mr. Tomlin, tell us about the case today, sir.
Sure. Can you all see my screen okay?
Yes.
Okay, today we have docket item 14, CD BZA 2023-00066. Located at 1621 Belmont Avenue in an R25 district. The applicant is seeking approval of a variance to the rear yard setback requirement to permit an existing addition onto the rear of the home. This is the general location. This is a closer look at the house outlined in yellow. This is the survey that was provided to city staff. What will be needed for the variance is a variance of 6 feet to the minimum rear setback on an infill lot to permit a rear setback of 19 feet on the subject site. The variation is a total of 6 feet. A substantial change to the character of the neighborhood is anticipated. The other houses in the contest area are compliant with the rear setback requirements. The difficulty could be obviated through deconstruction of the addition and reconstructing to meet code. That concludes my staff report, and I'll bring you back to the aerial of the property.
Thank you. Do we have anyone else in the audience? Or
Sharing your
against this
screen,
project?
Connor. You stop sharing your screen. This is a reminder for anyone else part of the applicant team or any members of the public who wish to provide testimony on this particular case to make themselves known now, either raise their hand on Zoom or approach the microphone in the center of the city council chambers as once public testimony has begun. No other people will be sworn in. Seeing none.
Okay, thank you. Ms. Williams, why should we approve your project today, ma'am?
If by approving my project today, it would allow me to get the electricity turned on in the property so that I can get an alarm put on the property, because as it is right now, I have had several people break in and destroy property. And I've went in and put bars on windows and doors. They've kicked in things. And I really would like to get the electricity turned on so that I can secure the property and not incur any more damages, as well as try to finish getting it fixed up, because I was trying to fix it up for my aunt who had cancer, who recently passed away. But needless to say, I still have other family members that could utilize the property.
Ms. Williams, why did you start the project without a permit?
I did not. I inquired the house. It was already on there, and I didn't know that it wasn't built with without a permit.
So you're a new owner to this property, yes?
Yes, I am.
Connor, we're approving, if we approve it, we're approving something that's as built. I mean, it's already done.
Yeah, so it's as built right now. It's just not within the criteria.
Right, understood. And was the electrical part what got her to this spot today when she tried to do an electrical permit for the?
Yes, that's exactly what got me to this spot.
Yes, it got you, didn't it?
Yes.
Board members, questions of Ms. Williams?
It's less of a question and more of a comment. In cases like this, it would be especially valuable to have photos. I see we have a survey, but it would be nice to see what was actually done on the property. I think there's different stipulations when submitting cases, and I think providing photos would be a very valuable piece.
I apologize. If I'd have known, I would have had photos available for you.
Is there currently no electricity to this house at all or just in the back?
No, ma'am, there's no electricity at all to the house.
So for clarification, when they tried to turn on the electricity, that's when they discovered that their work without permits had been done. And then when they submitted permits, realized that there's a need for a variance. Now we're here. Now we're here.
Yeah.
Okay.
That's correct.
Well, board members, what do you think about this? Of course, it wasn't Miss Williams who did the addition. She just got caught in the middle of it. So.
After electricity is established, how soon do you think you can get it occupied?
Well, I have to repair the damages that when the people kicked in the door and busted up all these holes. So I would literally probably need about 3 or 4 months in order to get all those repairs done.
Miss Williams, you've probably had no electricity for almost since mid-June or early July.
Yeah, it has been no electricity at all.
Yeah, you need some lights and heat.
Yes.
That's not for me to say.
I think in this particular case, there is definitely an undue hardship here if you're purchasing
Yes.
this property and this is already built on and you don't even have electricity in the property. So with that, I'd offer a motion.
Please.
In case number 66, I move the applicant's request be granted in accordance with site plan and staff report.
I have a motion. Do I have a second?
Second.
Thank you, Ms. Wright. Anna?
Aye. Mixdorf.
Aye.
Right. Aye. Ebbets.
Aye. Hopefully you have electricity pretty soon, Ms.
Thank
Williams.
you.
Thank you.
Thank
Have
you
a
so
good day.
much.
Sure. See you.
All right.
We gonna do another? Or wait, we're at a hard stop.
Yeah, it is 2 minutes till 4 o'clock.
We've
already we've like distributed information to everyone that there's a hard stop at 4.
Okay. Okay. Are these the next 2 cases or are they later?
Are you a single case? Are you? Both of you together.
What docket number and can they approach the mic?
They're here. I mean, if we only
I'm
have,
o-
we only have the
I'm
4
okay
board
if-
members, but
I'm okay with staff if they want to go ahead with 4, if staff's okay. Mr. Rex Winkle, you gonna kill us? If we take on one more case, it'll be one less for next month. Okay. Come on up.
We're after this, so go for it.
what?
There's a lot more cases after this, so I'm not gonna kill you for taking one more now.
This
Thank
is
you,
Connor.
guys.
Ian Connor.
So we're docket number 16, 1019 Benton.
Okay.
Is that right? Okay. So Anna?
Yep, we've got docket item 16. This is case CD BZA 2023-00119. This is a request to approve a variance to the maximum number of units allowed in a colonnade building in an R 1.5 district, which is a residential zoning district, plus additional variances on about 0.15 acres generally located at 1019 Benton Boulevard. Connor Tomlin is the staff planner associated with this variance request. The applicants are in the room here with us in the city council chambers. And the standard 9 exhibits for this case apply. And they have consented to the 4th-person quorum.
Yeah, I want to make sure you understand. You need all 4 votes, Mr. Baghdadi, and the other person I don't recognize. So,
Yes, sir.
sorry, okay? Please raise your right hand to be sworn. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
Yes, sir.
Please state your names for the court reporter.
Todd Tobin.
Thank you. Mr.
My name's Riyad Daddy.
Yes, thank you. All right, sir, there's a list of administrative exhibits labeled 1 to 9 that we need to hear as part of your case today. Do we have your permission to admit those?
Yes, sir.
Those are admitted. Part of that is a presentation by Mr. Tomlin. Connor, please tell us about the case.
Okay, today we have docket item 16, CDBZA 2023-00119. Location is 1019 Benton Boulevard in an R15 district. The applicant is seeking approval of a variance to the maximum number of units allowed in a colonnade in an R15 district. This second variance is mislabeled. It should say 12.5 feet. Variance will also be needed to accommodate the fire escape on the rear of the building. This is the general location of the site. This is the site itself, located at the corner of Benton and East 11th Street. This is an image of the building as it stands. This is a floor plan, site plan of the property. This is proposed parking for the residents of this property. They own these two buildings to the north on the corner of East 9th and Benton Boulevard. There is parking provided behind. I will let the applicant speak more to their plan with that. So for variance request A, a variance of 4 units to the maximum amount of units in a colonnade to permit 16 units on the subject site. 4 were proposed underneath down towards like the basement level, I guess you could say. As it was built and constructed, it was designed to have 12 units, hence the need for a variance. This will be a complete deviation to the requirement. A substantial change to the character of the neighborhood is anticipated due to what I just described as it being constructed for 12 units. The difficulty could be obviated through a change of design. Variance request B, a variance of 12.5 feet, not 8 feet, to the rear setback to accommodate space for the fire escapes. A substantial change to the character of the neighborhood is not anticipated. Difficulty cannot be obviated through a change of design due to the building taking up the entirety of the lot area. And with that, I conclude my presentation.
Okay. We have anyone in the other audience?
This is a reminder for anyone who wants to provide public testimony on this case to raise their hand now on Zoom. We have one person, Greg, from one person at this time. Greg from the Neighborhood Legal Support. Is that a part of your applicant team? Okay. If there's anyone else a part of the applicant team or any members of the public who wish to provide public testimony, please raise your hand now on Zoom. As once the public testimony has started, no future people will be sworn in. Greg is connected.
Thank you. Do you want to promote Brad and I'll swear him in? He may not give testimony. Do you want to?
He's giving testimony for
Yeah,
us, I guess.
he's connected.
Okay.
No other people has raised their hand on Zoom.
Okay, gotcha. Okay. Why should we wait? First of all, any further questions from Mr. Tomlin on city staff? Who's going to be speaking today on the process?
Would you like to start? or-
Yeah.
And why should we approve your project today, sir?
Well, because now it's a vacant building and we would like it to be inhabited, be used and inhabited, and that will improve, of course, the whole area. I just want to make sure that this is an existing building. We're not adding the apartments to it. The apartments are there already. We're just making it legal for that. So the total is we have 4 stories. Each story has 4 apartments, a total of 16 apartments. It's going to be great if this building is open, and it eliminates a lot of problem to the neighborhood. Go ahead.
Sir, so this building, thanks to Mr. Bradley Wolf, we were able to find some data on it. It was built in 1903. We have census data going all the way back to 1920 that states it was a 13-plex essentially. They had 12 units up top and a manager in the bottom. Unfortunately, in the 1920s, I believe they separated the land, which caused the zoning to change. And it's my understanding that the reason that we're having an issue now is because it's been we can't get or couldn't get grandfathered because it's been vacant for 2 years. We have a terrific standing in the Northeast. My brother and I have rehabbed over 450 units. Mr. Lombardi is president of the Neighborhood Association in Lycans. He's the one that's going to give testimony. They're very happy with our work. Mr. Tomlin had suggested if maybe we could help with the offsite parking. As a matter of good faith, we went ahead and bought a lot connected to our lot right down the street. It's only 450 feet away. Even though this place has never had parking, we've gone ahead and said, hey, if you guys want to, we'll help with the parking situation. We are part of the solution in the Northeast. We have a very good track record, as Mr. Lombardi will tell you. Fixed a lot of blighted problems. We want to fix this. This is our passion, is providing housing to low income and people in need. And by fixing these buildings, we're able to kind of keep them safe. Otherwise, you see they burn down all the time. So we've got that whole neighborhood pretty much sewn up ourselves.
So right now you have 16 units in the building.
So right now there's 12 with 4 available in the basement. Each one has its own full door, full access windows. So they would be completely conforming, I guess. Right now they're saying that we're only zoned for 4 units.
Right.
There's 4 addresses, 1013, 1015, 1017, and 1019, each with 4 floors.
Right. And is there electrical meters for each unit, or is there one common electricity unit? How's
Yes,
this
sir.
work?
There's electrical for each unit as well as a common
So you have
for the
16
hallways.
We
so
have,
we have 16 meters, 16 meters for each
Oh,
unit.
shoot.
yeah,
Right,
we
right.
have, actually, we applied for 17 meters. Yes, 16 meter for each, 1 meter for each apartment and 1
Yes.
for the common area.
Okay.
And we had applied, we submitted our plans, and I believe it had been approved up the chain until they found out the variance issue with the number of apartments. They said we could only have 4.
Mr. Lombardi, is he in the audience? Zoom audience?
It's on there.
Where? Oh, yeah, on the
Left
Zoom?
corner.
I'm sorry.
Mr. Lombardi, can I swear you in so you can offer some testimony on this case?
Sure.
Raise your right hand. Do you solemnly swear or affirm to tell the truth and nothing but the truth in this hearing today?
I do.
And your name for the court reporter?
Greg, G-R-E-G-G, Lombardi like Vince, L-O-M-B-A-R-D-I.
Thank you, Mr. Lombardi. What kind of testimony would you like to talk about this particular application?
Well, I would like to present the neighborhood's perspective on the application.
Go ahead.
Okay, so my name is Greg Lombardi. I'm the former executive director of the Lycans Neighborhood Association. I'm also the executive director of Neighborhood Legal Support of Kansas City. We've been working in the Lycans neighborhood for the last 6 years, converting blighted and abandoned properties into good quality housing. And the building at issue has been an abandoned property or an unoccupied property for all 6 of those years. And for approximately a year and a half before Shiloh's purchased the property, it was severely blighted. There were many windows broken out. There were fires being set in the building. The neighborhood association actually paid to secure the property so it wouldn't burn down. The Lycans neighborhood is in dire need of housing. And when this apartment building was built, it was fully compliant with code and zoning requirements of the time, or it may have actually predated zoning requirements. And normally it would be grandfathered in, but because it has been sitting vacant for the years that it has been vacant, the grandfathering doesn't apply anymore. And so in July of this year, Shiloh's applied to the Lycans Neighborhood Association asking for support for their application here. And they presented to the neighborhood association, and the neighborhood association asked them a lot of questions and then ended up voting unanimously in support of this. And the unanimous support is because it is a beautiful building. the work that Shiloh's has done elsewhere in the neighborhood is high quality work. The work that they have already done on this building, securing it and doing rehab work has been high quality work. And so it would add much needed housing to the neighborhood. And we're in a neighborhood that, as I said, is in dire need of additional housing. I would also note that if the variance is turned down, that this property will be essentially unusable. This cannot be converted in any reasonable way into a fourplex or a 4-unit colonnade. And that's not what it was designed for. It's not what it's needed for. And so the neighborhood, as I said, strongly and with all voting members unanimously supports this proposal.
All right, thank you. Board members?
Sorry, Mr. Chair, can I interrupt and provide some clarity? So per the definition of a colonnade, the 12 existing units that they have right now is permitted. With our research for the certificate of a potential for certificate of legal non-conforming use, the 4 units in the basement are not approvable because they've abandoned for more than 12 months, which is why they're seeking a variance for those 4 units in the basement. But the 12 units that exist there in the main structure of the colonnade are permittable.
And of course, codes administration would confirm that their improvements on those basement units would allow egress in case of emergencies, things like that.
If you were to approve the variance for the 4 units in the basement, yes, the building codes review team would ensure that they are habitable spaces.
Right.
Yeah, I just want to clarify that there are 4 separate doors in the basement, including windows. So there were some apartments in there at certain time.
Yes, they've got to be. Are they small? How many squares? How many square feet approximate?
The units is 31 feet deep by about 20 feet wide, 28 feet wide, 25 feet wide.
Yeah.
So 30 by 25.
Right.
Approximately.
For my own clarity, is at one point the 4 units were allowed, and then because they've been vacant for 2 years, they no longer have this variance?
I don't have that information. in
Yeah,
front of
so
me.
as you heard, the building was constructed in 1903. The city's first zoning ordinance was 1923, so it was considered grandfathered in at 12 units. But once we zoned the property, we applied a density limitation that comes with the zoning. And they're allowed to continue with the 12 units unless they cease using the 12 units, which you heard that they did do. That's what makes them ineligible for this certificate of legal non-conforming use. Otherwise, we would have been able to approve that.
Well, Mr. Rexwinkle, at some point it had 16 units in there because I hear 16 meters, right? At some point.
I don't.
Oh, not, you may not know.
I don't believe there were 16, but even if there were, if they ceased using them for 12 months, we still can't approve a CLN, and it's still a variance that comes to you guys. The alternative is rezoning the property to a district that allows the density.
Is there any further questions?
So may I ask a question?
Oh, sure.
So my understanding is that with the zoning that's there now, the maximum number of units is actually 4. And so I may be having a misunderstanding, but the only reason that the building could have even 12 units was because it was built before zoning and was grandfathered in.
We're looking for clarification on your statement. Give us a second.
Sure. During this process, as we were going through, we were told that we were only allowed 4.4. because of the square footage divided by the
Yes.
zone. That's where this whole thing started.
So I guess the intent from the beginning, you wanted 16, but you were told you could do 4.
Yes, ma'am.
But we think we could do 12.
I think the confusion, and I see this a lot with customers and staff, is between the fact that this was built before zoning, then zoning came in and limited the density, and then they ceased using the building at all for a period of time. So I think the confusion lies between what they're allowed to do by right without a CLN versus what they can get with a CLN versus what they can't get with a CLN, which is what's before you. And Anna's looking into the zoning as R1.5, which means that the density is capped at, I think it's 15. Yeah, 1,500 square feet of lot area per unit. And it may have something to do with the testimony you heard about how part of the lot was removed at one point. Where at some time it may have been compliant with that density limitation, but it appears that it isn't now. And she's doing the math right now. Yeah, so that if you apply today's zoning, it does limit it to 4 units. And we would have been able to give a CLN for 12 because that's what it once was if they had not abandoned the use. Even if they wanted to go back to just 12, they'd still be here in front of you because we can't give them that CLN at the staff level. But they want to go to 16, it sounds like.
So
I think there is something in there. Okay, when we applied for this building here, we applied for a permit directly for a construction permit. And in that construction permit, we included the 3 stories only. So that's a total of 12 units. The basement, there was unit in it. We didn't include it in there. We didn't want to do it. Then, and actually the plans were approved and then they were kind of disapproved. We were told that we have to go through zoning or do CLNU or go back to a variance. And that's where the number now becomes critical. Actually, there are 16 units. I mean, there are four units on each floor and there are 4 stories in there. So there were originally 16, but when we applied only for the 12. We didn't know that we're gonna go through the zoning, what we're doing right now. So now we're going to the zoning. We wanna make sure that the 16 is included. Even we're gonna do the 12, the renovation on the 12 units for right now. And then we'll submit a new plan for new construction plan for the 4 units in the basement. That's how I looked at it, and that's how this confusion I think came about in there because.
Yeah, I mean, anything other in this case, because the building was stopped being used for residential purposes for a period of 12 months or longer. They're gonna be here for a variance for anything more than 4 units.
Okay.
So it's really up to the board to decide whether that's a hardship and whether it should be 12 or 16. If you think limiting it to 4 units is a hardship.
And in our original plans is we submitted the request for 16 meters for 16 units plus 1 for the common area.
Well, I think as we look at the lack of housing in KC and we need more. So I definitely think that more than 4 is appropriate at this property, especially with the kind of historic nature of it. I guess my question is more the 12 versus 16 and what seems more appropriate for this building. I'm really excited to have more of the colonnades come back to life and get the reinvestment in them and kind of bring us back to our KC roots. So I'd look to other board members to kind of get a feel on the 12 versus 16 here.
Well, I think since the neighborhood's so supportive of the 16, there must not be problems parking and things like that you normally hear. So I'd kind of defer to the neighborhood on that.
And I remember down in the Northeast, we had a unit similar to this where we had 4 or 5 and they wanted to add 3 more. And they had parking issues and they were denied, as I recall, on that because they couldn't supply the parking. You, on the other hand, have parking up the street.
Yes, sir.
Yeah.
And this is on a bus route too.
A bus route.
Yes,
Wonderful.
yes.
Greg, are you still online?
Mr. Lombardi?
I am.
Question. Okay, so you were under the impression this was 4 units. From your neighborhood perspective, do you see an issue with pursuing the 16 versus the 12?
So that was what was put before the neighborhood association, and the neighborhood association unanimously supports 16
Supports
units.
16. Okay.
And having the parking up the street is a great addition that helps on that.
Okay. Thank you for the clarification.
Yeah. All right.
I think from a financial perspective, it would probably be more beneficial too to make it 16 for future. Cause I can imagine now, of course, having to rehab these colonnades is very expensive. And it's hard to maintain them and make them sustainable without having that extra 2 or 3 or 4 units to kind of cover some of those cost burdens. So that would be the hardship.
Entertain any motions recalling the variance 2 needs to be 12.5 feet, not the variance as noted in through the staff report.
And then if the BZA pursues allowing them to have 16 units, variance A also needs to be reworded to be a variance of 12 units, not 4.
Okay. All right.
I would offer a motion.
Thank you.
In case number 119, I move the applicant's request be granted in accordance with site plan and staff report, noting the change for variance A to a variance of 12 units and for variance B to a change of 12.5 feet.
I have a motion.
Second.
Thank you, Ms. Moran.
Brian,
Aye.
McStorff,
Aye.
Wright,
Aye.
Ebbets.
Aye. Your project is approved. Good luck with it.
Thank you all so very much.
Thanks.
Thank you.
Thank you.
Thanks, Mr. Lombardi. It approved. Meeting adjourned.
Full day today.
Yes, thank you, Ms. Baghdadi.
Guys.
Thank you, city staff, wherever you are.
I might just make one suggestion for the next hearing and going forward.
Yes.
That it would be, I think, helpful since your agendas have been so long for you guys, but also for the public. If you were to announce that we will conclude the meeting by X time or docket item number X, whichever happens first, whichever one you get to first, whether it's the time or the docket number. That way people know that if they're after that docket number, they can leave and go about their business.
Can we just stick with the 4 PM as a good cutoff as a rule of thumb?
Because sometimes.
And you don't have to do it at the beginning of the meeting. You can do it. I think it's once you get I think you guys, all boards, they seem to get like a feel of their rhythm by an hour or 2 into the meeting. So if you want to wait until that point to do it, I think that's fine.
Yeah.
But I do think that would be helpful for everyone to just know,
Right.
because our staff get a lot of emails from people during the hearing.